siqhubeke sikwazi ukuthi sisize inkantolo sisebenzisane ngokuhloniphana uthi ngiyamhlonipha naye akangihloniphe sihloniphane sihloniphe inkantolo.
I will refrain from such a conduct as long as we are in the same path. And this is not a condition. I'm just saying it, and I withdraw if I offended you. But let us take each and every question and answer in a way that will assist this court to see if such confessions were taken properly.
Yes, I agree, my lord, but in answering that, I cannot agree to things that I see are intending to create a wrong impression to the court. That's what I'm here for. And if I point those things out, Mr. Mgomezulu must understand that I'm simply here to assist the court. There's nothing personal about it. I'm raising what I'm raising based on the investigation that I've conducted. It's nothing personal. And if you want to challenge me with that and point me to another direction, if of course the facts are there, I'll concede. But if the facts are not there, I can't concede to something that is wrong. But that is not meant as a sign of disrespect. It's what we are here. We are here for that, my lord.
Mnumzane Mgomezulu ke uthi ngizoyeka ke lokho njengoba uthi sihloniphane ngizoyeka ukuthi singahloniphane sizohloniphana kodwa uma ingabe mina nawe sizovumelana kwizinto ekuthi ngiyazibuza ubrigadier uma iphendula uthi yebo asihloniphane nami ngizoyenza ukuthi ngiphendule imibuzo ngalendlela uyibuza ngakhona kodwa uma ingabe ikhona indawo ekuthi ufuna ukungisa kuyona eyikuthi mina angivumelani nayo ngeke ngivume ngizoyenza umsebenzi ukuthi mina bengikade ngiphenya kuleli cala futhi ngisize inkantolo ukuthi inkantolo ibe nesinqumo ekuthi yasithatha angizanga la ukuthi ngizothatha izinto ngenhliziyo asebenzisane ungibuze ngiphendule bese sikwazi ukuthi leli cala siqhubekele phambili.
Now, my lord, I'll come to the last question, but the first, perhaps maybe let me try and deal with what I remember what Mr. Mgomezulu raised, my lord. The issue of the J50s, and this is my understanding, that's why I said him and I have a different opinion. We've now read section 43, I think it's clear as daylight. But secondly, the warrant of arrest or the J50 is a means of taking someone to court. It must not be construed as the violation of the rights of the person that has been arrested. In any event, the Constitution, my lord, section 36 has a limitation clause. Once a case is made and the warrant is authorized, what do? The person must appear in court. And the warrant of arrest is the means of taking the person to court, as it can be summons, any other thing. I'm not aware of any provision in section 43 that says if a person is in custody, you cannot execute a warrant. I'm not aware of that. It was a means that was before us. The case that they were facing, my lord, is premeditated murder. I mean, even if the person was outside, how do you go and warn a person outside to say, you've killed the person X, on this day you must go and appear on your own? There's no way. It will amount to J50, my lord.
Uthike ithi ngichazele indaba le yamaphepha agunyazayo ukuboshwa kwabantu mina angiboni ukuthi lamaphepha lawa ayewakhishwa ngendlela engekho emthethweni ngoba mina umuntu nanoma engaphakathi kodwa njengoba ebhekene necala elibucayi ukufana nalo leli icala lokuthi uye wahlala phansi wacabanga ngokuyobulala umuntu othize mina ngokwami ngiyazibuza ukuthi ke uya kanjani kumuntu nanoma engaphandle ufike uthi kuye ubhekane necala lokuthi wena uye wacabanga ukuthi uyobulala umuntu bese ngelanga elithize uye enkantolo ngoba isizathu salencwadi le egunyazayo ukuthi umuntu aboshwe ukuthi lo muntu loyo ube nalelo phepha bese uyaya uyombopha akusukuthi uye uyomcebisa ukuthi ngelanga elithize kwamele uye enkantolo uthi manje lokho yiko engifuna ukuchaza ngalo lemicala.
Lastly, my lord, on the last part that Mr. Mgomezulu asked me, my lord, yes, they were right that were explained prior to the execution of the J50s on accused 1 and 2. Insofar as the questioning that took place prior to the arrest, they were questioned at a certain stage on the 30th, and whenever we engage with them, constitutional rights as prescribed and required to do so were explained to them. But insofar as the arrest, my lord, that took place, in other words, the indictment of them and the charging formally of this matter on the 26th, that was explained in terms of 14A, as is also prescribed, my lord.
Manje ke ithi ngiphendule lo mbuzo lo bengibuzwe ngawo uthi yebo amalungelo wona akhona ayikuthi ayewachaziselwa umangalelwa maningi kodwa ngaleli cala kuye kwafanele ukuthi simchazisele futhi amalungelo ngoba lawayana bekwamalungelo welinye icala ngalesikhathi ezebe ezokhuluma futhi kube kwamele ukuthi simbuze simchazisele amalungelo wakhe ngaleli cala njengoba na kuleli cala bekwamele siyenze ukuthi sithole le phepha egunyaza ukuthi aboshwe bese siyambopha ke ingakho bekwamele simchazisele amalungelo wakhe.
Okay. You gave your own understanding of Section 43. My question now is, in your affidavit, did you ever mention that accused number 1 or number 2 was arrested for another offense? Did you mention that in your affidavit?
I beg your pardon, just what is the question, my lord?
My question is, when you brought your application, it was supported by an affidavit.
Yes.
In that affidavit, did you state clearly that accused number 1 and number 2 are in custody or were arrested?
I'm not sure, my lord. I'll have to refresh my memory. I mean, I've made that application in 2020. The important thing, the background of the case that was stated, I know that the evidence insofar as accused 1 and 2 that I was making the application on, I'm sure I've stated that. But as to where they are or where they were at the time, one will have to refresh my lord. But the defense has also the copy, and I've got, I can go through it if that's what they want, my lord.
Uye wabhala na kwi-affidavit yakho ukuthi abamangalelwa ngaleso sikhathi bebakade bekuphi noma bebakade beboshiwe uthi anginaso isiqiniseko kodwa ngiyacabanga ukuthi ngichazile kule affidavit yami ngoba ukuthi ngiye ngasho na ukuthi baboshiwe noma cha lokho kuzofuneka ukuthi ngiye mhlawumbe ngifunde statement sami futhi kodwa unaso ummeli nami nginaso uma ingabe kuyavumeleka ngahle ngibheke bese ngiyakwazi ukuthi ngiphendule yebo noma cha.
And last, my lord, the application was not about the verification of address, so I just want to say this, it was about the J50. It was not a statement to say whether the address is positive or negative or they're staying there, so it might be there in terms of the background of where they are. But even if it's not there, my lord, that was not the essence of the application. It was the evidence that I had and the request for the G50 authorization.
Futhi ke leso sicelo bekungasi isicelo sokuthi siyavumelana noma asivume ukuthi ikheli labamangalelwa ilona noma akusilona, bekuyisicelo esigunyazayo ukuthi sithole igunya lokuthi siyobopha abamangalelwa. Yiyo inyinto emsemqoka ebengifuna ukuyichaza.
Let me just put it to you by saying, if that is the statement you made under oath in a 198 statement, if that is the application, that's the statement or affidavit in support of an application, I'll ask you to go through that statement. But in the meantime, I just want to put something to you, then you can comment on that one. If you brought an application, that's what I'm putting to you as a matter of law. If you bring this application and state clearly in your affidavit that accused number 1 was in Modabi and accused number 2 was at Pukeng police station, I'm making an example. The magistrate court was not going to grant that application. Do you agree?
No, I don't agree because you are now, I don't know, I don't agree, my lord.
Uyavuma na ukuthi ngalesikhathi wenza le sicelo lesi sale ncwadi egunyazayo ukuthi abamangalelwa baboshwe kube uye wachaza ukuthi umangalelo oqala mhlawumbe umzekelo use Moda B, umangalelo wesibini yena mhlawumbe use Pukeng police station, ngaleso sikhathi leso sicelo besingeke sivunywe uthi cha lokho ngiyaphika.
Perhaps counsel, my lord can refer me to a section that says if a person is incarcerated, a J50 warrant cannot be issued. Then perhaps we can close this matter because I'm not aware of such.
Mhlawumbe ke uma ummeli angangibonisa umthetho othi uma engabe umuntu esekaboshiwe akwamelanga ukukhishwe incwadi egunyazayo ukuthi lo muntu angaboshwa kwelinye icala, mhlawumbe singakwazi ukuthi sivumelane noma siqhubekele phambili.
Yes, it's fine. You can say that or you can ask for that law, but I'm still putting to you that the proper way of securing the attendance of these accused persons who were at that time of the application were in custody was to requisition those accused to the relevant court for their first appearance. Do you agree?
As a please, my lord, that question is unfair and it's wrong. The witness has.
But they haven't appeared in court anyway.
Yes.
How do you requisition?
Yes.
As I understand the law.
Yes. In any case, the witness has already said that a warrant is a way of securing the attendance of a person in court, and Section 38 clearly states, my lord, that the method of securing the attendance of an accused for his or her trial shall be arrest, summons, written notice, and indictment in accordance with the relevant provisions of this Act.
That's the only way.
The question that my learned friend is putting to the witness is
So that's Section 38 requisition. Hello? Does it talk about,
no, it doesn't talk about.
does it talk about requisition?
No.
Okay.
It talks about a summons.
Yes, someone's fine. Section 72(5)(c), I think. Hello?
I was listening to the
No, I'm
court.
quoting the law.
I didn't hear what the court was saying.
No, you know the law. I was saying to the gentleman who's saying he talks about a summons. There's a way it deals with what a summons is.
Yes.
Yeah, fine.
Mark, I'll still maintain, I'll get into the part where, even if you say there's no such a law, my concern is when the application was brought, there was an information that was not disclosed fully to the presiding officer.
My lord, the address, how is it relevant to the evidence? What the presiding officer and the prosecutor, who obviously both of them signed the warrant, needed to know the strength of the case, whether such warrant can be authorized. And the decision was taken based on that, and as well as the indictment that I referred to. So the issue of address, like I've said, my lord, if counsel perhaps can say to me, this is a section that says you cannot get warrant of arrest or warrant signed by the magistrate when a person is in prison are unlawful, then we'll find each other. Because like I'm saying, I'm not aware of such, my lord, and there's no law that says that.
Okay.
And secondly, lastly, my lord, as I've said earlier, warrants of arrest are one of the means to bring people to court.
Uthi-ke manje mina ngiyakutshela ukuthi ngalesikhathi wenza lesicelo kunezinye izinto ongazivezanga kuleya ncwadi egunyaza ukubopha umuntu. Uthi anginaso isiqiniseko sokuthi ukhuluma ngani ngoba ngiyacabanga mina ukuthi lencwadi egunyazayo ukuthi umuntu aboshwe incwadi ezoyenza ukuthi lo muntu sikwazi ukuthi ayovela nasenkantolo. Uma ingabe mhlawumbe ungangibonisa umthetho oshoyo, mhlawumbe singakwazi ukuthi sikhulume into efanayo, kodwa okwamanje mina ngisamile ekutheni incwadi leyana ngiyifake ngendlela esemthethweni, ingakho iye yavunyelwa nayo inkosi yenkantolo.
The J50 warrant of arrest, I'll just pass the issue of address, but it is relevant, and I'm going to make submissions on that irregularity in terms of granting that or issuing that warrant of arrest. Now let's get into your statement. I think it's A198, if I'm not mistaken. Your affidavit. Are you in possession of that, sir?
For the application for the J50 warrants?
Yes.
No, I'm not, my lord. I'm not, my lord. But my lord, to say the application, the issue was irregular, I disagree. There's no
That's
such.
for the court to decide, my lord.
No, it's not for this court to decide. It's for
Yes.
you, Mr.
Yes, I'll make submissions. At the end of
Mr.
the day.
to bring an application reviewing the decision of that magistrate to say that when he granted that warrant on application by Brigadier Belinda, the law was not permissible for him to do that. Not the witness himself. Unless you accuse him of Fraud, fine. Fine.
Are you in possession of that?
Yes, I am.
Am I correct to say it's A198?
Yes, 198, that's correct, my lord.
Do you need some time maybe to check if the aspect of the address has been canvassed on the affidavit?
I can, my lord, but like I said, I can. If the
Yes.
defense wants me to do that, but I've already dealt with them.
Now, I
The
just want to
issue-
place it on record, Mr. Kinenda.
I will, yes, my
Yes.
lord. But what I'm saying, what must be clear, there is nowhere where the issue of address is a prerequisite for getting a J50. You don't get J50 unless you are saying the person, because even if the address is wrong, if the elements of a crime are not there and the person didn't commit that offense, why would the judiciary sign the warrant of arrest? The basis of this application and authorization was based on the evidence collected insofar as accused 1 and 2 are concerned, my lord. But I will check if I...
No, this court wants to know what's inside that warrant.
Usiphethe na
That
istatement sakho.
application, the court must also know.
Usiphethe istatement sakho uthi yebo ngisiphethe uthi ungasibonisa na la ukhulume khona ngekheli likamangalelwa uthi lokho ngingakwenza kodwa angiboni ukuthi kumqoka kanjani ngoba awukho umthetho ongivimbayo ukuthi uma ngingenalo ikheli likamangalelwa ngingahle ngifake lesicelo manje mina ngibona ukuthi lesicelo ngasifaka ngendlela esemthethweni uthi ngakwenza lokho na njengoba sekasibheka istatement sakhe efuna leyo ndawo la ikuthi kubhalwe khona.
But you've got to read that statement, sir. Were you suggesting the same, Mr. Baloyi?
No, I want to point out that my learned friend wants to use a statement that he hasn't proven as yet. He must first prove the statement, then follow
No,
the
it's okay. He doesn't have to prove it if he wants this
Correct.
witness to read it under cross-examination. Okay. That's the law.
Well, we still maintain that if you want to cross-examine on a statement, you first have to prove it.
No, fine, but not under these circumstances because they are not at either. Just read that for everybody to know what is in that document.
All right, my lord. So it says, I, the undersigned, Bongani Nicholas Kinenda, state under oath, as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander for Cold Case Investigation Unit of the National Commissioner, with the rank of a colonel and the service number. I've mentioned the service number as well as the telephone number. That's paragraph 1, my lord.
Na yike
No.
iparagraph yokuqala
Let him finish first.
as the court places. Thank you, my lord.
I am the lead investigating officer of Phosphorus 636-10-2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that 2 black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witnesses stated that one of the accused was carrying a firearm, purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as a tall, slender, neatly shaven and dark in complexion. It is stated under oath that during the robbery in the same house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Meyiwa on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one of the cellular phones belonging to Ms. Kelly Khumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others, a hoodie, were standing hidden away about few meters from the crime scene prior to the incident, appearing to be typing on their cell phone. It is stated that the suspect fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identities were compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 8:30 and 2100 hours, my lord. The deceased was declared dead on arrival at the hospital at 21:15. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost during covering the area of Phosphorus Hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under will indicate that the planning of the offense and gathering after the incident took place at Phosphorus Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa. The suspect in question are as follows. 3.1 Musika Ukulelwa Sthemba Spear. He was first linked to this offense by means of witness statement under oath. The accused boasted to individuals closely associated with him in KZN Homelands as to his involvement, together with Mafika, herein as under suspect 2, Carlos under suspect 3, Mapisa suspect 4, and Ngani suspect 5 into killing of the deceased. A dispute ensued between the individuals and the closely associated individual disclosed to the ACPS the admissions these accused made to them. The accused was further linked with circumstantial evidence wherein minutes after the incident made disclosure and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo even before the death was reported in the media. He is further linked by means of a formal confession he made to the Commission Independent Officer on the 30th of May 2020. The suspect further made a formal pointing out the sequence collection prior to the incident, the guarding of the outside of the house during the assassination, and the dropping of the accused at the cell phone tower referred to herein above. Second one, 3.2, Bongani Sandison Tanzi, nickname Mafida. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identity compiled through description of witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and he was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and compiled identity. During the questioning, the suspect searched during the questioning and the subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. Hereafter, the suspect indicated his eagerness to confess as to the involvement in this matter. The suspect made a confession to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as a tall, slender build which came into the house. 3.2, Tobisi, friend's nickname Carlos Nobe. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was sentenced prisoner serving 35 years imprisonment for the murder committed in 2015. Ballistic test revealed that the same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloadings of this cell phone were done. The photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver upon entering the house. Photos downloaded taken of the accused by himself or selfies match the description of the suspect who had a firearm with red locks, big eyes, and with the gold teeth. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Photos were actually found of the murder weapon used in the murder of Senzo Meyiwa. 3.4, Mthokozisi Zikhozonke Mapisa, also known as Mapisa. The suspect is linked to this offense by means of certified sworn statement and referred to herein above. He is further linked by means of confession he made to a private person, a close friend, about his involvement in this matter. This confession came about in that the suspect requested this private person to establish reasons why suspect Mafika was arrested. The information disclosed was that the suspect Mafika was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person return disclosing this information to the suspect Mapisa, did Mapisa instruct the private person to return to and inform Mafika, that is accused to not disclose his Mapisa's involvement as he, Mafika, will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5, Sifokuhle Nkani Ntuli, also known as Nkani. The suspect is linked by means of sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo. Evidence also revealed that he drove the car with the suspect to the same scene and back to Phosphorus Hostel after the incident. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafika, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the said vehicle prior and after the committal of the murder in the company of the referred suspect. The above suspects are also known to be hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35, Act 108 of 1996 by me and questioned for these incidents. Some of the suspects made confessions to the independent commission officers as well as the magistrate as indicated above. Others made confessions as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence by means of sworn, collaborating and independent witness statements establishes a causal link between the offenders and the offense of murder, robbery with aggravating circumstances, possession of unlicensed firearm, and the unlawful possession of ammunition. The Director of Public Prosecution Gauteng Division, on a directive of the National Director of Public Prosecution, issued, after careful consideration of the presented evidence, that the above 5 suspects in paragraph 3 must be arraigned for murder, robbery and aggravating circumstances, as well as possession of unlicensed firearm and ammunition. The instruction are attached with the statement as B and G1. I hereby apply for the warrant of arrest for the following suspect on the above indicated charges on this paragraph. Then it is the names of accused 1 to 5, my lord. Then it's the oath, and the statement was commissioned on October the 3rd, 2020, the 3rd of October, my lord.
Naso-ke istatement sikaBrigadier Rudinanya ngamafuphi istatement lezi sichaza ukuthi uyenzeni yena ngaphambi kokuthi aze azobhala lesi statement la ukuthi uyachaza nokuthi abamangalelwa bona bafakwa kuleli cala bayenzeni, futhi kunala ukuthi uchaza ukuthi umangalelo oqala uye wahamba wayekhuluma nobani umuntu bekade sondelene naye, ingakho ukuthi lo muntu loyo uyewagcina sekuthi uyotshela amaphoyisa, bese ke umangalelo oqala kula ebandakanyeka khona. Nomangalelo esibini naye kunezinto ukuthi uye wazikhuluma ebekade ezikhuluma kumuntu othize naye ubandakanyeka ngaleyo ndawo, naye ukuthi umangalelo wesithathu uchazwa umangalelo wesibini ngalesikhathi ebekade ekhuluma egunyuluka laphayana ukuthi yena uthi bekayenzani kula, nawo umangalelo wesine naye uyachazwa khona lapho, futhi ngathi ikulesa statement sikamangalelo wesibini. Umangalelo wesihlanu yena uchazwa njengomuntu obekade naye ekhona, futhi uyena umuntu obekade eshayela imoto le bekade kuhanjwa ngayo ngalesikhathi kwenzakala leli cala leli kwenza liqale ingathi bekade kuyobanjwa nje inkunzi, kodwa kugcine seyikuthi kuyabonakala ukuthi bekungasi nje ukuyobamba inkunzi okujwayelekile, bekade kuthunyelwe noma bekade kunolwazi lokuthi kuyoyenzakalani khona lapho, futhi labantu laba bekade beyingxenye yokuthi leli cala leli liyoyenzakala. Futhi kuchaziwe nalana ukuthi umangalelwa ubekade owesithathu ubekade yena ngaphakathi kwicala ukuthi lenzakele ngo-2015 lokuthi nalo bekade sekuthi unikwe isigwebo seminyaka engama-35 la ukuthi ubekade ebhadla ejele, kodwa ke ubrigadier uthi naye uye wayenza uphenyo lwakhe, ingakho egcine sekuthi ubhala lesi statement. Ngamafuphi nje akusiyonke into ayibhalile, kodwa bengizama nje ukuthi ngithi ukusibamba laphayana nalaphayana nesi statement.
My lord, I just want to correct also the date in which the statement was signed and commissioned. It's actually the 23rd of October 2020. Sorry, not the 3rd, so it's 23 October 2020.
Tike futhi enye into idate yale statement la si signwe khona akusiyi 3 yi 23 zika October 2020.
Yes, Mr. Mgomza.
Thank you. Mr. Please, Molo, just before my learned friend cross-examines, we just want to caution my learned friend against this course of cross-examination that is embarking upon. We must keep in mind that we're busy with a trial within a trial. And the purpose of a trial within a trial is to insulate the proceedings from the merits and to protect the interests of the accused should he wish to testify in the trial within a trial, not to expose his flames to cross-examine on the merits. Now, my learned friend is canvassing issues which pertain to the merits. And should his client now decide to come and testify in the trial within a trial which must keep in mind that the trial within the trial is concerned with the admissibility of the statements that were made by the accused. Now, my learned friend is now canvassing the merits, which will expose his client to cross-examination on the merits, should he or should both of them decide to testify in the trial within a trial.
Mr. Khumalo is an experienced advocate. He knows what he's doing.
That's correct. In response from the submission made by my colleague, I am so grateful that he mentioned the aspect of protection of the client's rights. But what is very important in relation to the contents of his affidavit will be injected also when the argument arises on the admissibility of confession, the extraocular statement made by.
They're not admissible against another accused.
That's correct.
Yeah, we know that.
Yes.
And by the way, just so that there's no misconception,
Okay.
what Ginanda is reading there is hearsay.
That's correct.
Please.
That's correct.
So, hey, Judge Lee, things are going to give evidence, what? It's hearsay. It's not admissible.
Yes.
But I said he must read it because you were insisting that there are certain contents there which render that application unlawful, as you
correct,
said.
my lord.
Okay.
As I've indicated, my lord, also that the gist of these proceedings relates to the admissibility
Yes,
of
yes.
the confessions.
That's it.
Where does the I'd say, what factors will the court consider at a later stage if some of the information that is important to the argument that an extraocular statement was made which resulted to the arrest of other accused persons. May I proceed?
Yes.
Just to confirm, my colleagues are requesting a short
What's the time now?
It's 12 o'clock.
12 o'clock.
It's 5 to 12, my lord.
Until when?
5 past. Until
Okay,
5
quarter
past
past 12.
Just to wrap up on the issue of sorry, my lord, they
Oh, you're not yet here.
are not.
Yes, sir.
Thank you, Manu. So finally, Mr. Kininda, Brigadier Kininda, on that affidavit, it's clear that there's no mention of the addresses of the suspect. That's the only aspect I want to cover.
It is not there, but it's also not a requirement for obtaining of a J50 mallet.
Manje ekugcineni kuyabonakala ke ukuthi kwi-affidavit yakho akukho la ubhale amakheli wabamangalelwa uthi yebo akukho kodwa akusuki ukuthi kwamele uma ufaka isicelo sokuthi umuntu kube nephepha eligunyaza ukuthi aboshwe bese kuba nekheli lakhe.
Thank you. Let's get into the taking of the confessions. The defense is placed on record that the alleged confessions of both accused number 1 and number 2 were not freely and voluntarily taken or made. They did not make any statements to the effect.
So, I disagree, my lord. That's one. Secondly, accused one, both accused, before the confession was formalized, spoke to me. And when they spoke to me, my lord, they were aware of their rights. The confession that they made to me was made freely, voluntarily, without any undue influence. Therefore, I'll have no reason to doubt why they will know now when they get to the independent officer will not confirm such, because they elected to do such. That's the first part I want to explain, my lord.
Manje ke mina njengommeli ngiyakwazisa ukuthi thina asivumi lolu daba ukuthi abamangalelwa baye bagunyuluka laphayana umangalelo oqala nowesibili. Uthi ke ubrigadier uma ephendula uthi cha lokho ngiyaphika ngoba abamangalelwa baye bakhuluma nami qala aphambi kokuthi baye kulomuntu nomunye. Nakhona uma sebafika lapho kungani bangazange bachaze ukuthi thina asifuni kuyenza lento, asifuni ukukhuluma uthi mina baye bakhuluma nami, ingakho ngingagcina sekuthi ngibathumela uzakwethu ukuthi bayokunyuluka khona.
The second part, my lord, the accused two in particular, then the second confession was made in the presence of his attorney to the magistrate on the 24th of June 2020. But furthermore, my lord, there was a 105 engagement in terms of Criminal Procedure Act, Section 105 capital A, between the state and the accused while he was legally represented. And in the documentation that we have, they firmly say they stand by the two confessions that were made by accused two.
Manje ke futhi enye into esemqoka ukuthi umangalelo wesibili wagunyuluka nge-24 zika June 2020 ebekade enommeli wakhe, futhi kuye kwabhalwa futhi naphansi ukuthi bona bame ngawo lawo mazwi lawo akhulunywe umangalelo wesibili.
And elected as part of his plea bargaining proposal, my lord, and so I must say this because the assertion is that they never made any statement. Insofar as admitting the statement he made, went further in proposing the plea bargaining that he will plead guilty and testify against his co-accused. That is the extent of the discussions between accused two and the state.
Futhi ke akaphelelanga lapho ngokugonyuluka nje umangalelo wesibili uye wakhulumisana nathi ukuthi ke ake siyenzeni kanje, ngizovuma icala bese ningenza ufakazi kulo lelicala, ngizofakaza ngalolu daba olwenzakele, ngikhulume nokuthi abafowethu bayenzeni noma ngisho ukuthi abafowethu kwenzakele.
So those are the reasons, my lord, why I will not believe now that all of a sudden those statements were not made. There wouldn't be that discussion insofar as accused number two, and even if accused number one, in all the appearances, not once was it raised, even in Boxbeck, on the first appearance, my lord, none of the accused, this is 1 and 2, raised the inadmissibility of the confessions that they've made.
Futhi ke abamangalelwa bobabili umangalelo oqala nowesibili akukho nalanga lesikhathi bevela enkantolo nase-Boxbeck la ukuthi bona baye bachaza ukuthi animancala thina siphuqelelwa ukuthi sikhulume, thina asivumi leyo nto, thina besingafuni ukuthi sivume, thina besingafuni ukuthi sikhulume lento leyo, thina siphoqiwe. Bathi cha akukho la ukuthi baye baveza lokho.
When accused number 1 was arrested on the 30th of May 2020, on the same day he made a confession.
That is correct, my lord.
Umangalelo oqala uma eboshwa nge-30 zika May 2020 kula ikuthi yena uye wagunyuluka khona uthi yena.
And you said you did not know Colonel Mboto. Am I correct?
No, I said I've never worked with him and he was not privy to the investigation. I don't think if I said I did not know Colonel Mboto. The person that I said, my lord, I do not know. I've never spoken to him and I've never worked with him and even saw him and saw him for the first time was Lieutenant Colonel Rapadi. I don't think I said the same thing about Colonel Mboto.
Uthi uye wathi ke uKolonel Mboto bokade ungamazi uthi cha uma ngikhumbula kahle uMbotho ngithe angikaze ngisebenze naye futhi wayekade engenalo ulwazi laleli cala.
Okay.
Mina angizange ngithi angimazi umuntu ongicabanga ukuthi ngithe angimazi uKennel Rapal.
No, it's fine. Accused number 1, when he was arrested at Tembisa, he was then taken to Vosloorus. But before he was taken to Vosloorus, he said he was beaten, he was tortured to make a confession. Will you dispute that?
Well, my lord, it was not told to me. I was not there when he was arrested. What I know is the engagement that I had with him at Vosloorus police station. And when we were there is no statement that he made to me that he was tortured or beaten. I've asked him. I actually even took an opportunity of sending away the officers who were there with me and spoke to him away from them because I wanted to establish exactly that whether he was threatened or he was talking to me under undue duress, and I didn't pick that up, my lord, and I didn't see any visible injuries, nor did he tell me that, my lord.
Uthi ummangalelo oqala yena ngalesikhathi eboshwa eThembisa uye washawa waphoqwa ukuthi ayokhuluma. Uthi ke ubrigadier mina ngalesikhathi elethwa kimi eVosloorus akazange akusho lokho. Futhi nalamaphoyisa labe bambopha mina ngiye ngathi bahambe ukwenzela ukuthi ngikhulumisane naye ummangalelwa ngizokwazi ukuzwa ukuthi ngempela mhlawumbe ummangalelwa ushayiwe noma kunento ayenziwe engamphathanga kahle azokwazi ukukhululeka enami sobabini kodwa akukho na ummangalelwa agcine sekuthi uyasho ukuthi kwenzakeleni kuye.
What I want to establish is when you were talking to accused number 1 at Vosloorus, and when you asked those people to give you space, you're the one who was telling Colonel Mboto that a person wants to make a confession.
No, so that's not how it happened, my lord. I warned him, we spoke, when it was clear that he was prepared to make a confession to an independent officer, freely and voluntarily. I then instructed those members to change the direction in terms of where they were going and go to Eraton. While I was driving to Eraton, alone in the car, I phoned numerous officers until I got assistance from Colonel Mboto. So the communication between myself and Command Mboto and Colonel Mboto was not in the presence of accused number 1.
Manje ke ummangalelwa ngalesikhathi uze kuthola uKennel Mboto wena ubukade unaye uthi cha mina ethe makulibele besahamba naye ummangalelwa kulayi ukuthi ngiye ngabacebisa ukuthi baye ngase Eraton mina ngangishayela ngedwa la ukuthi ngiye ngashayela ucingo amaphoyisa amanye ahlukile kulayi ukuthi ngcine sengithola uncedo kuye uKennel Mboto ngalesikhathi ummangalelwa wayekade engekho nami enalamanye amaphoyisa.
All right. My question is, when you communicated with Colonel Mboto, that was you who informed him that there is a suspect who wants to make a confession.
That is correct, it was me.
Uthi yebo ngalesikhathi ngikhuluma noMbotho ngiye ngamtshela ukuthi kunomsolwa ofuna ukuyokonina.
Okay. I just want to establish if you heard accused number 1 telling Colonel Mboto that he wants to make a confession.
No, my lord. As I said, my discussion with him was, are you prepared to make a confession to an independent officer, not Colonel Mboto? I did not know which officer I would find at the time. So, and as I said, when the communication of calling various officers were made by me, the accused number 1 was not there. So I didn't ask him to make a confession specific to Colonel Mboto because I did not know who will assist me at the time.
Manje ke umzwile na ummangalelwa yena ekhuluma kuKennel Mboto uthi cha ngalesikhathi mina ngikhuluma nommangalelwa bengingakatholi ukuthi ubani umuntu ozongisiza ukuthi ummangalelwa akhulume futhi ummangalelwa angizange ngithi kuye uzimisele na ukuthi ungayokhuluma noKenneth Mboto. Mina ngithe uzimisele ukuthi ungayokhuluma nomuntu ongekho la phakathi kwethu oyekuthi kuumuntu okhululekile ole eceleni.
But you will not disagree with the accused if he says he never, he did not tell Colonel Mboto after he has been appointed or whatever way. But he says he did not communicate to Mboto that he wants to make a confession. You cannot dispute that. That was only said by you.
I don't follow my lord. Which part was said by me?
May I rephrase it?
Yes.
I would say accused number one did not make or did not say he wants to make a confession to Colonel Mboto. That you cannot dispute.
No, my lord. As I said, there was no mention of Colonel Mboto in my discussion with him. It was a discussion of, are you willing to freely and voluntarily make this confession to an independent officer, someone not attached to this investigation? The answer was yes.
All right.
There was no specific name given that this is the person who will take the confession.
Thingicacise kanjena Nkosi yenkantolo, mina angizange ngithi kummangalelo wokuqala uzimisele ukuyokhuluma noKenneth Mboto. Mina ngithe uzimisele na ukuyokhuluma nomuntu ozimele ongekho la phakathi kwethu. Angizange ngimnike igama ukuthi eyokhuluma nobani.
Okay. May I rephrase it by saying, accused number one did not say he want to make a confession to that independent person. Will you dispute that? That
Yes,
he never said that.
No, absolutely, I'll dispute it because he said it to me. He said it to me, hence I made those arrangements. If he did not say it, I was not going to make those arrangements.
Manje uzophikisana nommangalelwa na uma yena engathi akazange athi yena ufuna ukuyokhuluma nalo muntu lo obekade ezimele. Uthi yebo lokho ngizokuphika ngoba bengeke ngiyenze ukuthi ngithole lo muntu uma ingabe ummangalelwa wayekade engashongo ukuthi ufuna ukuyokhuluma nomuntu ozimele.
That's the reason why accused number one says he was subjected to torture, he was choked for him and for you to make such arrangements. He did not voluntarily make such a statement. There was a prior act or action that was taken against his will. Later, you then made arrangements for the taking of a confession. That's what he's saying.
My lord, let me understand so that I don't answer haphazardly. Is the defense saying accused one was tortured in my presence? Because I understood him to be saying he was tortured in Tembisa, then brought to me. So is that what the defense is saying, or is it now saying, or the version is that he was now tortured in my presence? So that I'm clear in my response.
Let it be clear. Accused number one, he was tortured in Tembisa when he was arrested, taken to Phosphorus. I did not mention
Sorry.
torture in your presence.
Oh.
I just said when you allege that he made a confession, he was subjected, I didn't specify the place where. He was assaulted by the police. As a result, when you arrived, that's then the issue of taking a confession happened. Because according to him, he did not speak to any independent person to say, I want to make a confession.
My lord, he spoke to me prior to Kenneth Mboto. Prior to me meeting him, I got a call from Sergeant Mohola who told me that he was making some sort of admissions. Hence, I then said, bring this person to Phosphorus ACPS so that I can talk to him. When we met, my lord, there was no indication or complaint that was said to me by accused number one insofar as being threatened or tortured or anything whatsoever. I asked him this question when I was trying to establish that he is willing to make this confession freely and voluntarily, and that he understood his right. He didn't say such to me, my lord, and I did not see any visible injuries or signs of being in pain, things like that. I did not read anything to that effect, my lord. Otherwise, I would not have proceeded making such arrangements.
Mina kimi ngalesikhathi umangalelwa nginaye angizange ngibone impawu zokuthi mhlawumbe ushayiwe noma ulinyaziwe noma uphoqelewe ukuthi agcine seyikuthi ufuna ukuyogonyuluka, ngoba uma bengikade ngibonile bengizombuza bese ngiyenza isiqiniseko sokuthi lo muntu lo akayenza into eyena angayifuni. Mina ngimbuze imibuzo ngizama ukwenza isiqiniseko sokuthi ngemva kokuthi umhula sekamlethe kimi iqiniso nawo ukuthi lento umhula angitshelayo ukuthi ingathi umangalelwa yena kunezinto azikhulumayo ezenza ukuthi manje kuzofuneka ukuthi kutholakale umuntu la azokunyuluka khona. Ngifike ngambuza nami ukuthi iqiniso na kube bengibone lezo impawu bengeke ngiqhubeke.
Okay. Now, at that time, when the alleged confession was taken, after the confession was taken, the alleged confession was taken, what was the step that you took to charge the accused? Because now we have some kind of evidence implicating accused number one.
No,
What
there was,
step did you take?
so, my lord, there was no step. It was not necessary. There is no, with greatest respect, my lord, I don't mean it to sound it in a bad way. There's no law that says once a confession is made, a person must be charged. Unless a person says, I'm pleading guilty, take me to court. And that is why, insofar as accused number 2, we had this 105 capital A arrangement. Those are the processes that are undertaken. So you don't, because when a person confesses, he's simply saying, I'm admitting my wrongdoing, then there are processes that will be put into place to finalize the matter. You don't just turn and charge a person just like that. And if it's investigation, my lord, I needed personally to corroborate what was said, to get more evidence, establish whether what he is saying there's authenticity in it. So there were a lot of things that needed to be done before you can come to the finalization of that confession matter.
Eziphi inyathelo ezithathile ngemva kokuthi umangalelwa sekagunyulekile ukuze uzogcina somthwese icala uthi cha akusukuthi kwamele kube nezinyathelo ezithathwayo umuntu mayeqeda ukugunyuluka? Kwamele lo muntu loyo mhlawumbe yena uma engathi uvuma icala bese ke ngiacele yena ukuthi ngiyise nenkantolo kula ukuthi lo muntu uthathwa ayisiwe enkantolo. Kodwa ngemva kokuthi umuntu sekagunyulukile akusukuthi kwamele athweswe amacala, kwamele kwenziwe isiqiniseko cala sokuthi lo muntu lona lento azikhulumayo zineqiniso elingakanani, ziyiqiniso elingakanani, futhi lezo zinto uzikhulume kahle ngale ndlela bekade vele bekwamele azikhulume ngayo, ngale ndlela yena azi ukuthi kwenzakele ngakhona. Ingakho kuye kwagcinwa seyikuthi kwenziwa nalesi sivumelwano ebekade siyenziwe lesiyana ngomangalelo wesibini la bekade ethe angavuma icala bese yena kugcina seyikuthi ugcina sekufakazi. Kodwa akusukuthi umuntu mayeqeda ukugunyuluka bese uthweswa amacala.
What do you understand about the procedure after you have explained the rights of the accused to be brought before court within 48 hours? What do you understand by it?
My understanding, my lord, is that when he's charged, my lord, he must indeed appear before court within 48 hours, and if 48 hours lapses on the weekend, on the first day of the court appearance, when he's charged on that matter, not when he's given rights for investigation purposes. Those are two different things, my lord. You are given rights, 14A, you are charged formally to say, now, these are the charges, we're putting them on you. Then indeed, within 48 hours, or on the first day after the ending of the 48 hours, if it's on weekend, my lord, the said person must appear in court.
Engikuzwisisisayo ngokuthweswa kwamacala ukuthi umuntu ma ethweswe icala lo muntu loyo kwamele ayobingelela umantshi kumahora kungakapheli amahora ayishumi nane. Uma kungenzeka ukuthi lawo mahora lawo awela ngaphansi kwempela sonto kulayi ukuthi lo muntu loyo iviki uma liqala kwamele aye ayobingelela umantshi kodwa uma ingabe kungayenzakalanga kanjalo mhlawumbe engakathweswa amaqala kungenzeka ukuthi amahora lawo angahle adlule.
All right. Accused number 1 was detained in Valeria after the taking of a confession. He was detained.
I agree.
And his rights were explained further.
I agree, but the reason, my lord, that's what Mr. Mgomezelo is not going to. He was detained in Valeria for the charge of dealing in drugs. And the rights were given insofar as that matter. Subsequently, he was formally charged, and on the 1st of June, he appeared in Tembisa Court for those charges.
Uthi-ke
2020, 1st of June 2020, my lord.
umangalelwa wokuqala ke yena ngemva kokuthi sekakhulumile naloyelela phoyisa uye waboshwa ke wavalelwa eValeria. Uthi yebo wavalelwa eValeria kodwa bekangavalelwa ngenxa yaleli cala ukuthi ulithweswe lona noma bekade ebhekene nalo. Ubekade evalelwe ngenxa yaleli yaqala lokushushumbisa idakamizwa akusiyileli esikulona.
Yes. Now the question is, from the day he made a confession, the alleged confession, that is the 30th of May. Then the 6th of June, it's an alleged pointing out. So, was that evidence not enough to charge accused number 1?
So, my lord, let me just correct one thing. The pointing out was done on the 5th of June, not the 6th.
Sorry, the 5th.
Yeah, the 5th of
Yes.
June 2020, my lord. That's the first part.
Yes.
Now, yes, my lord. So, in the confession, the written confession, not the pointing out, certain things were said by accused number 1, which one followed extensively. And what we followed is in the docket that we disclosed to the defense. As I said, we needed to corroborate what was said there. So there were things that were said there that were followed in terms of his co-accused and where possibly the whole thing came from, the killing of Senzo Meyiwa, because he mentions clearly who gives them the instruction to kill Senzo Meyiwa. So those things, you can't just say now it's enough. You've not found independent corroborating evidence of the assertion that he's saying, my lord.
Manje ke umangalelwa yena uyaboshwa ke nge-30 zika May 2020 bese nge-5 kulayi ukuthi yena uyahamba uyokhomba okuthize. Uthi yebo ke kodwa bekwamele siphenye siqhubeke uphenyo ngoba kunezinye izinto azishoyo kuleya ndaba le ayikhulumile. Uyasho nokuthi ubani obatshelile ukuthi bayobulaya uSenzo Meyiwa. Bekungasi ukuthi sizovele sithathe lokho akushilo bese simthwesa amaqala. Bekwamele siqale siphenye.
All right. If a person is detained after he has made a confession, and on the 5th of June, it is alleged that he pointed out either the crime scene or whatever place, that person is still kept in detention until he is charged on the 26th of October 2020.
My lord, he was kept in detention not for this matter. He was in detention for the drug dealing matter, not this matter.
Umangalelwa lo njengoba eboshwa nge-30 zika May nge-5 ehamba ayokhomba le ndawo noma eyokhomba noma yini le bekade yenzeka, uye wagcinwa esitokisini kufikela nge-26 zika October 2020. Uthi yebo kodwa engagcinelwanga leli cala, wayekade egcinelwe icala leyidakamizwa.
But the investigations were ongoing whilst he was in custody.
I agree. So far as this matter is concerned, they were ongoing, my lord, and rightfully so.
Yebo uphenyo lalikade liqhubeka ngaleli cala. njengoba ummangalelwa yena wayekade egcinwe esitokisini.
Okay. So, to place it on record, from the day he made such an alleged confession, pointing out on the 5th, up to the day in which he was formally charged on the 26th. Accused number 1 indicated to me that there is a document where his fingerprints were taken, and that document bears the date in which he was charged.
I'm not sure, my lord, what document is referring to. But what I can say about fingerprints, the taking of fingerprint does not necessarily mean you have been formally charged. Fingerprints are taken, for example, if you want to run your fingerprints to see if you are linked in other matters, which, for example, you could be circulated or partial prints, appearing on the system and you are still outstanding. So there are various reasons why fingerprints are taken, but I'm not sure what document is referring to in this one in particular. But all that I'm saying is that during the cold case analysis, as I've indicated earlier, when we were trying to triangulate them and eventually go to them, a lot of extensive investigation in terms of profiling, and obviously when we got to them, prints were taken for the Tembisa matter, and obviously elimination prints were also taken to see if you can pick them up in various matters. Hence, different cases were picked up that we were aware of before we picked them up. Others came up after accused 1 was picked up, my lord.
Manje ke ummangalelwa utshele ummeli wakhe ukuthi kunephepha thizeni eyikuthi lela setshenziswa ama fingerprint wakhe wabekwa kulo lelo phepha. Uyalazi na uthi ufakazi uma yephendula ucha lelo phepha ngazi ukuthi eliphi. Mina ongwaziyo ukuthi umuntu akusukuthi uma kuthathwe ama fingerprints wakhe lo muntu sekathweswe amacala. Kungenzeka ukuthi lawo ma fingerprint athathwa ukuthi kuyohlolwa ukuthi mhlawumbe awekho amanye amacala la ukuthi lo muntu ubandakanyeka kuwo noma lo muntu loyo. And my lord, I see the accused is raising his hand.
Yes.
Lo muntu loyo angahle mhlawumbe ama fingerprint lawo kuyohlolwa ukuthi akhona na amanye amacala noma lawo ma fingerprint kugcine seyukuthi kusayobhekwa ukuthi lo muntu lo uyena lo muntu osithi uyena.
All right. Tell me, who formally charged accused number 1?
It's Sergeant Mahula.
Ubani umuntu othwese ummangalelo wokuqala icala uthi uSergeant Muhula
In relation to this matter
Yes.
of Senzo Meyiwa?
Correct, in relation to Phosphorus 636 of 10/2014, my lord.
uthi ngikhuluma ngaye uSergeant Muhula uyena othwese ummangalelo wokuqala icala leli lika Mufi uSenzo Meyiwa.
Do you know which date was he charged?
26th of October 2020, my lord.
Uyazi ukuthi uthweswe nini icala uthi yebo bekade kuyi-26 zika October 2020.
Thank you, my lord. According to evidence or the version of accused number 1, he says, you're the one who charged him at Phosphorus police station, and it was, he can't recall the date, but it was in August.
My lord, as I've said, I mean, we've disclosed the docket. The 14A, the defense is in possession of. They can see the person who gave the notice of rights insofar as this matter is clearly depicted. There's no confusion. It's Sergeant Mokola. The statement that is made insofar as charging the accused on the 26th of October, it's there. The defense has it. The warrant of arrest that was executed on the 26th of October 2020 is also there. It's been disclosed to the defense. There's no dispute who charged him. It wasn't me. I did charge some of the accused, or one of the accused, but definitely not accused number one, my lord.
Sibiya uyalichitha ubrigadier Dininda udaba lokuthi uyena okuthwese icala ngo-August uthi cha akusuyena yonke into ibhaliwe edocketini futhi uthi ibhalwe ukuthi uSergeant Mkhula uthi yebo yena ukhona omunye wenu oyikuthi uye wamthwesa amacala kodwa bekungasusibiya.
My Lord, with your leave, may I reserve this question until I fully consult with the contents of the docket.
You haven't consulted the docket yet?
Relating to that aspect. I need to revisit my notes, the docket.
Okay, fine.
So in essence, my lord, what should perhaps, what I can say, my lord, there is no reason for me to hide the fact that I would have charged accused number one if I did. Hence, the accused that I charged, that is before court, and that is accused number 4. My statement is there as well. Notice of right, statement, the warrant that was executed is also attached in the docket, and it has been disclosed to the defense. So there's no hide and seek around it. It's a pertinent issue, my lord. I don't think it's really something that we want to hide, my lord.
No.
Uma egcwalisela kwimpendulo yakhe ke ubrigadier uthi asikho isizathu esingayenza ukuthi yena afihle ukuthi uthwese bani amacala uthi kahle kahle umuntu oyena amthwese icala umangalelwa wesine oyikuthi uyena oyewamthwesa amacala akusumangalelo oqala asikho isizathu esingayenza ukuthi yena afihle ngoba into encane ukuthi ukuthwese umuntu icala bese uyayichaza akusinto ukuthi angahla ifihle.
If permission is granted, my Lord, may I proceed to other questions?
Yeah, no.
Yes. There's one thing that I just want to conclude on the aspect of the taking of the. It's an obvious question. It's an obvious question that you were not present to prove that accused number one gave that confession freely and voluntarily. When he was the allegation that he made such a confession, you were not physically present.
With Colonel Mboto, which accused perhaps maybe?
I was referring to accused number one.
I was not with Colonel Mboto, I agree. I was not there. But if you say to me, my lord, the confession was not made freely and voluntarily, that's not the impression I got, because it started with me. And my understanding, it was freely and voluntarily. When he came back, I spoke to him, and I didn't receive any complaints from him. Hence, the proceedings of the pointing out to the traditional healer the following day was embarked upon. The arrangement of the formal pointing out, confession by conduct of the 5th of June was embarked upon after I've confirmed with him in person on the 4th, the day before, that he's still willing to proceed with this confession by conduct, my lord. So the information or the impression that I got in all material times, because he was warned according to his constitutional rights, is that he was willing to continue and he was making these confessions freely and voluntarily. I don't have any other reason to do
Uthi ke manje kuyazeka ukuthi wawukade ungekho ngalesikhathi umangalelo oqala eGumilunga uthi yebo bengekho kodwa mina into engiyaziyo ukuthi ukhulumile ekhuluma engaphoqwanga ngoba uma ebuyela kimi ngiye ngambuza ukuthi uhambe kanjani laphayana ukhulume kahle akuzange kube nokuthi aphoqwe akazange alinyazwe noma into ezinjalo uthi umangalelwa naye akazange angibonise noma angitshele ukuthi ushayiwe noma kunani eyenzakele ebekade ingekho emthethweni uthi futhi leyo into ukuthi ngijwayele ukuthi ngiyenze ukuthi umuntu mayebuya bese ngiyambuza ukuze nganeliseke nami ukuthi lo muntu akaphoqwa.
You deal with the requirements of free and voluntariness in sound and sober senses. On the interview that you had with the accused, that was not a confession, in terms of the provisions of Section 217. It was just an interaction between you and the suspect. So there were no formalities there. But the formalities, in terms of that provision, must be proved by the person who took a confession. When you say, may I just qualify this for you to understand this? You explain the rights. After he said they said information to you, that was an informal process. Do you agree?
I'm not sure.
May I repeat it?
Yeah.
May I rephrase it? At Fosloras police station on the 30th of May, when you were interacting with accused number 1, I'm saying whatever that he said to you was an informal process, because for you to legitimize that process, you had to get somebody who must take a formal confession. You agree?
I agree. I agree, my lord. But the part that I wanted to correct was that it was the rights before and then he spoke, not the other way around. That he spoke and then I wanted.
Uthi manje ke uyavuma nawo ukuthi inkulumo yakho nommangalelo wokuqala lapha eFosloras bakade kuyinkulumo nje ebungasi inkulumo esemthethweni noma ebhalwayo ukuthi ingahle isetshenzisiwe. Uthi yebo lokho ngiyakuvuma, kodwa ngicela ukucacisa la ukuthi akusukuthi ukukhulumile bese ngimtshela amalungelo, ngimtshele amalungelo cala bese uyakhuluma.
Yes. What I want to put across to you is that what Mboto or Colonel Mboto has done with accused number 1, and you were not present, cannot be an evidence by you to confirm that the provisions of section 217 were complied with. That from you is a hearsay evidence,
Well,
because
my
you were
lord,
not present.
Yes, I totally agree, my lord. I was not there. All I'm saying, and that's what I've said even earlier, I'm not giving an impression that I was present. All I'm saying is that prior to Kenenbo to kicking in, I was convinced that he's prepared to make these confessions freely and voluntarily. And the issues of not being under influence, my lord, I think they're critical, because you cannot, for example, establish that the person is under medication or he is intoxicated. I mean, why would you want to formalize that confession? So they were important before you can start formalizing the process. But yes, I was not present with Colonel Mboto. All I was saying is that there was no reason given to me prior to the taking of the formal confession and after. But furthermore, my lord, I had access to the confession when I collected it from Colonel Mboto in his office. And it's clearly, I mean, I read it. I read it. I saw what questions were put, what answers were given, and the signatures that were put there. So if you go through that confession, insofar as I went through it, my lord, I did not also get any impression that some rights were violated, insofar as the performer is concerned.
Mina ke ngibone ukuthi ngemva kokuthi umangalelwa aye kuKennel Mboto ekhulumile mase sekufika leli yaphepha ekuthi bekade elibhala, ngibone ukuthi akunamalungelo wakamangalelwa ekuthi wona ayiwanyathelwa la ukuthi umangalelwa mhlawumbe wenziswe into bekade engafuni ukuyenza, ngoba njengophoyisa eliphenya kuyicala ngiyengafunda konke obekade kukhulunywa kubhalwa ngabona nemibuzo ebekade ibuzwa. Futhi kubalekile ukuthi umuntu umbheke noma umbuze ukuthi lento afuna uyikhuluma ngenhliziyo yakhe ekhululekile, akaphoqwanga. Uthi nalokho ngikwenzile njengoba ngiyiphoyisa eliphenya kule licala.
The essence of this question, before I move on to something else, is that the version of accused number 1 says he was compelled to endorse a signature on a statement. He did not make a statement himself. And that when he endorsed the signature, you were not present.
Yes, I agree, my lord. Like I've said, what took place insofar as the formal taking of the statement, I was not there. So Colonel Mboto, I think, will be a better person to talk to those issues.
uthi ummangalelwa wokuqala uma etshela ummeli wakhe ukuthi yena uye waphoqwa ukuthi asayinde iphepha elithize eline statement futhi wena brigadier wawukade ungekho angisho uthi yebo engikade ngingekho nalokho uKenneth Mbotho ongeza ezochaza kabanzi ngalolu daba ummangalelwa okhuluma ngalo.
And in relation to the issue of being kept incommunicado, he was not afforded an opportunity to communicate with his family. He was kept in a single cell alone. Will you regard that as human enough to detain such a person?
So, my lord, I think I also dealt with this aspect last year, that during June 2020, the country was under COVID lockdown. It was a regulation which, if you violate, you could be charged to maintain a safe, distance between parties. And I did mention, my lord, that depending on the facilities that each police station will have, they will decide as to how many inmates they will incarcerate per cell. We, as the investigation team, did not have influence, detection as to who must be incarcerated where. Ours is to hand the person in, sign the handing over of that person, they receive that person, they place that person according to the category of the charges he's facing, and as they deem fit according to their regulation. That is the first part, madam. But the second part, which says he did not speak to his family, I don't think it's true, because on the first appearance in Tembisa, he was legally represented by legal aid. Subsequent to that, his family hired a private attorney who represented him in that matter and eventually came to Phosphorus when we charged him in Phosphorus court. So he was able to make those calls and communicate with his family, and hence private attorneys were activated.
Umeli uchaza lelo daba lokuthi wena Sibiya uye wavalelwa ngendlela ebekade ingekho emthethweni la ukuthi awuzange unikwe nethuba lokuthi uxhumane nomndeni wakho futhi wawukade uvalelwe wedwa. Uyachaza ubrigadier ukuthi yebo ekuvalelweni yedwa bekungasithina abaphenyayo ngecala abatshele ipolice station ukuthi lo muntu akavalele yedwa. Uthi uma sikhumbula ngo-2020 ngoJune country yonke yayikade ikwi-lockdown la ukuthi abantu bekade bengamelanga ukuthi bagcwale la ukuthi i-police station yona iyona ebekade isho ukuthi kwamele kufakwe abantu abangakanani eselini elithize. Futhi lolu daba lokuthi wena bowungaxhumani nomndeni wakho uthi akaliboni kuyiqiniso ngoba uma uyovela phambi kwamantshi uye ubokade unommeli we-legal aid la ukuthi ngemva kwalokho wena umndeni wakho uyibekade ukhona futhi wakufunela nomunye ummeli okhokhelwayo, yingakho bona babona ukuthi wawukade uxhumana nommeli wakho njengoba wawukade uxhumana nomndeni wakho njengoba wawukade ukhona futhi bakufunela nommeli okhokhelwayo.
My lord, I'm not sure if it's convenient time to attend for lunch.
Yeah, you said you wanted to, pose some other questions.
It's only one question. The aspect.
No, you can do it any other time.
Yes.
Okay, so, but you want us to adjourn now?
For lunch.
Is that the consensus, Mr. Baloyi?
Indeed, it's time for the long agenda.
There's just one aspect this court is going to remark on. He keeps telling Mr. Mgumezulu that when so-called interfering, I only quoting the law. You see this process of saying when he agrees with you, you're both wrong. When you put it to him, Brigadier Gininda, that when you are speaking to your client, accused number one, and gleaned from number one that he wants to make a confession. That was an informal process. No, that's a constitutional process. It's not informal. Our law says an accused person must be apprised of his rights in terms of Section 35. So when this accused person, who is a lay person and doesn't know the law, says to you, when you speak to him, he wants to make a confession. When you engage him, that is his constitutional right, and that is a constitutional process. Okay,
May I tell?
that's the law.
Yes.
You and Gininda can agree on another law. That one I don't know.
My Lord, may I clarify it? The explanation of rights is something else.
No, fine.
I was talking about,
An informal process.
yes, like taking off a confession in terms of Section 217.
It's not informal, Mr. It's not. It's a constitutional requirement that before a person makes a confession, he must be apprised of his right. You can ask Mr. Am I correct? Mr. Nisi.
There's nothing informal.
Yes.
Things.
You see, and I keep quiet now. Hayi, the judge has umthetho. When I mention it, hayi, the judge interfere.
manje ke inkantolo ichaza ukuthi njengoba ummeli ethe ngalesikhathi ukhulumisana no brigadier leyo nto yakade ku inkulumo engekho emthethweni uthi cha inkulumo esemthethweni ngoba umthetho sekelo iconstitution iyachaza ukuthi umuntu mayefuna ukukhuluma leyo nto leyo ayikhulumayo ilungelo lakhe ekuthi lisemthethweni manje ngalesikhathi nikhuluma no brigadier bakade kuyilungelo lakho ekuthi lisemthethweni futhi libhalwe na kumthetho sekelo inkosi yenkantolo ithi yona ayigamkeli kule indaba ezikammeli wakho no brigadier Gininda futhi uyabuza nomnumzana umnisi ukuthi iqiniso na uthi yebo into esemthethweni ngoba ilungelo elikumthetho sekelo.
Okay, can you agenda then until 2 reasons?
20 in Carlton Bill. That was the first time I met him.
Ubufakazi bukammangalelo wesibini yena uthi ubrigadier wayekade ekhona lapha ePretoria nothi cha ngiyaphika lokho ngiqale ukumbona nge-18 zika June eCarltonville.
So accused number 2, when he was arrested on the 16th of June 2020, he was not arrested on the strength of a warrant of arrest or a J50 on the case of Nangoma under 163. Oh, is it 03?
04 2018.
2018, thank you.
That is correct, my lord. But Section 40 of the Criminal Procedure Act 51 of 1977 does make a provision for the police to arrest without a warrant of arrest if they have a reasonable suspicion, which I believe in this instance, as I was briefed by Sergeant Mohane, they did.
Mangalelo wesibini yena waboshwa ke eboshwa ngaleli yaqala liyasenongoma nangokho bengekho iphepha egunyazayo ukuthi aboshwe uthi yebo uyavumela umthetho sekelo ukuthi uma engabe amaphoyisa bona banokusola okuthize ukuthi lo muntu angahlabandakanyeke kwiqala elithize banegunya lokuthi bangambopha njengoba naye etshelwe uSergeant Mohane ukuthi bebakade besola lokho.
Yes, I will address the provisions of Section 41B relating to an arrest without a warrant. But what I want to put across to you is that accused number 2 was arrested because he is linked with a murder case in Gwanongo.
That is correct, my lord. He was arrested for the Nongoma case on the 16th of June.
Uthi yebo nge-16 zika June 2020 ummangalelo wesibini yena wayekade eboshelwa leli cala lakwaNongo.
Okay. So are you in possession of the docket?
The docket, yes, is available. It is available.
uthi yebo idocket uyiphethe.
Yes, it is available, my lord.
So in terms of the docket, does it state that it's a murder case?
Yes, it says murder in possession of unlicensed firearm outside murder.
Liyachaza na leli dokodo ukuthi likhuluma ngokubulawa komuntu uthi yebo lichaza ukubulawa komuntu nokuphatha inhlamvu ezingekho emthethweni.
Can maybe we have sight of the docket?
Yes, you can.
Have you
Oh, you mean outside? So
made the copies? Because we've been requesting to see the docket and
Okay, the docket is here, my lord. We can make copies, I suppose, when we are checking for the defense, but it is here. Here's the docket. So we can make copies for the defense if they need.
Has this gentleman appeared in court in respect of that docket?
This is not accused number 2.
Yeah.
No, it didn't, my lord. I
Does
know
the law
that-
allow that?
sir,
No, I just want to know from the brigadier, because here's a man is allegedly arrested for murder and possession, right?
Yes.
He has been charged.
Yes, my lord.
Has he appeared in court?
No, my lord. What happened is he was arrested on the 16th, then on the 19th, that's when he was taken to Fosora's court,
Okay, yeah.
where he was supposed to be placed and transferred
Okay.
to Wanongom, and that is where the decision not to enroll the matter was taken, my lord.
Okay.
That's that matter.
But the state doesn't, or at least you as senior police, you have no problem with making available the copies of all the documents in the docket,
Well, on
except
second,
the usual ones.
no. On second consideration, my lord, because the matter is not finalized insofar as the investigation is concerned, I think it might, because he's still going to be pursued together with others. And this docket is linked to about 3 other dockets. I think one would have to reconsider what I said, that we can make copies for them. It will defeat the purpose of the investigation, my lord.
It's all about me trying to know the law.
Thank you.
okay.
Inkosi yenkantolo iyabuza ukuthi uNtanzi uye wavela na kuleli cala lase Nongoma. Uyaphendula ubrigadier uthi cha akazavele enkantolo kulayo ukuthi kuye kwathathwa isinqumo sokuthi leli cala lingafakwa enkantolo. Manje ke inkosi yenkantolo iyabuza futhi nokuthi usaqhubeka uthi usafuna ukuthi ungabanika amakhophi walo lelo dokodo uthi cha ngiyawagwinya lawo mazwi ngicela ukuthi ngiwagcine ngoba lamadokodo le yaseNongoma ilandelwa amanye amadokodo amathathu ayikuthi umangalelwa wesibini usazolandelisiswa noma kusazophenywa ngawo lamadokodo lawa.
If this matter was not placed on record, is there any kind of documentation to prove that that matter was refused from the road?
Well, I do believe, my lord, what was I think the OBs and the entries from the court, I think was submitted to show that the accused went to court and the matter was not enrolled together with the drug dealing matter in Foster's on the 19th.
Yeah,
What-
but sorry. To refer to Mr. Mgomezulu, what do you want from this docket so that this court must assist you to have access to it if it pertains to the defense of your client about the admissibility or otherwise of the alleged confession the state alleges that your client made? Are you with me?
I'm with you, my lord.
Yeah, so that you can peruse it.
So before my lord, I can answer on that. May I ask one question from him, then I'll take it from there.
Okay.
Are there any persons mentioned in the docket who appeared in court?
There's 2 names here, my lord. It's Seliselani Buthelezi on top, and then number 2 is Ntanzi. Its surname is Ntanzi Bongane Sandile, which is accused number 2.
Kunabantu na ekukhulunywe ngabo kulelo dokodo uthi yebo babini kunoqiniselani
Yeah.
Qiniselani Buthelezi omunye ke bese kuba uyena uNtanzi.
Okay. Do you have the copy of the charge sheet?
No, I don't know.
uthi akanayo ikopi yale yancwadi ebekade ummangalelwa ethweswe amacala ngayo.
You said your matter is not finalized yet.
Yes, Sergeant Mokhane is still investigating the matter. The matter is still, Sergeant Mokhane is still investigating all this.
Alikaqedwa leli cala laseNongoma njengoba ukuthi uSergeant Mokhane yena usaphenya ngalo.
Sergeant Khane, was he the only one who was investigating on that matter?
It was assigned to him. Ever since the matter got to us, my lord, it was assigned to him. But as I said, in KZN, a certain defense investigating officer who was pursuing the first suspect at that time was the investigating officer. But this side, ever since it came, it's Sergeant Mokhane, my lord.
Manje kuyabuzwa ukuthi uyena yedwa na uSergeant Mokhane oyikuthi uphenya leli cala kuthiwa lani kwayena soloku lafika la kithi kodwa eKZN ukhona omunye oyikuthi naye ubekade ephenya kakhulukazi indaba le kamangalelwa wokuqala kuleli cala.
Completely. I don't waiting for the
Yeah,
instruction.
fine.
I remember there was evidence by Mr. Sergeant Mokhane to say he the instruction is that in that docket there were two accused persons, namely Thabani Ngwenya and Piniselani Buthelezi. And that matter was finalized. Do you have something to say?
My lord, I agree. The matter in KZN was finalized. The investigation insofar as accused to is not finalized. And this is what Sergeant Mokhane was basing on.
Uthi ke ummeli yena utshelwa ukuthi kuleli cala lakwaNongoma bekade kunamamangalelwa ababini uThabani Ngwenya noQiniselani Buthelezi eyikuthi lelo cala lelo laqulwa uthi ke ubrigadier yebo kwakade kunabamangalelwa ababini uphenyo lwaphela.
All right.
With the conviction for Mr. Buthelezi, my lord. Buthelezi is the individual that I said we have approached based on the collaboration of the confession that we got from accused number 1. And the statement for this Buthelezi is in this docket 636 and has been disclosed to the defense. That is the accused that is charged with Mr. Buthelezi.
Buthelezi loyo okukhulunywa ngaye kuleli cala uye wayiwa kuye futhi wenze istatement leso statement leso sikhona kwidokodo lelika 636 ileli elalecala leli esilikhulumayo namuhla uthi futhi leso statement sanikwa nabameli.
All right, let's just put things into practical perspective. The matter was finalized and the verdict, was it a guilty verdict?
Yes, for Mr. Buthelezi it was a guilty verdict with a direct imprisonment.
Manje uthini uthi lelo cala laqulwa kwaba nesinqumo kwaba nesahlulelo uthi yebo uButhelezi watholwa enecala futhi wathunyelwa ejele.
What happened to the murder charge in respect of Buthelezi?
There's a guilty verdict, my lord. I didn't, as I said, I've assigned this matter to the IO. I'm simply talking, the cosmetic part, but obviously there was a finding, and it's a guilty verdict with a direct imprisonment.
Yeah, but it's for murder.
I think it is for murder because the sentence, it's my lord, I don't want to perhaps say the wrong thing. One will have to go and maybe get the sentence so that I don't say what is.
But it should be annotated on the docket.
No, it's not written, my lord.
It's on the other one.
Yes. It's
Where
on
is the
other
other one? That is the one of Nongoma, which is allegedly finalized.
What we have in there, my lord, it's what was in the docket of Nongoma, because subsequent to the adjournment, I even made arrangement that we speak to the IO, and what we have, because we wanted to see those issues of the sentencing that would have occurred when we are here. There's nothing that they have except this. What I know that is available is the sentence, which is on the system that we can draw, and then we can make it available, my lord.
It will say sentence for murder, guilty of murder, sentenced to such and such a period.
Correct, my lord. That's what it will say. Or whatever charge they've convicted them on.
Yeah,
that,
fine,
that,
yeah.
that we can get, my lord.
So this matter is coming from 2018.
That's correct, my lord.
Manje ke kulo lelicala laseNongoma utheni uthe kunesigwebo esakhishwa futhi bekade kuyisigwebo na sokubulala uthi yebo kwakhishwa isigwebo kodwa angifuni ukuthi okwamanje ngisho ukuthi lo muntu wagwetshwa iminyaka emingaki ngoba nginaso isiqiniseko kodwa kwisystem isikhona singakwazi ukuthi sisidonse bese sikwazi ukutshela inkantolo ukuthi lo muntu wagwetshwa iminyaka emingaki futhi ke uma eqhubeka ubaba uButhelezi ubaba uMngomezulu uma ubuza futhi nokuthi lo muntu loyo yena ngempela ugwetshiwe uthi yebo ugwetshiwe kuleli yaqala laseNongoma.
From the 19th of June 2020, I can see this matter is coming from 2018. Accused is arrested on the 16th of June 2020. On the 19th, the matter is removed from the roll. What steps was taken after the 19th to secure the attendance of accused number 2 to Nongoma court?
My lord, so as I've said, the IO was Sergeant Mohane, but then secondly, on the 19th, then the case of possession of unlicensed ammunition kicked in. That's the first part, which was in the Northwest Province. Now, if one had to, and I'm not talking in defense of Sergeant Mohane, but if one had now to pursue this, my lord, in terms of placing it, investigations were conducted collectively. They didn't stop. But if one had to singly focus on this case, it would have meant that the accused would have been placed in KZN. Then he would have had to move from KZN to Northwest and subsequently to Gauteng, which was a risk factor. So the approach was that all these matters, when we now had him on the Bokeng matter, must be investigated, completed, presented to the DPP, so that as and when the decision is taken, collectively the centralization point is made to avoid risk factor and the cost factor, because we would have had this matter, the Northwest matter, there's another matter of Rustenburg where the details were disclosed to the court, then KZN. It would have been a mess, my lord. We knew where the accused was, he was in custody, so the view was that Sergeant, investigate, complete everything, let's have it centralized, presented to the DP and get a central point where all these matters will appear.
Manje ke leli cala leli kube siye sathatha icala ngecala bekuzofuneka ukuthi ummangalelwa agcine seyikuthi uyovela enkantolo kwaNongoma avele ePhukeni abuye azovela futhi nala eGauteng la ukuthi lokho bekade kuzoba into eyikuthi bezosifaka esimeni esibucayi ngoba bekwamele simsuse kuzo zonke le indawo ingakho siye sanika usajeni umsebenzi wokuthi akaye ayophenya wonke lamaqala ukuthi uma sesesiwanika kumphathi wabashushisi akwazi ukuthatha isinqumo bese sikwazi ukuthi simbeke endaweni ebekade izovumela ukuthi zonke lezi indawo zibe eduze noma akwazi ukufinyeleleka ummangaleli.
Okay, I'll get into the particulars of the accused person and the verdict thereof. My concern is we knew that accused number 2, since he was arrested on the 16th of June, this year is 2024, accused person has never appeared in that court under the case now.
It was not enrolled, my lord. Like I said, it was never enrolled. You agree, but people are placed when the matter is accepted by NPA. When you place them, then you can transfer them. So it was not enrolled. That's my understanding, my lord.
Objection, my lord.
Yes.
My lord, there is evidence that was led in this court regarding this docket. There is, I'll double check the number of the exhibit, my lord. It was a computer printout of this docket reflecting another information. And then today, my lord, the evidence or reference is being made to the same docket. And the witness is testifying on the content of this document which is in front of the witness. My lord, as a result of that, I submit that as the defense were entitled to the disclosure of the docket in which the witness is making reference to. And even in the evidence of Sergeant Mohane, my lord, if I'm not mistaken, reference as to this, regarding this docket, was made that was the basis for the arrest of accused number 2. As a result of that, my lord, I submit and I ask with the leave of the court that this docket should be disclosed to the defense so that we can be able to verify what the witness is testifying about right now.
Yeah, I said so. I said, to be fair to Mr. Mngomezulu, if this docket or his instructions are that there is a link, this docket can be utilized for the defense of his clients in the trial.
Yes.
This court can authorize that you must have access to the dockets,
Yes.
so that the defense of your clients is not impinged upon. That's what I said.
Thank you, my lord. I'm asking for that permission, my lord. That's the court business, my lord.
Mr. Baloyi, what said you?
Yes.
I had a quick look at Exhibit WW. It contains the list of those confidential cases that Sergeant Mohane requested.
Yeah,
that they
it was
should not be
disclosed that
disclosed.
confidential cases, you remember?
Yes, but this docket doesn't feature, on that list. I think it's something we can sort out between
There are 4 dockets, Mr.
ourselves and the defense.
Yes, ma'am.
Yes, ma'am.
There are 4 dockets.
Yes, ma'am.
Give them to this witness, to the counsels here.
That's the court business, my lord.
And go and show these dockets to your clients, like what happened with the confidential information, which I said it's only for the eyes of the defense and the court.
That's the court business, my lord. We want.
So you want us to adjourn and you want to see them,
That's the
or
court business.
you want to do what?
We're asking for the adjournment, my lord, because the witness is continuing to go deep.
Inkosi yenkantolo ithi yebo lokho kuyavumeleka. Enye into esemqoka inkosi yenkantolo ivezile ukuthi abameli banganibonisi lamadokodo njengaleli yaphepha ekuthi liye lavezwa nyakenye leli ke kwachazwa ngalo. Manje ke inkosi yenkantolo ithi bawabheke lamadokodo manje la bangahambi nawo emakhaya.
Okay. You are available tomorrow?
Yes, I am, my lord.
Okay, let's adjourn now. What's the time now?
It's 14:13.
Yeah, so that you can take instructions if you glean any information which affects the defense of your clients in the trial.
Thank you.
Okay, so we adjourn for the perusal of the 4 dockets by the
Sizigcina
council.
la namhlanje ukuthi abameli bayobona lamadokodo sizobuya futhi kusasa.
Okay.
In Carlton Bill. That was the first time I met him.
Yes, quite.
In fact, the court remarked that they may not be taken home.
Yeah.
However, the defense were of the view that the court order can be interpreted in such a way that that copies can be made of those dockets, and we therefore could not reach
Those are privileged documents, are they not?
an agreement yesterday. Indeed, my lord.
And if you know your law, those are privileged documents.
Yes.
The state, the accused are not entitled to those documents as a matter of right. If you read State versus Chabalala
Yes.
in the Constitutional Court, it tells you that that is part of what C of the docket.
Well, it's in our view, it's additional information.
Yeah, fine. But the point is,
They are not really.
they are not yet charged
Yes.
in the technical sense. The
Indeed.
matter was supposed to be enrolled And the prosecutor in Post Luras
Yes,
came with a new version of the law that
yes,
he doesn't have jurisdiction,
yes,
which is not correct.
yes.
And the charges were never laid, in other words.
Indeed, they accused.
And then, as
never
Mr.
appeared in court.
Brigadier says, they decided that they should investigate all those dockets, 4 of them. And thereafter, because they are situated in different parts of the country, they must apply for consolidation.
Indeed, my lord. And
What
again,
section is that? Consolidation.
it's centralization,
Centralization and Mr.
of the charges.
Yes. So you can charge a guy having killed a person in Cape Town, and then he goes to so-called the border of Mozambique and South Africa,
Yes,
and then you consolidate those cases. The cases handled here in Pretoria,
yes,
because the Supreme Court is the Supreme Court or the High Court of South Africa. If you read, there's nothing like the High Court of Gauteng. It's the High Court of South Africa with subdivisions in Gauteng, Northwest, Cape, KwaZulu, KwaZulu-Natal, whatever.
yes.
But it's one court in essence.
Indeed, my lord. And we've already seen in Exhibit B that that there was centralization of the charges in this matter.
Yeah.
And we again this morning listened to the recording, and that's precisely what the court said, my lord. The stance of the state is exactly in line with what the court ordered yesterday.
Yeah, but I made an order that they must be read in court. Is that not so?
Yes, indeed, my lord.
Yeah, so what's the problem? Mr. Ngomezulu, what is the problem with the order?
God praises, my lord. My lord, the defense and the state, after we adjourned 2:30, we went to the office of my colleague, Mr. Baloyi,
Yeah.
with the purpose of obtaining such copies. So it came this morning that there is a dispute regarding that. But yes, the whole of afternoon yesterday, there was no such a dispute. But in relation to, if I can take the court back to the request that we made during the evidence of Mr. Mkhani, Sergeant Mkhani,
Yeah.
the court made an order that we should have access to the docket.
Yes, of course, yeah.
And there
But
was a
not copy anything. That's why I said it must happen in this court. Because the last time you remember what happened.
I remember what
Yeah,
happened, my
the
lord.
order was taken and shown to our clients. That's why I said the rider is, it must not even taken to my sitting room.
My lord, all emanated from dockets 163. But now the state is alleging serious allegations against the accused.
Where?
And in terms of State versus Shabalala, he was supposed to disclose such information for a purpose of consultation.
Which one? Which information is that?
I mean, regarding the alleged or pending matter of murder,
In the Nongoma case?
the Nongoma case.
No, State versus Chabalala is not applicable. Please.
That's what was
State versus Chabalala is applicable to a case which is going to be heard at a particular time, where the indictment is drawn and where the clients, your clients have pleaded. Then you give, as a matter of constitutional right, in terms of State versus Chabalala, then the state is obliged, they have no choice, to give you all the contents of the docket, which they are going to use, except, of course, classified information.
My lord,
But this is not applicable to Nongoma. I said I'm making the order in fairness to you because there is a possibility that you may want to glean information which affects the admissibility and otherwise of the confession, and you want to raise certain issues.
but my submission, my lord, is that when the court remembers, every time the state is disclosing new evidence during the course of the trial, within the trial, was furnishing us with the contents, of which such contents, most of them, were not discovered during the trial. In
Yeah.
this case, the issue of 163 started during during trial within the trial. So why is the state at this stage reluctant if during the course of it was, we even call it ambush discovery? Why are they not open before this honorable court and give us the content so that we go through?
No, but Mr. Advocate Ngomezulu,
Yes,
the state has been ordered to hand over the dockets to you guys.
yes.
The proviso is that they must be read by you in this court. You can read it to page 1 to page 100, no problem. But you are not allowed to make copies of those.
Court,
That's the order. It's a simple order.
That has not been done.
And I never said you can't make notes, but you can't make copies.
Court, please.
So that is the order.
Njengoba izolo masisaqala inkantolo yayithe abameli bethu baboniswe namadokodo lawa ekuthi umkilindo uphuma ngawo. Manje izolo bekwamele afundwe lawo madokodo kodwa kungayenzwa amakhophi. Manje kunokungazwani phakathi komshushisi nabameli benu bona ingathi bebafuna ukuthi bathole yonke into ujaji uthi bona banelungelo yokuthi bangafunda yonke kodwa bangatholi amakhophi okwamanje ngenxa yokuthi lamadokodo inawakhuluma ngokontanzi ukuthi kunamanye amacala ayikuthi mhlawumbe bangagcina sekuthi bamphesa wona okwamanje akakathweswa lawo macala yingakho ukuthi akwamenanga ukuthi kukhishwe amakhophi kodwa ukufunda nokwenza ama-notes abameli benu banalelo lungelo lokuthi bangabhala ukuthi mhlawumbe nanoma ubrigadier ekhuluma ephana ngokufaka bese bakwazi ukubuza ngalento eyikuthi nabo bayibonile.
And I'm saying this because there's evidence here through Sergeant Bokhano that he doesn't know you, Mr. Ngomezulu, and your attorney. He doesn't know how you acquired that information which is confidential to the police. Do you remember that?
Yes, exhibit review.
Yeah, you remember. The investigating officer in that matter, he says he doesn't know how you gained access. You are not to blame, your attorney. He doesn't know how your attorney gained access to that confidential information. It was not officially acquired because according to Mokhano, if it was, he has to authorize it. So it's not just a simple thing like.
Ngoba inkantolo ikhulumisa nisakhumbula nyakenye kunelinye iphepha ekuthi liye laphuma nathi nanani senibonile. Ithi inkosi yenkantolo uSargeant Umkhani uye wathi akazi ukuthi ubabu Ramsipili uyithole kanjani lawo maphepha ngaphambi kokuthi azokhishwa nakini ngoba lawo maphepha lawo bekwamaphepha ayikuthi abhalelwe akwamelanga ukuthi abonwe yiwonke umuntu ingakho nawo lawa inkosi yenkantolo ithi akwamelanga ukuthi kwenziwe amakhophi azobonwa yiwonke umuntu ingakho efuna ukuvikela lamadokodo.
And if you remember, Mokhano said his job and deliberations are governed by the Official Secrets Act. Did he say that? I mean, he said that. That's why I'm making such an order. Remember, there's a...
As the court pleases, my lord, my lord will be given an opportunity to make our submissions also on this issue.
Which one is that now?
This issue of that you are dealing with the copies of dockets.
No, I've made an order, Ms. Mchololo. Dockets will be read in court.
As the court pleases.
What submissions do you want to make? So have you read the dockets?
No, my
How
lord.
long do you need? 3 weeks? 2 months?
We have not yet received them.
Hello?
We have not yet received them.
Yeah, because he says you said you wanted to make copies. Where are the dockets?
They are available, Manot. They are with Brigadier Gilindi.
Where's Brigadier Gilindi? Hey, yeah.
Lamadokodo abakwazanga ukufunda izolo njengoba babadala impikiswano kodwa akhona akubrigadier naye angathe wakhipha ukuthi abameli bakwazi ukuwafunda.
So how long do you need? Because yesterday you had about two and a half hours. How long do you need?
I think we don't even know how many pages are there and what.
I saw those documents, they're thin. I was looking at them.
They are thin, madam.
Yeah, thin. Thin. I was looking at them. How long do you take to read 100 pages?
I can't confirm their thickness or their thinness. But I think we need to be at first with the docket, because it's not only reading them, it's to read and analyze them at the same time.
If I may
10
say,
minutes break, madam, then we come back to the book and indicate how long can we take to peruse them.
indeed, that was going to be the suggestion, that we adjourn for 10 minutes, then we assess the dockets and see how long.
Where are the dockets? I want to see them.
Yeah.
Because I saw them yesterday.
Yes. They are with the Brigadier Guinina Malot. He's just parking outside.
He's parking.
Yes, I'm told he's just making his way to court.
Oh, I see.
I think he was delayed along the way. So,
uyeza ubrigadier ubekade enento esambambile kodwa uyeza yangena amadlela
we request that we adjourn at least for 10 minutes, Malot.
No, I'll adjourn after he comes. I want to have a look at the thickness. I saw thin dockets.
As a good business.
inkosi enkantolo ithi izomlinda aze afike bese-ke kula izothatha isinqumo ukuthi isikhathi esingakanani elimisa ukuthi ababili bakwazi ukubona lawo madoda.
As soon as he's here, Malot, we'll let the court know. Maybe the court can just wait in the corridor.
Yeah, I'm comfortable if I'm seated here. You should get out and leave me alone if you're uncomfortable. If you need the whole day, you'll get the whole day. But the proviso, as I say, is you read them here in the presence of the prosecutor. Because I remember I once handled a case of a certain police general. He was charged with whatever. Was amongst the charges was allegations of fraud and what have you. And what happened is they just used the Official Secrets Act to classify the documents. I don't know if you were in that group of prosecutors. And the prosecutor decided they can't go on because about that charge because
The documents need to be declassified first.
yeah. But who says the court can't do it? Because you've got to explain why you classify them. I'm charged with killing a person, then I classify the post-mortem report. That's how nonsensical sometimes the classification is being abused in this country. Are you aware of that?
Yes, possibly.
Somebody just classify
There are such instances.
the post-mortem report, and as a result you can't prove why this guy was, what is the reason for his death or her death.
Yes.
It's classified.
Yes. Even the instance that the court alluded to of fraud, I mean, it's nothing secretive about
No.
documents that are in the docket. But most probably it relates to tender procedures,
Yes,
procurement procedures, and all those things.
that's it. And those documents were classified. And the joke is, when another head of intelligence was appointed, he immediately declassified those documents. and the charges were reinstated. You remember Sergeant Khumalo said after the disclosure of that document that he now fears for the life of his witnesses.
Indeed, my lord, and that is the main reason why.
Yes, you remember, he said, I thought me saying that. He says, now I fear for the life of the witnesses.
Yes.
But you see, court officers are court officers before they are attorneys or advocates of their own clients. They take an oath to uphold the law and the constitution of the country. So if the case has not been fully investigated, they know the consequences.
Yes.
And then you have access to the docket. The matter is not fully investigated or finalized, being investigated. But here there are special circumstances which make this court to say they can peruse the docket, because it may be Mr. Gomezulu and others, they want to use the contents of the docket in disproving the allegations against their clients. I don't know.
And indeed, my lord, the state wants to meet the defense halfway, but there's a serious concern that if copies are made of those dockets, that might spell the end of the investigation in those matters. So there's really a serious concern here.
Yeah. But under apartheid, I can tell you, the judges of old, they had so much power. They could ask, why do you want to use the docket, Mr. Gomezulu? And you say, hey. And then the judge reads the docket alone, not with you. Doesn't even make the docket available to you. And then he tells you, I've read the docket, this exigency we're dealing with, I don't think you need this information. There was no accountability then. Then the judge, he makes that ruling. Then he doesn't think it's relevant. It's relevant. You can take him on review and appeal, fine.
That's the reason for that doctrine, Sesanto Ratone Leges case at Ipselex. Yeah. If the reason of the law ceases to exist, the law must fall away. So on the introduction of the Constitution, that that law had to fall away, not by privilege or by choice.
Yeah, no, I say the law has changed.
That's correct.
Yeah. But when we were practicing, the judge could even determine what evidence should be led in the interests of the security of the state. Hello?
The attorneys back then challenged it because the court once asked me whether I challenged the lawfulness of the arrest of 1 and 2. So that Security Act, did the judge challenge it?
Hey. Yeah, some of us try to challenge all those, but the judge, because the judges had such a wide discretion, they would listen to you, and after that make a ruling. But now you are entitled in terms of the Constitution to challenge anything and everything. I'm level.
I think the current position is that there must always be a connection between the exercise of power and the rationale for for such exercise of power. There's that balancing act currently.
The Administrative Act. What's Act 60? What's the section? There must be a rational basis for the decision which a judge takes, or any person who exercises public power.
Yes.
Is that not the law?
Yes, indeed.
Yeah, it must be based on rationality. And that was developed after the 1960, is it 60? No, sorry, 1966, the Constitution? The first
1996,
1996, so the first Constitution.
Yes.
Yeah, administrative law was developed then.
Yes.
But before then, it was just difficult.
Indeed, my lord. I wonder if we should not take the adjournment. I wonder what the hold-up is.
Okay, let's adjourn. You'll call me. Yes, quite.
In fact, the court warrant of arrest. Have you seen that?
I've seen when I was basically perusing the docket, my lord, but like I said, this is not my matter. The matter is assigned to Sergeant Mukhane, and then in case it is investigated by other people. But yes, I've seen a statement that seems to talk to that, my lord.
Ubonile na ukuthi uqiniselane Buthelezi yena ubekade eboshwe ngemva kokuthi kuye kwakhishwa noma kwatholwa incwadi egunyazwa ukuthi aboshwe. Uthi lokho ngikubonile kodwa akulona icala emina bengisebenza kulo. And
I'm saying this, my lord, because I don't want to speculate or state certain things on those matters as a fact when I was not privy to. I can talk to 636 because I'm directly involved. Here, I just came with the docket because I was asked to. So I can assist the court as much as I can, my lord, but I can't commit on certain aspects that I'm really not 100% privy to.
Izinto ekuthi lezo ngizibonile ingakho ngafuna ukuqagela ngikhulume izinto engazazi mina ngifuna ukusiza inkantolo ngakho konke engingakwazi ukuthi ngiyisize ngakho.
But Mr. Kinenda, there's one problem I have in relation to the evidence of Sergeant Mukhane. When we confronted him with the information relating to case number 163, he kept on saying everything is with Brigadier Kinenda. The docket is with Brigadier Kinenda, to the extent that he failed to secure the docket until he concluded his. Who must we rely on between you and the evidence of Sergeant Mukhane?
My lord, I can say before Sergeant Mukhane concluded, I think on the last day, the docket was found, before his evidence was concluded, and I spoke to Advocate Baloyi about it. It is true, my lord, that he had difficulty in accessing where the docket was kept with other dockets in the safe. There was difficulty in terms of locating, because during that time, the person, if I recall, was in possession of that key, was not around. They've undergone investigation out of the province. That was the challenge, not that the docket was with me personally. No, it wasn't with me, my lord.
Manje phakathi kwakho no Sergeant Mukhane sikholwe bani ngoba ngalesikhathi ela ubekade ethi akakwazi ukuthola idokodo ngoba likuwe. Manje ubrigadier uphendula uthi uyakhumbula ukuthi ngaphambi kokuthi uSergeant Mukhane aqede ubufakazi bakhe lilatholakala idokodo ngoba ngalesikhathi elibele phana ngobufakazi umuntu obekade ephethe iskhiya salapho sala amadokeda ahlala khona bekade engekho ingakho ekade ehlupheka ukuthi atholele le dokodo.
I'm putting to you that after perusal of the docket, there's nothing, absolutely nothing, directly or indirectly, that links accused number 2 with the murder case.
The statement, my lord, the statement mentioned his name. It implicates him, and Sergeant Mukhane also disposed the affidavit. A warning statement was taken from accused 2. I can take it insofar as that. If counsel then wants to question the extent of the evidence, I think the IO will be a better person to take it further, my lord.
Ngiyakutshela ngiyakwazisa futhi nokuthi mangiqeda ukufunda leli yadokodo ayikho into ebandakanisa untanzi naleli dokodo lakwaNongoma. Uma ephendula ubrigadier uthi istatement siyasho futhi siphinda sichaze negama likaNtanzi nokuthi wenzeni. Uma engabe ummeli angafuna ukuthi lelo daba alibuze futhi azalibuze futhi angase usajeni loyano yenze istatement nalabo abanye angakwazi ukuthi nabo ababuze, kodwa ubrigadier uthi yena ufakaza ngalokho akubona manje.
Thank you. Brigadier, the matter has been finalized in Pietermaritzburg High Court. Was there any application for separation of trials if there were more than one accused persons?
No, not from us. Like I said, my lord, it's a number of dockets. I know that insofar as accused 2, a counsel has seen the statement. He would have seen that there are a number of names mentioned there. It's not only him, and I don't want to go there unless I'm asked, my lord. And they are mentioned in relation to a number of dockets that were committed in different places, different provinces. Those dockets, some of them and most of them were collected dockets. Those that were sub judice copies were collected at the time, and then later, not to disturb those proceedings, originally were collected. And we're of the view, my lord, because of security reason, safety reason, the magnitude of the perpetrators or suspects that were involved there, that we should rather try and conclude the investigation, present the docket to the DPP for centralization, so that when you move on one jurisdiction, because otherwise you would have had a situation where, for example, accused number 1 is taken all over the country, my lord. By so doing, beside the cost implication, there's a risk factor, because the crimes involved are very, very serious and dangerous cases involved. We're talking about premeditated murders, firearms being involved, small firearms, ammunition, high-profile individuals being assassinated across the country. It's not an easy situation where you can just separate. There's a risk factor that needed to be considered.
Manje njengoba kunommangalelo oyedwa oye wakwetshwa kuye kwaba mhlawumbe nesicelo sokuthi lamacala ahlukaniswe uthi ubrigadier cha ngoba leli cala ukuthi kunabantu abaningi ababandakanyekayo kulo leli cala. Akusuntanzi yedwa, maningi amagama akhulunyiwe akafune kwasho ngaphandle kokuthi inkosi yenkantolo ingathi awasho lawo magama, ngoba abantu abaningi futhi amacala ambalwa noma amaningi ayekuthi ayenzekile eindaweni ezihlukile. Ingakho ukuthi akuzange kuthiwa lo muntu uNtanzi aze ahlanganiswe kuwo wonke lamacala, ngoba bekwamele ukuthi asuswe endaweni kusuka kule ndawo aye kwenye indawo lokho kwamele kuvikelwe futhi abantu naye avikelwe, ngoba kungamacala amaningi ahlanganisa ibhamu nezinhlamvu ukuthi zikhona kuwo lawo macala la.
Mr. Brigadier Gininda, let me just be honest to you to say there's only one statement under 163 which mentions the name of Bongani Ntanzi, and that single statement is attached to 3 other different dockets, and it relates to the merits on 163. I'm not sure whether you made copies and attached to other dockets that does not relate with other cases, but the subject of what I'm concerned about is that there's only one statement by Simpiwe Buthelezi who only talks about something overhead.
I don't agree. That's not my understanding of what the statement says, my lord. It's not something that he overheard. That's the first part. Then the second part, in that statement, he talks about various issues. He mentions issues of murder. He mentions issues of hits in the taxi-related environment. He mentions issues of firearms. And that is why those statements, and in the warning statement, my lord, when accused 2 was questioned, he was questioned in relation to different cases. Those cases are mentioned in the warning statement. Counsel have seen them. So that is why the statements relate to different matters. It was made by one person, but it implicates accused 2 with other people on various different matters, including the 163 docket.
Chike ummeli yena uma ebuka kune statement esodwa ukuthi sikhuluma ngoNtanzi, kodwa leso statement sifakwe kumadokodo ahlukile. Ubrigadier uma iphendula uthi uyala leso statement akusona statement esifanayo kulamadokodo. Statement ukuthi lo muntu wakaButhelezi ushilo ukuthi kwenzakeleni futhi amacala ahlukile uhlanganisa amacala wokubulala amacala weyibhamu amacala weyinhlamvu amacala ahlukile ukuthi uButhelezi ukhulume ngawo ingakho istatement zihlukile and your my lord the accused is raising his hand.
Tell me, you are saying, I mean, you are senior people. You are saying Simpiwe Buthelezi, that's the deponent.
That's correct, my lord.
You say he links, his statement links the accused with several cases,
Correct, my lord.
including firearms, ammunition, etc.
Correct, my lord.
And now Mr. Gomez says, no, that is not so.
My lord, it is so because not
Where's the statement?
it is here, my lord.
Just read it. Yes. Because I can't have two officers of the court. You're a senior officer.
My lord, can I make a request? The statement is here, and in this statement, I wanted to say the part that he also mentions this case.
May I mention it? Because
Yes. Now, my
you have
concern.
two people reading the same statement and giving it a different interpretation. So I want to hear.
Yes. My lord, can I make a request?
Yes.
Just a quick request. In this statement, I don't know, the court can just advise. There are names mentioned here of witnesses which are known to this accused, because this statement does not only involve accused two. I didn't want to mention the other accused. And this is the part that...
No, just read that statement with everybody there, every name there. Jesus.
Manje kune statement ukuthi wena ukhuluma ngaso ummeli naye ukhuluma ngaso ukuthi nobabini ningabantu ukuthi niphethe ikhundla eziphezulu nikhuluma ngestatement ingathi azifani manje inkosi enkantolo ithi funda.
And whose statement is that? Is that
yonke into
the
ebhalwe
deponent there? What's his name?
It's Simpiwe Buthelezi, my lord.
Mr. Gomez, are you referring to that?
That's
deponent?
correct. That's correct.
Okay, just read the statement so that we
funda
all know.
statement lisika Buthelezi.
Objection per se.
Who's that?
It's not an objection.
So what is it per se?
It's just a concern that I have in view of the order that the court gave me. When you remember, the court said in the interest of priviness or in the
Yeah, I said that.
secrecy, the information that is contained in the document should not actually be revealed.
Yes, I said that. But what do you do, Mr. Mnisi, when you have two senior advocate, a brigadier,
Yes.
they read the same statement
Yes.
and they're telling this court different things?
I think there's a way in which that can be resolved.
No, me, I don't want secrets. Just read it.
Thank you.
Yeah.
Manje inkantolo ithi afunde namagama walabantu akhulunywe kule statement nangokho bekwamele ubrigadier bekathi ucela ukuthi angafundwa inkosi yenkantolo ithi afunde asho nalawo magama wabantu uyafunda ubrigadier.
I, Simpiwe Buthelezi, state under oath in English. I am an adult male born on the 5th of March 1974, residing in Kwanongoma, KwaZulu Natal, and currently unemployed and no contact number at the moment. I know Qiniselani Buthelezi and know known Mkhwanazi from the same area, or known him as Mkhwanazi from the same area in Mahlabatini village in Nongoma, where we both grew up. He is a known hitman around Natal and Johannesburg. Qiniselani has committed many crimes such as murder, possession of different caliber of firearms. Some of the firearms that Qiniselani used in killing people are supplied to him by a well-known gun supplier by the name of Bongani Mafika Ntanzi, who also comes from Nongoma area. Ntanzi Mafika is a very quiet gentleman and no one cannot suspect him. He is a firearm supplier and ammunition. Bongani Mafika Ntanzi is working in TA6 MT Carltonville, where he is operating from together You, my lord, I'm struggling, so I'll try to read, make sense of what I'm reading. From together with brother, operating from together, I can't see, with brothers, operating together with Basotho nationals. Is working together and operating with Basotho national. They supply the hitmen and others kind of firearms and ammunition around the country, and somehow here the firearms or sometimes hire firearms to hitmen. Kiniselani Buthelezi is a very connected person, and some of his case are thrown out of court when he is arrested. Kiniselani, who sometimes hire people to help with bribe the police and the prosecutors and etc. and then the magistrate, and he even bragged that around November 2012 he kept, I can't see this much, but he kept possession of, or he was found in possession of an AK-47 and ammunition, and was the court will bear with me. It's handwriting issue. He further told that the firearm was Bongani's Tanzi, Mafika Tanzi, and he further told me that the AK-47 was one used to rob ShopRite in Fosteras by Bongani Tanzi and another man by the name of Nkani Ntuli and other unknown people to him. Policemen were shot. Around January 2014, I decided to move from Nongoma to stay in Mazulu Hostel in Fosteras to try and make a living for myself. So was I can so that I can make mine. I suppose that's what I wanted to say, my lord. And I stayed working as at a taxi rank, marshal car and minibus. Sure. And the driver with I know approach by the name of taxi drivers. Sure, my lord, God, you'll just have to bear with me. This for a gun to possess the firearm. And so it seems, my lord, he says he was approached by somebody at the taxi rank, taxi driver looking for a gun, or he was approached by a taxi driver looking for a gun to protect himself, and he specifically said he want a hot firearm, mentioning unlicensed one known as a pistol. I immediately contacted Kiliselani to hook me up with Mafika Ntanzi. He now stays, who now stays in Johannesburg. Mafika Ntanzi brought a 9mm pistol, and I took it to the taxi driver, and a 9mm myself. Then he received cash for the said transaction and ammunition, because the middleman of the firearm and ammunition, as a middleman of the firearm and ammunition, I was, sure, my lord, my sincere apology. This handwriting is difficult for me sometimes. Bongani Ntanzi used two firearms in Fosora's house and surroundings, and had some secret meetings at the hostel with other people and share, I can't say what he said, or share certain things with me, or share certain things with me, and I am talking about June 2014. There was a time around October 2014 where we used to hang out around with the hostel from home in Wanongoma by the name of Carlos. There was a time in 2014 where I used to hang out with the homies from Wanongoma, and the name of those people, my lord, seems to be Carlos, Mapisa, Nkani, Muzi, in a room where Kwabeni resides. Kwabeni is also from Wanongoma. Around November 2014, Bongani Ntanzi started to give me attention. He was always visiting me and sometimes bring firearm to see to people, to show to people. I also noticed that he was not the same Bongane I know. He became distant and not talk like before. And when I asked him, he said something is waking him, but I must not worry. He is sorry. He will solve it. We continue selling firearms to Keniselani and other people, especially in KwaZulu Natal, because there is a high demand of unlicensed firearm and ammunition. There was a time where Ntanzi Mafiga worked from Carltonville to Rustenburg. He found a better job in the MTE, and he still continued supplying firearms and ammunition. There was a time around the year 2017 where Bongane sold a 9mm pistol with ammunition to Keniselani. That pistol had a special name and made Keniselani to have power and bragging that he is carrying a very Payson, I don't know what it means, my lord, Payson pistol with a special hand, something special handmade, my love, and it was where it fostered us. I don't know where Bongane Mafika Ntanzi got this firearm from, and he didn't want to show me his supplier. Bongane Ntanzi was staying in Rustenburg and making money securing firearms, and I also heard from Keniselani that Bongane is now making more money in that province. He also supplies more firearms in Marikana, and is understanding where I am involved. Bongane Mafika Ntanzi invited me to visit him in Rustenburg at Pukeng, and he told Coach will go with me, my lord. The handwriting of the person who took the statement is just a bit difficult. Where he kept there and overheard him talking on the phone with Mapisa, or invited me to visit him in Carltonville in Rustenburg, where I overheard him talking on the phone with Mapisa that they did a good job by killing a union member in Marikana. and Mapisa must make sure that Kwabeni pay them the money because he did not want to be, he must pay the money because he did not want to be traced. Well, must make sure he must pay them the money because he did not want to be traced with bank accounts. I heard that the person that was killed is a big person and very powerful, and I asked him, is he also started killing people? And he said to me, it is a man's job that he had to do because he need money to make a better living, and I warned him about it. Bongane used to keep small quantity of firearm and ammunition in his room to set or secure rear out further in the confrontation. And yeah, red. Sure. And he used to keep firearms in his room, and the roof of his room in a bag, a cover, and then a blanket. I used to move around Nongoma and Phosphorus, pointing some job selling firearms for me and Bongane Ntanzi and Keniselani, and was our customer because by now and then a higher price. Keniselani sometimes he knew the firearm. He used the firearms to kill people, and I discovered that Keniselani had a lot of cases which is being arrested or investigated for killing people. Around June 2020, I went to Phosphorus and had Muzi Sibia and his girlfriend. Muzi Sibia had serious, I don't know, his girlfriend regarding he seriously hit his girlfriend regarding the Senzo Meyiwa case, and attempted his father paid a policeman to cancel up the case. I also heard that Bongane Ntanzi, Mapisa, Carlos Nkani, Ntuli are involved in the murder of Senzo Meyiwa. I was very angry at them because they have killed a very important person who was the national goalkeeper of our football club and Orlando Pirates. Around May 2020, I was approached and visited by Sergeant Mabena and Sergeant Mukhane from the South African Police Service. I didn't know how they found me because it was Carlos, I don't know, by Carlos. And they started asking me, how do I know Keniselani Buthelezi and Bongane Ntanzi? Sergeant Mabena told me that I am a gun supplier and I am supplying the hitmen with firearms and ammunition, and a lot of people were killed. And I became concerned and started shivering. I then cooperated with the police and told them what I know about Keniselani, Bongane Ntanzi. I told that I heard that Keniselani is arrested in Nongoma, and they asked me my gun involvement with Ntanzi, my gun involvement with Ntanzi, and explained that I was a middleman, my gun dealings with Ntanzi, and I explained that I was a middleman,
just making money for myself. I voluntarily decided to work with
the police to trace Bongani Ntanzi in Rustenburg. On the 16th of June 2020, I took the police to Pukeng and showed them a place where Bongani Ntanzi is staying. I also positively pointed him, or positively, I think it's identified him or pointed him, my lord, to Sergeant Mabena and Sergeant Mohane. Bongani was working at the time because of COVID-19. I am prepared to take the police to meet the witnesses that are also threatened by Ntanzi, Mapisa, Carlos Ntuli, and Keniselani. And their further names are Joseph Dambo, Fuzile Bali, Ntando Khumalo, Tsepo Mukwena, Nontobeko Sitole, Dikeledi Sirape, and John Siyoka. I know and understand the contents, so that's basically the oath, my lord, and then it was signed and commissioned by Sergeant Mohane on 2020 June the 16th at 1400 hours.
Isona ke leso statement sakhe.
My apologies, my lord, the handwriting, I was really struggling, my lord.
Isona statement sakhe Simphiwe Buthelezi ukuthi ngiyathemba ukuthi nisizwile side kodwa uma ngisiqaphuna yena uthi uNtanzi bekade kuumuntu ophana ngeibhamu onika inkabi ukuthi zishaye abantu abahlukahlukene futhi ukhuluma namagama wabantu ukuthi obani labo bantu ukuthi uNtanzi wayekade banika ibhamu naye uke kwaba nesikhathi esebenza erank la ukuthi baye bamcela ukuthi kudingeka isibhamu esithize waxhumana noNtanzi wamnika sona leso sibhamu wakhokhelwa futhi kunomunye umuntu oyekuthi uye wasebenzisa isibhamu ebesinamandla kakhulu lo muntu wayekade hamba eqhoma yonke indawo ukuthi yena ushaya ngesinye isibhamu esingeke sivinjwe futhi ukhuluma ngalolu daba lecala lika Senzo Meyiwa ukuthi uNtanzi noSibiya kuke kwakhulunywa baba kaSibiya naye ingathi uke wakhokhela amaphoyisa ukuthi azame ukucisha leli cala la ukuthi uma uqhubeka uthi yena uye wahambisa amaphoyisa uMabena noMkhani wabayisa ePhukeni labe uNtanzi ehlala khona wafika naye wakhomba uNtanzi ngaleso sikhathi uNtanzi wayekade esebenza ngaleso Northwest la ukuthi ubekade esebenza emayini futhi uyaqhubeka uthi uNtanzi ubekade emnika ezinye ibhamu ubekade engazi yena ukuthi uNtanzi uzithatha phi ithemakezwa uma kukhulunywa ukhuluma amagama wenu nobahlanu madoda uthi ithemakezwa ukuthi nina nani ingxenye yalokubunalwa kuka Robert Senzo Meyiwa uthi wanithuthelela kakhulu ngoba nina nanikade nibulele unozinti wezwe futhi neOrlando Pirates uthi ke yena ke uzimisela ukuthi uyazwisisa yonke into ayibhalile futhi uyazimisela nokuthi angafunga. Thank you my lord, I just summarized the statement.
Yes, I've listened to the statement.
That's correct.
Yes, Mr. Buthelezi, Mr. Mgomezulu. Any other questions?
Yes. Do you know that this Simphiwe Buthelezi died in 2022?
Yes, I've heard, my lord. He was also a witness. Subsequent to this information, I also pursued him, because he mentioned issues in relation to this matter, and followed up with him, and he gave us a statement, which is in this docket 636, which is disclosed to the defense, and he does make implications of the other accused in that statement. So I am aware that he died subsequent to that, my lord.
Uyazi ukuthi uSimphiwe Buthelezi lo wale statement yena washona ngo2022 uthi yebo ngiyazi ngoba ngaya nakuye bengade ngifuna ngiphenya ngazo lezi document azenzile ngoba wayekade ekhuluma ngezinto ezibucayi kakhulu ingakho ngiye ngaya kuye ngifuna olunye ulwazi ngiyazi ukuthi ngempela yena washo.
But the other witnesses are still alive, my lord.
Kodwa abanye abofakazi bona basaphila.
All right. Regarding docket 163, we talk about murder in Kwanongo. According to that statement, I'm not talking about the truthfulness of what is there. It talks about a murder in Marikana. There's no mention of murder in Kwanongo. Do you agree?
No, it says that the man was involved in killing people. Always,
Yes.
it says that, and so when the police, the investigators, they were plotting these matters because he made one statement, made various of different cases. Even then the Marikana matter, he didn't say this is the person. He gave like a prognosis of the things. Then we analyzed and got to a specific docket where indeed a high-profile person was found who was a union member who was assassinated. That's how we got to that docket. So even the murder that is referring to, he gives a direction of where the murder occurred. We dissected sort of that statement and we were able to identify those dockets and pull them one by one. So yes, if the question is, he didn't say at this specific place this person was killed, is not saying, but it is clear if you read the statement that people were killed, firearms were used, and indeed Mr. Buthelezi was convicted for murder and there's firearms also involved.
Ubonile na kule statement osanda kusifunda ukuthi uButhelezi uthe kubulawe umuntu eMarikana akakhulumanga ngokubulawa komuntu wase Nongo uthi yebo kodwa kulesi statement ushilo ukuthi kubulawe abantu endaweni ezihlukile ingakho nathi besikade siphenya kulezi indawo ezihlukile akusukuthi bekwamele siphenye kuphela kuleli yaqala lasePhukeni ngoba ukhulume ngeindawo ezihlukile futhi naye uqinisela Buthelezi uye egwetshwa ngecala ekuthi belikade kukhulunywe ngalo kuso lesi statement.
And my lord, I can say the essence of this statement is that there was, I believe, a reason for Sergeant Mokhane to make a move on accused number 2 on the 16th. That is really the essence of the basis of why they approach him. A lot of things were said there, and I can tell this court, if I have to reveal the dockets that actually we had to pursue or come to know about based on this information, others that we've got, it's more than 30, my lord. And it's serious
Dockets
matters.
of murder.
Murder, attempted murder, firearms, it's a lot, my lord, that came. It's a lot. I can tell this court without it's a lot. We are not even done, and I don't want to say bad things about this accused because I'm being asked now by counsel for accused 1 and 2, but a lot has come up, my lord. So it was not baseless, it is the truth.
Manje ke ukuthi uMokhane ayofunana noNtanzi uthi kwasasikhona isizathu ngoba nqwaba yamacala ayikuthi sisawaphenya amanye seqediwe ukuphenya ngawo amanye asaphenywa namacala uthi uma engathi nje ukwabala angaba lapha yako 30 uthi akafune ukubonakala ingathi umuntu okhuluma uNtanzi kabi kodwa amacala amaningi amanye ahlanganisa ukubulalwa kwabantu amanye ahlanganisa ibhamu nezinhlamvu ezingekho emthethweni.
So let me just put it straight to you. I'm just putting to you to comment, and this is what actually emanate from the version of accused number 2. You have unlawfully and wrongfully arrested accused number 2 by accusing him with the murder charge, with the murder case under 163. And it is further my version that you had no other reason to contain him other than to put him under arrest so that you can solicit a confession from him.
My lord, maybe just for clarity, is the statement saying I have unlawfully arrested the accused 2 made in the general sense that the police, or is it directed to me in person?
You.
No, but I didn't arrest accused number 2.
Well,
He was arrested by, I was not there even when he was arrested, my lord. So that cannot be true. Yes, Sergeant Mokhano. And Sergeant Mokhano submitted his arrest statement. It's in the docket. It clearly indicates that he arrested him. I was not there.
Manje ummeli uthi mangalelo wesibini yena uthi uboshwe ngendlela engekho emthethweni amaphoyisa hlangana naye uSergeant Mokhano. Uthi ubrigadier yena ubona ukuthi bambophe ngendlela esemthethweni futhi noSergeant Mokhano naye washo kwi-statement sakhe naye ufakazile ukuthi uNtanzi uboshwe ngendlela esemthethweni ngoba kwekade kuneyinsolakalo zokuthi ubandakanyeka kwicala.
That is to say, on the 16th of June when he was arrested, the following day, the 17th, he was interrogated about the death of Senzo Meyiwa, not about the Nongoma case.
But that's not what is contained in the docket. It's not true. The warning statement, my lord, which it's in the docket, counsel must have seen it.
Whose warning statement is that?
For accused number 2.
It has never been.
For accused number 2, the docket
Have you
is
seen it, Mr.?
No, I haven't seen it.
the warning statement.
Yes.
No, but my lord, it's attached. Let me just
We are dealing with the confession and the pointing out.
My lord, the warning statement is A8 in Nongoma 163. It indicates that he was questioned for this Nongoma 163 and other matters, because these matters they were in with Nongoma case 163. A warning statement was taken from accused number 2 and he signed after the warning statement was taken, where he denied all the allegations. Allegations were put to him. Case numbers were reflected, not one case. This Marikana case was mentioned. The robbery case was mentioned to him as articulated by this Mpiwe and Sergeant Mokhane, and they were put to him. He signed where he says he denies all the allegations.
Uthi ke ummeli uNtanzi yena uthi uboshwe ngendlela engekho emthethweni ngoba uboshwa namuhla nge-16 zika June kusasa sekabuzwa ngecala lika Senzo Meyiwa. Ubrigadier uthi cha, lokho akwenzwa ngalanga kanjalo, ubuzwe ngamacala ahlukile futhi na kwi-statement la ngalesikhathi ecebiswa uye watshelwa uNtanzi. Ummeli uthi akasibona ngaleso statement kodwa ubrigadier uthi sikhona la sinobufakazi buka AA la ukuthi uNtanzi wayekade ebuzwa ngama case number ahlukile, amacala ahlukile futhi nokuthi kwenzakeleni uNtanzi elibele ephika kodwa ugcine seyikuthi uyasayina kuso leso statement.
Furthermore, my lord, A5 of this docket, this portion that the court asked counsel to look at, A5, it's a notice of right, 14A, where this case 163 is written. It was made to accused to by Sergeant Mokhane, and it states clearly it's a murder charge. He was given this notice of rights and signed, and Sergeant Mokhane signed.
Futhi la kunencwadi ukuthi ikubufakazi A5 la ukuthi ikhuluma ngecala lemeda, kukhulunywa ngalo lelicala le163 la ukuthi uSergeant Mokhane usayinile nawe Ntanzi usayinile khona la.
I think you fail to understand what I was saying. When he was arrested on the 16th of June 2020, he was arrested under the charge of murder, case number 16304/2018. That's what I was saying. I did not dispute that. But what I'm putting to you is that you use the docket to secure Ntanzi for the purpose of obtaining a confession from him.
No.
Number 2, to add on that, there's a docket 534/06/2020 for Sloras. I just want to know as well on that aspect, was Ntanzi charged and was he brought to court? Was that docket registered with the Sloras police station?
I'm not sure what docket is that, my lord, but it's that Phosphorus 534. I'll let you be
Which
told.
docket is that now?
The one
534, which? What is the
for
charge?
possession, my lord.
Possession of firearm,
No, for possession of drugs.
drugs.
That's what Mokhane told this court.
So, Yes, putting it to him that
Yes.
he used it in the case of drugs
That's correct.
to get a confession.
Yes, I'll make a follow-up
Fine.
on that.
To get a confession, fine.
Yes.
When was this docket of drugs opened? You know, Sergeant?
My lord, I don't know. Sergeant,
When was
it's
it
not my
opened?
docket.
Gomezulu?
According to Sergeant Mukhane, the docket was open in Phosphorus.
Yeah, on which date? Because you're linking it to a confession. I just want to know
Yes,
how related.
yes.
Uthi ubrigadier lelicala lasephosphorus leyidakamizwa yena akalazi ngoba akulona icala eyena asebenza kulo kodwa kuthiwa uSergeant Mukhane ukhulume ngalo.
May I remind the court that when we requested to see the dockets, both 534, 06-2020 and 163, they were not provided to the defense.
Yeah, but you can approach your client. Was he ever arrested under case number 534 in connection with drugs?
That's what is
And did he
denied.
appear in court? When did he appear in court? Because
never
I want
appeared.
just listen to me.
Yes.
You are the one who are linking that docket of dealing in drugs. And you're saying this witness, Brigadier Dinanda, used it as a pressure to obtain a confession from your client. Is that not what you're
That
saying?
is so, ma'am.
So that's why I want to know, when was the docket opened?
The
Here's
doc-
your client. When was he arrested at least?
May I
Yes,
approach
please.
him? I'm approaching.
Manje inkosi enkantolo ithi ummeli
Let me
azobuza
approach.
ukuthi uye waboshwa nini kuleli cala leyidakamizwa lasephosphorus.
My instruction is that for the first time, accused number 2 heard about the the docket under 534 and 163 heard from Sergeant Mukhane. He has never been arrested and never been charged with such cases.
No, this is not how I recall the evidence of Sergeant Mukhale.
Mukhane,
No, not the lady, Mamfundis, as you call him.
I'm referring to the male.
No,
Mukhane.
I know, wasn't Mukhale, sorry, the lady. Wasn't she the investigating officer?
Mukhola.
Mukhola.
So, no, for accused 2, my lord, it was Sergeant Mukhane, the male.
The male.
The male, yeah.
In
So far
relation
as the question
to, sorry, in
accused
relation
number
to
two.
the drugs case.
No, so the drugs case, my lord, it was Sergeant Mukhola, the court is right. But that drugs-related case, it's Tembisa matter.
Yeah.
That is Sergeant Mukhola. The murder docket, and I think the case that counsel is referring to, they saying it's Sergeant Mukhane, so that's the case that I'm lost
The
about.
murder docket, which murder docket is that, sir?
The 163.
The one we're dealing with.
The one we are dealing with. I want to remind the court that accused number 2 was taken to Phosphorus
Yeah,
on the 19th.
yeah, that's when you said they must divert.
Yes, that's when they called Brigadier Kiminda, who told them that they must go to Moroka police station.
So my lord, perhaps let me start answering here. It is. I think the question was that they were never arrested. That's what counsel said. He said they were never arrested. I mean, accused 2 was never arrested for 163 and this drug dealing offense.
Yeah,
my
that's-
response, my lord, insofar as 163, because I don't have the contents of the other docket that is referring to. Insofar as 163 of 4/2018, I don't agree with counsel because this is the docket he just read. The notice of rights are here, the warning statement is here, but furthermore, my lord, OB, occurrence book that have been submitted as evidence in this court were presented, and it is clear that accused 2, after the arrest of the 16th, he was detained at the police station under this case number. So it will be incorrect that he was not arrested for this case number. And then he was then booked out, I think on the 19th in the morning hours to court. This is the day now where they made a diversion and went to make a confession. So insofar as 163, I can confirm, my lord, that he was arrested. The other matter is the one that I'm saying, I don't want to say wrong things, my lord.
Uthi akafuna ukukhuluma izinto engasizona ubrigadier isikhulukazi uma kukhulunywa ngaleli cala leyidakamizwa uthi lelo akanalo ulwazi ngalo alaziyo yileli le163 la ukuthi uye uNtanzi uye waboshwa futhi uNtathakusa uye wakhishwa eyiswa enkantolo uthi yilona icala alaziyo uma kuthiwa uNtanzi akazange aboshwe uthi ngaleli lika163 unesiqiniseko sokuthi uNtanzi waboshwa.
All right, let's just deal with 163 according to your evidence. Was he formally charged under docket 163? Was he ever brought to court under 163? Did he appear in Wanongoma court?
My lord, we dealt with this. I think I did indicate that yes, he was processed, now the formal processes.
Yes,
and
yes.
what I was reported is that when he was taken to Phosphorus, where they intended to transfer him that site, there was, the matter was not enrolled together with another matter. That's what I was informed. That was not part of this process, but that's what I know, my lord. What I do know is that indeed on the OB, he was booked out for court purposes, my lord.
Kuleli cala le163 uNtanzi uye wathweswa na amacala wayiswa enkantolo futhi wavela na uthi ubrigadier mayiphendula yena unolwazi alizwe bamcebisa ukuthi uNtanzi ngempela yena uye waboshwa ukuyovela kwamanje kulayi ukuthi baye bamcebisa ukuthi akazange avele ngenxa yokuthi amacala lawo akazange athulwe enkantolo manje uthi yilona ulwazi analo ngaleli cala le163.
And that is why, my lord, so sorry, counsel, sorry, I don't mean to interject. My lord, that is why I said then, subsequent to us knowing that this matter was not enrolled, this is now this one, and there were these other matters in different provinces where I took a decision that let these matters be investigated, concluded, and presented so that we have one central point to move on as and when the investigation are concluded. But the magnitude of work obviously then has overtaken us up to this stage.
Ngemva kwalokho kula mina ithema ngizwa ukuthi leli cala alizange lifakwe enkantolo ngiye ngathatha isinqumo sokuthi wonke lamacala lawa ake aphenywe ukuze sizokwazi ukuthi siwahlanganise wonke kodwa ngoba umsebenzi umningi gcine seyikuthi uphuma ezandleni zethu ukuthi sikwazi ukuphenya wonke lamacala ngesikhathi.
So let's get now into the aspect of a confession. Questions arising from the confession that was taken on the 19th of June 22. My instruction is that prior to the taking of that confession by Colonel Mboto, by Colonel Rapato, it's my instruction that accused number 2 was assaulted, subjected to torture, he was choked with the plastic, poured with water, and electrocuted. That was prior to the making of that confession. Will you dispute that?
It is, maybe let me understand, my lord, also. Is this assault saying I was there, or is it a general remark that happened in my
absence? It's a version
when?
of accused number 2. I said prior to the, and did not mention the name of anyone, prior to the alleged confession being taken, he was tortured. I'm still coming to the people who tortured him. I'm just putting the basis that he was tortured, electrocuted, and choked.
My Lord, what I know, and I'm answering on the basis of what I know. When I interviewed him the first time on the 18th, with regard to the first alibi, there was no indication from him that he was assaulted. And he was not assaulted also at any stage when he was with me, and that is with regard to the following of his first false alibi, because that is when I came across him. He was given his rights in terms of the Constitution. I spoke to him. I did not detect or see any visible injuries, nor there was any of such complaint reported to me.
Mina ngalesikhathi ngikhuluma naye uNtanzi ngaphambi kokuthi azoyenza lesiya azogunyuluka laphayana, mina ngiye ngakhuluma naye ngimbuza, kodwa akazange angicebise ukuthi ushayiwe, ulinyaziwe noma unesikhalazo esithize. Ngaleso sikhathi ngikhuluma naye akazange nje angitshele lo.
Now, so Council, now moving forward, my Lord, then the confession was made when I got hold of the document. This is now after meeting Colonel Rapad. In the documents, because it was given to me by Lieutenant Colonel Rapad, nowhere was it recorded that he's got any injuries or complaints.
Futhi ke ithema ngithola amaphepha asuka ku Lieutenant Colonel Rapad, yena akukho la ukuthi ubhale ukuthi uNtanzi wayekade elimele endaweni ethize.
Now, furthermore, my Lord, when he was detained on the 16th, as I said, I assisted in coordinating the occurrence books. Nowhere on the detention office, just after his arrest, also when he was booked in and out on the 17th, the 18th, and 19th, leading to the confession, as well as after, we came back from Pukeng, where the docket of ammunition was registered. All those OPs do not reflect that he was at any stage booked in or visited and found that he is complaining of assault or there are injuries that were seen. So on those bases, my Lord, it will be difficult for me to say, he was assaulted. It was not brought to my attention. Evidence that is before this court suggests otherwise, my Lord.
Bulamalanga ayikuthi ngibe noNtanzi kusukela nge-18 kuyofika nge-19 fikela size siya nasePhukeng, asikho isikhathi la ukuthi kuye kwabhalwa khona phansi kwincwadi ezama-OB ukuthi uNtanzi ushayiwe. Angizange ngibone lapho ukuthi uNtanzi kubhalwe ukuthi ushayiwe noma ulimele endaweni ethize.
On the 18th, in the evening, it's my version that Ntanzi was assaulted near an engine garage by Mabena, Jonathan, Utelezi, Maphumulo, and yes, it was next to an engine garage in Albertine.
My Lord, I was not there. As I indicated, the last time I saw him on the 18th, it's when we were following the alibi in Carltonville. From there, we parted ways. So I will not, I was not there. All I can say, like I said earlier, my Lord, there is no indication in the OBs, including the 18th, because I made arrangements to collect those OBs and peruse them. Nowhere it's documented, even on the entries of the 18th. I think he went back to the detention cells in the morning hours of the 19th, my Lord, that he was booked in with injuries and subsequently booked out to court with injuries, or further, when he went back, I think, to the police station next to Jamestown, Primrose, as well as Pukeng. None of those occurrence books, my Lord, suggest, such assertions, my Lord. That's how far I can answer it, my Lord.
Uthi uNtanzi yena nge-18 ushayiwe ngase-engine garage eshawa uMaphumulo, uButhelezi, uMabhena noJonathan. Bebalapho ngaleso sikhathi bemshaya. Uma iphendula ubrigadier uthi mina bengekho. Ngeke ngikwazi ukuphendula lokho, kodwa ithe uma ngihlola ama-OB wonke akukho la ukuthi kubhalwe ukuthi uNtanzi ushayiwe uma ezofakwa esitorisini, futhi nanoma ekhishwa ayisiwa kuleli police station elase Primrose, akukho nala kubhaliwe ukuthi uNtanzi ukhishwa ushayiwe, nanoma efika ngale akukho la kubhalwa ukuthi uNtanzi ufika eshayina.
And for your information, Sergeant Mkhane, when it was firstly put to him when it was firstly put to him during cross-examination that Ntanzi was assaulted next to an engine garage by the persons that I've mentioned, he denied having been next to an engine garage, and he denied the assault. That's what Mukhane said. Firstly denied, but now getting into the AVL shows that there was a stop at engine garage in Albert, and he further confirmed that after he saw that the AVL shows the location of the vehicle at that time.
Yeah, my lord, no, I hear what Council is saying, but it's I don't know what to say. I was not here when Sergeant Mukhane testified. I was not there. I don't know how could I assist in that.
manje ke ngizibazise ekuqaleni uMkhani ithe makukhulunywa ngendaba yase-engine yokushawa kukamangalelwa, yena eshawa yilabantu laba asesikhulume ngabo, yena uqale ephika ukuthi azami asondele ngase-engine garage. Ithe-ke mase sekuvela lo buyabufakazi be-AVL kulaye ukuthi uye washo ukuthi yebo bekangase-engine kodwa ukushawa kona ugcine sekuthi uyakuphika. Ubrigadier uthi mina bengingekho ngeke ngikwazi ukuthi uMkhani utheni futhi nalaphayana e-engine mina kangingekho.
And please, my lord, who submitted that question is misleading, because the version that was put to Sergeant Mukhane was that en route to Morocco on the 19th of June, that's when the assault took place. But this version was later adapted to say that the assault took place on the way back from Cottonville.
I'll differ with what my colleague is submitting. I'll make reference to the records. And the reason why my colleague is raising with this objection is because they knew and deliberately so omitted the location of that motor vehicle on the 18th on the reasons that they knew that it was an evidence that corroborated the version of accused number 2. I will submit with due respect that there is no such objection or statement made by Sergeant Mukhane. What is understood is that Sergeant Mukhane initially denied having taken accused number 2 next to an engine garage in the presence of Jonathan, Maphumulo, Buteles and the rest. And further, it has been denied by all these witnesses, I mean the SWAT unit, to be next to an engine garage at any given stage when it was put to them that Ntanzi was assaulted on the day. But what I can put to you now is that when Jonathan, Buteles, Maphumulo were cross-examined in relation to the version given by Ntanzi that he was assaulted next to an engine garage, they also denied having been next to the engine garage. They also denied having assaulted accused number 2.
As it was, we will repeat the same objection that the version that was put was that this assault happened on the 19th of June.
Not on the 18th.
On the way, yes. On the way to Morocco Police Station.
Yes.
That is not true. We'll definitely rely on our records. May I proceed, my lord?
Yes.
Yes. I'm putting to you that the version of accused number 2 is that on the 18th he was assaulted and later he was taken back to Pretoria North where he was kept, and 2 hours later or 3 hours later he was booked out again. No, it's not that one. After he was assaulted, round about 12 o'clock midnight, he was transported back to where he was kept at the police station. It was Pretoria North. So 2 hours, so when he was booked in at 2:30 in the morning, and was booked out around 5 or around 4 to take him to Vosloorus police station on the 19th. Can you dispute that?
The booking out, my lord, I will not dispute that because it's. I think I've seen, although I'm not sure about the time, but I will not dispute it because if it's not accurate, it's not far from that. So that part I will not dispute, my lord. The part that I want to dispute clearly and without a shadow of a doubt is the impression that the state, including myself, I suppose, we deliberately kept the information of the 18th because we knew that it has issues. That's not correct. When I received the request for the AVL, I made that application, my lord. I made that application. And the request was the information for the AVL to be provided from the 30th of May 2020 to the 24th of June. All the days. And when I say all the days, I'm not saying selected days. Every day. 30, 31, 1, 2, 3, 4, 5. Once that was obtained, my lord, because it was voluminous, I consulted with the state as to which parts to make it easier does the defense and the state wants to deal with. I was never given the date of the 18th. And when that is why the initial package didn't include the 18th, because I then took the request, not that I prepared it myself, sat with the expert and said, please package this information according to this date and submit your affidavits so that it can be presented. And that's how it was done, my lord. Later, when additional dates were requested, we followed that same pattern. So at no stage was information kept away. That is really not correct.
Nkosi enkantolo, indaba leyo yokuthi uNhlanzi uye wabuyiselwa esitokisini ebusuku uthi ubrigadier lokho angikuphikisi nangokho uma engabe isikhathi singafani kodwa sicishe sisondela khona lapho. Indaba engifuna ukuyiphika ile ndaba yokuthi ilanga leli lange-18 bufakazi bakhona thina siye sabugodla ngenxa yokuthi besazi ukuthi kunento eshaya amanzi khona lapho. Uthi cha, asizange thina sagodla lutho ngoba lesi sicelo sokuthi kulethwe lobuyabufakazi be-AVL yimina ongafaka leso sicelo ngemva kokuthi sengiceliwe ukuthi kudingeka ubufakazi obunjalo. Yimina futhi ngasho wonke amalanga, angizange ngikhethe amalanga. Itheke mase sekuvela la enkantolo ukuthi kudingeka amalanga athize kulana khona ngiye ngathi kungodi loyana ukuthi asithumelele noma asenzele lawo malanga adingwa inkantolo futhi aphinde ayenze i-affidavit. Mina ayikho into ebengikade ngiyigodla.
May I just further take you on the version at Engine Garage? Sergeant Mkhane conceded when he was cross-examined on the AVL of the 18th of June 2020. He conceded to say he was at Engine Garage. That's where they bought water and some stuff. And further conceded that on that night he was later joined, or on that night he was further joined by the SWAT unit, that is Jonathan, Buteles and Mapumo.
My lord, obviously the issues of the engine garage and buying food, I was not told about that. What I do know is that on the 18th of June 2020, Sergeant Mohande did report to me that the car was giving him mechanical issues. That I know. Subsequent to that, I did say he must get a backup because I knew they were in a company of accused too. I know he was joined by SWAT team members. I just didn't get the names as to who, but I know that at the time when they were at a specific area, there was a mechanical issue, and insofar as I was briefed, SWAT came to assist until the mechanical issue was resolved, and they went to detain accused too. That's what I know about the presence of SWAT. It was to assist basically with the safekeeping of everyone.
Indaba yokuthengwa kokudla noma okuphuzwayo kwange-18 angizange ngitshelwe ngakho angikwazi. Kodwa engikwazi ukuthi uSergeant Mohane uye wangichazisela ukuthi nge-18 imoto yayikade imnika inkinga, kungakho ngiye ngamcebisa ukuthi afune i-backup, ingakho egcine sekathola laba akukhulunywa ngabo. Kodwa angizange ngitshelwe ukuthi abobani amagama walabantu laba abafikile bazomsiza, ngoba mina ngithi athole laba bazomsiza ngoba bengazi ukuthi unomangalelwa wesibili.
And it was for the first time when confronted with the AVL of the 18th that Sergeant Mohane gave evidence of the mechanical breakdown of a motor vehicle. During his evidence in chief, or even cross-examination before the AVLs, he never said anything about mechanical failure in the motor vehicle. I'm surprised that as the lead investigator, you want to support a statement that was never said initially by you, by Sergeant Mohane.
My lord, I don't know how the question was put to him. I'm simply narrating what was told to me, and subsequent to that, my lord, the vehicle was indeed booked in the police garage in Benoni, because on the 24th, I know that they were using Sergeant when the confession, insofar as accused number 2 is concerned, at the Boksburg Magistrate Court is concerned, the car was already sitting in Benoni. So the reporting was made to me and is not meant to mislead or do anything. It's a fact that I was told, my lord.
Mina akusukuthi ngifuna ukulahlekisa inkantolo noma ini, ngiye ngatshelwa ngokuthi imoto yayikade ihlupha futhi umangalelwa wayekade hamba nabo naye uSergeant Mohane. Angazi ukuthi ubuzwe kanjani ukuze azophendula ngalendlela ummeli bekathi uphendule ngayo, kodwa mina ngiye ngatshelwa ukuthi imoto ibikade ihlupha futhi bebakade bangale ngasendaweni yaseBenoni.
My lord, before we request an adjournment, with your permission, I am going to pause on this cross-examination for the 18th, because I didn't want to juxtapose and show no logic in what I'm asking. And I will provide the records tomorrow morning relating to the evidence that is now given by Brigadier Kininda about the AVL of the 24th of June. May I just have few questions on the AVL of the 24th? As I'm saying to you, putting what has been asked from Mr. Sergeant Mohane, on the 24th, is it your evidence also? Can you confirm it under oath that on the 24th, the Toyota Fortuner was in Benoni and it was not transporting accused number 2 to Boksburg prison, to Boksburg court?
No, it was in Benoni. I think the AVL record, my lord, shows that we gave it to the defense. It's not a point of contention. The AVL, I remember, went through it, and I think it was there few days before the 24th. My recollection on the 24th, it is parked in Benoni. It's a mechanical police garage, my lord.
ngiyavuma ukuthi nge-24 imoto le i-Toyota Fortuner yayikade ingahambisi ummangalelwa wesibini ngoba ngiyazi futhi ngibonile nakwi-AVL ukuthi yapakwa laphaya eBinoni amalanga ngaphambi kokuthi i-24 zifike.
Yes. The reason why I requested permission or indulgence to the court to deal with the date of the 24th is because, firstly, I'll bring the records tomorrow in the morning, whereby there was a ruling by the court when we objected on the use or the giving evidence on the AVL. And the court made a ruling and I'll provide that ruling that has been made by the court, which was considered by Sergeant Mkhano to that motor vehicle was interlinked with the AVL. And there were certain areas that were also mentioned in that ruling relating to the Fortuner that was transporting accused number 2.
My lord, I don't understand the interlink. What I know about AVL, it is assigned to a specific vehicle. You can't link it to another vehicle. It's assigned to a specific vehicle to monitor the driving, management of the driver, the location, the speed, but it's assigned to a specific vehicle. And the one that I saw, my lord, like I said, my recollection and which I can provide, I do have that AVL. On the 24th of June 2020, the vehicle was parked in Benoni. The AVL shows that. So if it was interlinked with another vehicle, I don't know how, my lord.
Sorry, Mr. Before you interpret it, sir, not interlinked with another vehicle.
Oh.
The evidence of Sergeant Mkhane relating to the transportation of accused number 2 was interlinked. That's what I was saying, not with another motor vehicle. You still dispute that he was transported on the 24th of June?
No, I don't dispute that he was transported from prison, from the police station, my lord, because I made arrangements for the confession. I've said this in my evidence in chief. I didn't give instruction to Sergeant Mkhane. I know that accused 2 was picked up from the police station, taken to Boksburg Magistrate Court, and that is where the confession by Magistrate Pretoria was made, and then taken back, and that is the 24th of June 2020. What I'm saying is that in my recollection, the vehicle, the Toyota Fortuner, I think it's FV47LFGP, my lord, that vehicle was at Benoni. He was not utilizing that vehicle. That's what I'm saying, my lord.
Angiphiki ukuthi nge-24 ummangalelwa wasuswa estokisini ayisiwa enkantolo ukuthi ayohlangana nomantshi uKronye ngalesikhathi eyogonyuluka, kodwa wayekade engahambi ngale Toyota Fortuner ekukhulunywa ngayo. Mina nginaleso siqiniseko sokuthi wayekade engahambi noma engahanjiswa ngale Fortuner ekukhulunywa ngayo.
I'll further give you the records tomorrow morning to confirm that Sergeant Mkhano led evidence that from the police station to Boksburg Court, he transported accused number 2 using a white Toyota Fortuner bearing the registration numbers that you have just said, and he was escorted by the SWAT members, and the SWAT members also, the evidence of Jonathan is there, evidence of Mapumulo is there, the evidence of Buteles is also there, that on that particular day when they took accused number 2 to make a confession in Boksburg Court, he was put into a Toyota Fortuner. This means that evidence that it was not in use. That means either the AVL is not accurate or the witness is deliberately misleading the court.
As a good please, that is not according to our recollection of the evidence of Sergeant Mohan, but as Council pointed out, we can peruse the record just to verify that aspect, but that is not according to our recollection.
May I adjourn, my lord, for tomorrow? It's 3:30.
Mshushisi usukuma ephikisana nale ndaba obaba uMngomezulu ayishoyo ukuthi imoto kuthiwa ye24 iFortuna ekade ihambisana noNtanzi manje uma ebuya ubaba uMngomezulu uthi ake silibeke khona la loludaba sizophinda sibuye kusasa uthi unobufakazi obubonisayo ukuthi uSergeant Mohan ukhulume kanjalo futhi lobo bufakazi uzobuletha kusasa ekuseni.
Okay, tomorrow at 10 o'clock. Yes, Mr. Mngomezulu, you're still...
Court, please,
Any further questions? You're still on the oath, Brigadier?
Yes, my lord.
Thank you.
My lord, may I seek your permission or ask
To do
for
what?
permission for the witness to be taken back on the aspect of his knowledge about the docket 534 concerning possession of drugs in Fostoras.
You want to cross-examine him again on that?
On that aspect, that
Okay, fine, no problem.
thank you.
As a court case, my lord, just for my learned friend to proceed.
Yeah,
Yesterday, he undertook to find certain portions in the record
I know.
to
Show us on the records.
support the questions that he was putting to the witnesses.
So has he brought that record? Mr. Mngomezulu?
Yes, Lord, I've got
You
the-
brought it. He says he brought it.
Yes, yeah. But the first point, my lord, relates to the
The vehicle.
questions that he put to Sergeant Mohan
Yeah, Mohanu, yeah.
as to what happened on the 19th. He contended that Sergeant Mohan denied that he was joined by the
Jonathan. SWAT team.
Ekurhuleni team,
Yeah.
and we just want to refer the court to
Yes.
the proceedings of the 7th of
7th?
November,
No.
7 November
November
2023.
2023.
Yes, page 20
Page 20. Right?
from line 14.
Line 14.
Yes, 14.
14
Yes, 14
to
to page up to page 22, my lord.
up to page 22. So it's page 20 to 22.
Yes.
Yeah, okay.
And we just want to briefly quote what Advocate Mngomezulu said. Mr. Mngomezulu, accused will come and tell the court that on the 19th, on the date the alleged confession was taken,
Yeah.
he was assaulted by the Metro police officers, including Mabena, who was in your company. Then he says the Metro police officers who were present was Butelezi, Jonathan, Mabena. Then Sergeant Mohani then replied, I do not accept that because I do not know anything about that. He would have informed me if you've been assaulted. And that was when I think the submission of counsel was based on this particular answer by Sergeant Mohani that he denied that the SWAT team was present on the day in question. And on page 21, Sergeant Mohani carries on. He says he was the driver of the car.
Right.
And Mr. Mngomezulu says, yes, this is line 3 on page 21. It is my instruction that as he was transported, a car parked next to a certain filling station, where he saw a board reflecting Alberton. Then Mr. Sergeant Mohani asked, I want explanation of whether it was when we were still on our way to Moroka, then Mr. Mgomezulu said, this is the version of the accused. And he said, you can pose questions to me. Then Mr. Mgomezulu at page 18 says, I agree that the bottom line is I'm putting the version of accused 2. He was stopped, or the Toyota Fortuner stopped next to a filling station, and that is when a short while a motor vehicle that was driven by Jonathan arrived. Then Sergeant Mukhani said that is not true. And counsel yesterday contended that Sergeant Mukhani denied the arrival of the SWAT team, but as we mentioned, my lord, that the cross-examination was based on the version that was put that the incident occurred on the 19th en route to Morocco Police Station. And that is basically the trend of the cross-examination insofar as the rest of the pages are concerned.
Kubeka-ke umshushisi efunda loya daba leli ubaba uMngomezulu wayelivezile izolo ngalesikhathi ebuza umnumzane uMukhani imibuzo kula ukuthi uye wamtshela ukuthi umangalelwa wesibini yena uthi uye washawa ngase garage ethize. uSergeant Mukhani yena wakuphika lokho emtshela ummeli ukuthi ushawe amaphoyisa abuya ekuruleni Metropolis. Wakuphika lokho uSergeant Mukhani waphinda futhi ummeli wamtshela ukuthi imoto kaJonathan iye yafika ngaleso sikhathi ulaye ukuthi noSergeant Mukhani waqhubeka ephikisana nalo lolo daba. Manje izolo angithuma sesishayisa bekathe ummeli uzoza ngaloko bufakazi. Umshushisi uqala ngabo uthi nabu lokufakazi oyikuthi inkantolo iye yabuzwa ngey7 zika November nyakeni.
Okay, yes, Mr. Mngomezulu.
My lord, the version put to Sergeant Mukhani relating to the assault on the 19th.
On the 19th?
On the 19th, it's not in dispute. Sorry, my lord. It has been put to Sergeant Mukhani that on the 19th, accused number 2 was assaulted by the police. The continuation of the assault, it did not end on the 19th.
Even on the 20th, after having made the confession, he was still assaulted.
He was assaulted even on the 24th.
I see.
Yes.
Now, what would be the assault for? Because he's already made his confession.
That is the question to be answered by the state.
Okay.
Yes.
Was it ever put, sorry, I don't recall that evidence.
Yes.
Mr. Baloi, was it ever put that even after the confession was made, accused number 2 or Mr. Mngomezulu's client was again still assaulted?
Well, we remember that version insofar as accused number 1 is concerned,
yes,
but not as far as accused number 2 is concerned.
No, but we're talking about number 2.
Yes, yeah, I'm just saying that the continuation of the assault after the making of the confession that was put
in respect of accused number 1.
Yes, on
okay, fine.
Yes, on record. But
I will check that evidence.
Yes.
I will make a special note here with a red pen that there's a dispute between the state and the defense regarding what was put and what was the answer of Mr. Sergeant Mukhani. Any other thing you want to add, sir?
My lord, the assault that was actually effected on the accused on the 24th was even after
the 24th of June.
Of June.
Which accused is that?
Accused number 2.
Number 2
was
after he had made a statement on the 19th
from the magistrate.
Okay. So what was he assaulted for, by the way? Can you remind me? According to him, your instructions, what was he assaulted for? Because they have killed him, these 5 guys.
That's correct.
To make a confession. And then he actually, as I recall the evidence, he doesn't make the confession. The statement of the alleged confession is written out for him. He's only told to sign it. Is that number one?
That's number 2.
That's number 2.
Even number 1 is the same position, but
He also signed what was already
what
written.
was already, yes,
Okay.
in Diepkloof police station.
In Diepkloof police station and at the
Accused number
magistrate's
2,
court.
accused number 2, that's why he said he was assaulted in Orlando East
Ah,
when Brigadier Kininda came with
the
Sergeant
written
Khan,
confession.
with the written
statement.
confession, sitting on the back seat of the white BMW.
Then fine, I appreciate
Yes.
it.
Then the reason why the court is interested to know why was there any continued assault after securing the
Yeah.
confession.
Mm.
This is what I'm going to
Or canvas.
canvass
Okay,
with
fine,
the
fine.
court, please, my
Okay,
lord.
okay.
My lord, may I, with the leave of the court,
Regarding the question as to whether it was put to the witnesses that accused number 2 was assaulted after the 24th, the only allegation was that after he made the confession to the magistrate, on the way to Jamestown, they stopped along the route and he was assaulted and forced to sign the confession. But that is on the day of the of the confession and not after that.
Yeah, I appreciate that because on the day of the confession, the allegation is that he was forced to sign a written statement or alleged confession which was presented to him for signature.
Yes.
You see. Now, after having signed it, was there an imputation that they even assaulted him after he had signed it? And I'm saying,
Yes.
I never heard that,
No,
that imputation.
No, not after that.
Okay, fine. Is that how you recall the evidence, Mr.
That's correct.
Okay, fine, yeah. Okay, continue.
with the leave of the court, may I refer the witness to the records relating to the offense Sergeant Mkhano referred to, the docket under 53406/2020. It's on page.
Do you have a copy of that record, sir?
No, I don't mean it.
Can you assist?
We have an electronic
Oh, I see, okay.
version. We'll just show it on the screen.
Okay.
Sorry, my lord, Mr. Ramsipid is not present today. He's going to assist me next to me. From page 37,
Yes.
the date is, I'll check the date here.
November. 6 November.
The date of the 6th of November 2020. My lord, may I request my PA to come and sit next to me?
Yeah, fine.
Are you still looking for it? Yeah? Page 37 to 38. The last paragraph of page 37. Sir, are you in possession of the records?
No, I don't. I was told I'll watch it on the screen.
We'll print one for him just now.
Or may I give it to the interpreter? May I request the interpreter, my lord, to read for me?
Yeah,
It's going to be much
what you want to put
to the witness.
must be read
Yeah.
into the record.
Court, please.
Okay.
The last part, the last where it says Mr. Mgomezu, the last sentence of page 37 to the following page 38.
Mr. Mgomezulu. All right, now can you please give me the case number where accused was charged with possession of drugs? Should I read the response of Mr. Mkhani?
Yes, please. Up to the yellow.
This part.
Yes.
Mr. Mkhani, before what? Mr. Mgomezulu, possession of drugs. Mr. Mkhani, case number 278/6/2020. No, sorry. Sorry, 534/6/2020. The case number is 534/6/2020. Mr. Mgomezulu, so what is the charge under that case number? Mr. Mkhani, I remember that was the case. Mr. Mgomezulu, you are not sure. Mr. Mkhani, indistinct, not interpreted. Mr. Mgomezulu, sorry. Mr. Mkhani, let me say he was not charged. Mr. Mgomezulu, all right, the SAP 14A.
Just a slight correction, my lord.
Yeah.
On page 38, Mr. Mgomezulu put it to Mr. Mkhani, so was he charged, not what was the charge?
Okay.
Was he charged under that case number? And line 11, Sergeant Mkhani says, let me say he was charged. We just wanted to.
Okay.
Thank you.
I think the interpretation was that he was not charged.
Oh, but he was charged. That's the answer.
Yes.
Okay, fine.
Mr. Mkhani, after he was charged, Mr. Mgomezulu, all right, the SAP 14A notice of rights in terms of the docket 4534/6/2020, Mr. Mkhani, N in bracket indistinct, when the docket comes, Mr. Mgomezulu, so are you referring to this matter which was ultimately not placed on the court roll of phosphorus? Thank you. That is up until the yellow.
Thank you, my lord.
Yes.
So, Brigadier, did you understand the question that I posed on Sergeant Mkhani relating to the drug case in phosphorus?
Yes, I did, my lord. According to the record, if he's referring to this, I understand what was read to me, my lord.
Uzwile na umbuzo ongubuze umnumzana uMkhani uthi yebo nguzwile uma ingabe yiwo lo okhuluma ngawo.
So, is it your first time to hear, during the course of your investigation, to hear about the docket 534/06?
So, my lord, no, it's not the first time. What I said yesterday is the case reference number that I was not sure of, but I am aware that when accused 2, and I think I testify about it in my evidence in chief, that when he was taken to forced arrest, they wanted to put him with a matter that was pending. The case number I'm not sure because it's not my docket. Sergeant Mkhane is the IO, and that is a docket that I'm aware of. So if that is the reference number, then I'm aware. But also, my lord, in addition to, perhaps not in addition, I wanted to start there. Yesterday, it was put to me by Defense for Counsel, counsel for accused number 2, that the vehicle, this is now the Toyota Fortuner with VF47 LRGP, on the 24th. It was, I think there was a dispute in that regard.
Yeah.
I've checked my
Sorry.
records.
Sorry to
No, no,
interject.
Mr. Mgumezulu, please. Let him explain whatever he wants to explain.
It wasn't dispute, my lord. Then I
Yes,
was told
yes,
that
I hear
the
you.
records will be brought to show that the vehicle was there because I've
Was the one that was being utilized
Indeed, and the vehicle indeed was at the police garage mechanical school.
in Benoni.
In Benoni on the 24th, my lord.
That's how I understand the evidence. The AVL expert also says that.
With
Indeed,
due
my lord.
respect, my lord, I'm coming there.
No,
I'm
just
still
saying.
busy with what happened in Force Lawrence. May I not be disturb Brigadier Ken? I'll come to that issue of yesterday, because yesterday you deny having knowledge of the docket of Force Lawrence under 534.
No. I was asked, but that's not correct, my lord.
Yeah.
I was asked specific about the case reference number, not that I was aware if accused was taken to Phosphorus to appear. That's not how it was put to me, my lord.
Okay,
so
fine.
That's not correct.
Maybe you can listen to the records from yesterday.
Yes, we can, my lord.
Yes.
Yabuza ke ummeli ukuthi njengoba sekuchazwe ke le case number le eyase Phosphorus usathi wena awuyazi ukuthi njengoba sekuchaziwe ukuthi laliphi icala ngiyayazi le case number ukuthi nje izolo into bengingayazi bengingenaso iqiniseko sayo bekade kuyile case number ukuthi yaliphi icala kodwa ngiyalazi futhi bese sekachaza nokuthi imoto leyana iToyota Fortuner njengoba bese sekuthiwe bekade ihamba yena uyachaza ukuthi ngempela unesiqiniseko futhi nayizolo makabuyela ngemva kokuthi icala selimisiwe yena uye wayohlola wathola ukuthi futhi leyo moto le yayikade imile ngalelo langa le 24 kodwa umnumzana uNgomezulu uthi uzobuya lapho akalinde angamhambeli ngaphambili.
Say, I'm putting to you that you had a conversation with Sergeant Mkhane in relation to transporting of accused number 2 to Phosphorus police station, or to Phosphorus court.
When, my lord, if I may ask, on what date?
On the 19th.
Yes, we did, my lord. This is the day where I told Sergeant Mkhane that Lieutenant Colonel Rapadi is available. So they should start the Moroka ACPS for the confession. Then I was aware that when they were done, they will be going to Phosphorus Magistrate Court. I've said that in my evidence in chief. I've
Yes.
covered that aspect, my lord.
Uthi ngifuna ukwazisa ke ukuthi wena nomkhane niye nakhuluma ngalokhanjiswa kwamangalelo wesibini nge-19 uthi yebo sakhuluma ngoba bengikade ngimcebisa ukuthi sengimtholele uLieutenant Rapadi ngoba ubekade umangalelwa kwamele ayogunyuluka kuye manje besikhuluma ngalo lelo daba.
My concern is with reference to the evidence that you gave yesterday, denying knowledge. That's the reason why I had to go through my records. You deny having knowledge of the case against accused number 2 for drugs. Now I would like to refer you to another record where there was a conversation between yourself and Sergeant Mkhane. Take a photograph.
My lord, I think counsel for accused 2 is misunderstanding. There was no denial that I'm aware that accused 2 was taken to court. That's not the question that was put to me. A question was put about a specific case number. I was given a specific case number that I was asked if I know it. It's not my case, so I couldn't remember from the top of my head. But the fact that accused 2 was taken to Phosphorus court, I'm aware, and I've testified about it in my evidence in chief. There was never a denial.
uthi ke bengingaphiki ukuthi ummangalelwa yena uyisiwe eFosloras enkantolo. Into bengiyisho ukuthi i-case number akuyona eyami. Manje bengingazi ukuthi eliphi lelo cala ekukhulunywa ngalo, kodwa bengingaphiki ukuthi ummangalelwa uyisiwe eFosloras.
Thank you. What page is that, Mr. Interpreter?
Page 74.
Date?
Dated the 13th of November 2023.
Yes. Where I've indicated there, it's a re-examination of Counsel Baloyi of Sergeant Mkhani.
And it states, Mr. Baloyi, yes, the outcome thereof is on then Exhibit MM. Can just put that in record again. The register, it is UU1. Mr. Mkhani, after placing him on the holding cells, I went to see the prosecutor and the matter was not enrolled on the court roll. Mr. Baloyi, yes, then what happened to the accused? Point number 10, Mr. Mkhani, we took him and left with him. Mr. Baloyi, yes, yes, thank you. You were on the N3 freeway, Fosloras at 14:06:35. When we left the court, Sergeant Mabena noticed that he left his memory stick and his keys at Moroka police station.
Yes. Thank you, Mr. Interpreter. This is the re-examination to confirm. May I address the court, my lord? My lord, the reason why I'm canvassing the issue of the docket 534 is because the court also remarked that could not remember the docket of possession of drugs in Fosloras. The court makes reference to the matter that it recalled for accused number 1, where Sergeant Mkhola was the investigating officer in that matter. Okay. Hence, I was going to request to listen to the records because I want to prove to the court that the witness, Brigadier Kininda, denied having knowledge of this docket. May I proceed, ma'am?
Well, he disputes it. He says he never denied. And I'll check what is the actual state. I'll make a note with a red pen that I should check the evidence on page of the 13th of November, page 74. Okay.
That's correct.
Fine.
So, Brigadier Kininda, according to your experience, as per your evidence, accused number 2 was arrested on a charge of murder under case number 163 of Kwanongom. And now it is apparent that there was a pending case in Fosloras against number 2. So, is it your evidence that both matters were not placed on the roll on the 19th of June 2020 in terms of the records?
If I can seek clarity, my lord, which record is counsel referring to?
No, Mr. Kininda, we just read the record relating to the drug matter. And yesterday you testified about the matter that has not been placed on the roll under case number 163.
My Lord, what was read to me, and that's why I asked the question, nowhere in what was read to me was there an indication that there's a pending matter. So that is why I wanted to get a clarity. Which part refers to a pending matter in phosphorus? Because I did not hear that, so that I answer precisely. That's all that I'm asking. Because what was read to me refers to what happened in phosphorus, not a pending matter. My understanding of a pending matter is a matter that is on the roll already. My understanding of the situation that took place on the 19th, the matter of Kwanongoma, as well as the one that they wanted to add accused on, he was never accepted to be added there. Hence, the matter was never involved insofar as Nongoma 163 of 4/2018. That's what I know. I don't have an indication that he was enrolled in phosphorus, and I don't have any information that there was a pending matter against him. That's why I wanted this clarity.
Bengidinga ukuchaziselwa ukuze ngizokwazi ukuphendula ngendlela efanele ngoba uma kukhulunywa ngokuthi kunaleli cala lase phosphorus elingazange lifakwe enkantolo, mina bengidinga ukwazi ukuthi kukhulunywa ngaliphi icala ngoba kunaleli cala lakwaNongoma bese kuba naleli cala la sephosphorus leli eyikuthi lakwaNongoma kula umangalelwa angazange libe liyiswe enkantolo noma libiliswe phambi komantshi. Ingakho bengidinga ukuchaziselwa ukuze ngizokwazi ukuphendula kahle.
Was it not your evidence that that matter was not placed on the roll, the Nongoma case?
Yes, it was not placed on the roll. That's what I said, my Lord.
Thank you.
Ngisho njalo njengoba ungibuza ukuthi angishongo nawo ukuthi leli yaqala lakwaNongoma alifakwanga kwamanje uthi yebo ngisho njalo.
And the accused was in custody under that case. Case number 163. Is that so?
Is it now?
Accused number 2, was he in custody, or that means he was arrested under that case number, that case number?
He was
Is that what we agreed on?
No, my Lord, we agree, but you see, you must put it into a right context because
No.
after, can I explain, my Lord? On the 16th, when he was arrested, I agree. He was in custody under Nongoma 163 of 4/2018. Up to the time he was taken to forced arrest, up for the magistrate court in forced arrest. Subsequent to that, later, he was then detained on a different case of Bukeng. So if the assertion is that on the 16th to the 19th, he was detained under Nongoma case, yes, we're on the same page. But subsequent to his release, he was never in custody on the same case number.
Siyavumelana uma ingabe sithi kusukela nge-16 ukuyofika nge-19 umangalelwa wayekade evalelwe ngaleli cala lakwaNongoma. Yebo, lokho siyavumelana. Kodwa into esingavumelani ngayo ukuthi naleli cala leli lasephosphorus silibandakanisa kuwo lawo malanga lawo kube kade sekavalelwe ngelinye icala.
Please understand me to say, accused number 2, when he was taken to Phosphorus police station, the case of Bukeng at that time did not exist. Did not exist at that time. When a decision was taken by the SPP not to place the matters on the roll in Phosphorus, the Bukeng case was not there, because a Bukeng case followed after accused number 2 was taken to the place where he was renting a place. Do you agree, sir?
I agree, but also,
Yes.
but subsequent to the decision of the prosecution, my Lord, of the SPP, that's what I'm saying, that after the matter was not enrolled, he was not in detention under Nongoma case. We're on the same page in that part. What I wanted to be clear is that there's no, because I understood the question to be saying he was in detention on the same case even after he was released. That's the part I wanted to be clear.
Bengifuna nje ukususa loludaba lokuthi sizwane kahle ukuthi ngemva kokuthi kuye wangafakwa enkantolo kuleli yaqala lakwaNongoma bese sekavalelwe ngelinye icala. Nangokho ummeli ethi lecala laseBukeng lalikade lingakafiki ngoba umangalelwa wayekade engakayiswa kule ndawo la bekade eqashe khona.
Yes, my concern is immediately after a decision has been taken that they will never place those matters on the roll, was accused number 2 was he not supposed to be released? Because those matters were not placed on the roll. That's my question.
Well, my lord, what I know, they were pending investigations, and I think Sergeant Khane can explain that better, because I don't want to speak on his behalf. But what I do know, there were pending investigations that needed to be done insofar as this matter, the 636. But he was not in detention. Where he was placed under arrest, it's when the ammunition was found later.
Manje bekungamelanga na ukuthi umangalelwa wesibili ngemva kokuthi lamacala angafakwa enkantolo bekungamelanga ukuthi akhululwe na uthi ubrigadier uSergeant Mohani uyena ongachaza kangcono kodwa bekade kusaphenywa ngalelicala u636 bese ke kulayi ukuthi ke kwavela futhi naleli yaqala lokuba nenhlamvu ezingasemthethweni.
I'm putting to you that aspect has been canvassed by Advocate Mshololo to Sergeant Mohani in relation to the status of accused number 2 immediately after the disposal of such matters or after these matters were not placed on the roll. This is what Advocate Mshololo put to Sergeant Mohani. Why was he not released? It's the same question that I'm posing on you. If accused number 2 was not placed on the roll in Phosphorus, why was he not released?
But he was released, my lord. When he was discharged to say the matter is not enrolled, he was released from the charges pending 163 and whatever that he was being pursued on. From then, another investigation started that the police were following. It's a different, it's not a continuation. And my understanding, my lord, there's no provision that says if you are released on this matter, then literally the police must let you go if they want to pursue certain things and then start all over again on another day. He was with them. They felt that now that it's been disposed of, let this information of the would be followed. I don't see anything that was procedurally done, my lord.
Lolu daba othi uSergeant Mohani uyena ongaphendula ngalo. Ummeli uMshololo uye wabuza ukuthi ngemva kokuthi lamacala angafakwanga enkantolo kungani umangalelwa wesibili angazange akhulume. Brigadier mayiphendula mababuza yena ukuthi kungani angazange akhulume. Uthi uye wakhululwa kodwa ngoba bebusanophenyo ingakho uye kwahanjwa naye bese bekusaphenywa lelicala elehudi kulayi ukuthi umangalelwa akazange akhulu kodwa kulamacala lawayana njengoba angafakanga enkantolo uye wakhululwa kulawa macala futhi uthi akazi umthetho othi uma ingabe umuntu kusaphenywa ngaye kwamele akhululwe bese bazobuya bamlande futhi ngemva kokuthi baqedile uphenyo.
That is the reason why we are going to place it before this honorable court and we are going to show this court that immediately after accused or during his arrest and after the matter was not placed on the roll, accused number 2 was still under unlawful detention. May I proceed? When accused number 2 was booked in back to Pretoria North, there's an occurrence book, I think it's MM, wherein he was booked back from investigation. May I confirm that, my lord? But I just want to reiterate on that. When he was booked in back to Pretoria North, under what case number was he booked in?
Can I have that exhibit, my lord, so that I can know what is written there?
When he was booked in.
Kuzwa ukuthi untanzi ngalesikhathi ebuyiswa ePretoria North yena wayekade evalelwe ngaliphi icala ngayiphi icase number usabhekwa laphayana.
On what date, my lord, perhaps if counsel can indicate what date is referring to?
No. I beg your pardon, I just want to confirm the OB, page 10. It's page 10, I'll check a little. When we return to... It's at page 10 of Exhibit 10. Page 10 of Exhibit 10.
What's happening?
My Lord, we need to confirm the occurrence book on the 19th.
Yeah, where is the exhibit? Because you say it's exhibit MM.
Yes.
Where is it?
On page
Is that
10.
what you have handed over to the brigadier?
It's page 10 of...
Yeah, but this one, my lord, I don't think this is the right date, because it refers to the 17th. The name of the inmate is different. It's a different person for theft. It's not, doesn't relate to accused to.
May the court bear with me. I have a side problem.
Why don't you put on spectacles?
No, they are aggravating the condition.
Is it?
Yes.
Because I know Clevers didn't want to put on spectacles.
No. They aggravate.
You see? Why, Mr. Mnisutega? You used to say you're a moho if you put on spectacles.
The 7th, I think I showed you. It's the 7th. On the bottom of the page.
Do you want me to adjourn so that you get your exhibits in order so that we know what we are doing? Because that exhibit is of a wrong case.
That one, my lord, but this one, the one that they give me the second time, it relates to accused number 2.
On the same date. Which date is
Well,
it?
it's a different, it's the 19th of June.
Is that what you're referring to?
That's correct.
19th of June.
Yes.
Okay.
To which police station was he booked in?
He was in Pretoria mode, my lord, on the 19th.
Nge-19 ke uye wafakwa kwesiphi isitokisi kuthiwa ePretoria North.
But this entry, my lord, is not about the detention, it's about the charging. When they were charging him in preparation of the court, it's not about the detention, the one that I'm referred to.
Kodwa la lokho ngifundayo akusiyi ngalesikhathi efakwa ummangalelo wesibini, ingalesikhathi bemthwesa amacala.
So it relates to him being charged in respect of what? Which case?
I suppose, my lord, it will be one Nongoma, although here is blocked because somebody used a pen. But I know when he was there, I know that, my lord, that he was charged for the Nongoma case, the 16304/2018. And Sergeant Mohane was the one charging him.
Is it after now the prosecutor in Boksburg refused to place it on the roll? Or what?
No, this is the morning, my lord.
The morning,
4:35,
okay,
when
fine.
they were preparing to take him to court.
Okay,
on the
fine.
19th. Yes.
Okay.
Nangokho kungabonakali ngoba kunala kunomuntu esule ngepeni, kodwa ngiyacabanga ukuthi la wayekade ethweswa leliyaqala lakwaNongoma bekusekuseni Ntathabusa ngo 25 to 3.
I request to an adjournment. my lord.
Yeah, we need that because
Yeah.
we don't know what's happening.
Yes.
Ngicela sibuye ngemva kwe
Yes, Mr. Mgomezulu.
Thank you, my lord. Thank you very much for your indulgence, my lord, to stand and step down. Mr. Brigadier Kininda, let's just proceed. May I just start? I just want to understand, when the confession was taken on the 19th now of June, was it taken in the morning or in the afternoon?
It was taken in the morning, my lord.
Ukugunjuluka laphayana nge-19 zika June kwayenzakala nini emini noma ekseni uthi kwayenzakala ekseni?
When were you in possession? When were you given the documents relating to the confession? Was it the same day or day after?
No, it wasn't the same day. It would have been maybe a day or 2 days. I had to go to Lieutenant Colonel Rapado's office in Enade to collect the confession form, my lord.
Unikwe nini ke leliya phepha? Walinikwa ngalelo nanga noma nini uthi bekungasingalelo nanga ngoba mina ngeke ngafanele ukuthi ngiye enkantolo yaka Lieutenant Colonel Rapado.
All right, I'll get into the confession part. But what I want to check is when the matter was not placed on the roll in phosphorus in the morning after the alleged confession was taken, was it your decision to direct Sergeant Mkhane and Sergeant Mabena to take accused number 2 to Rustenburg?
No, so let me start here, my lord. The confession was taken in the morning. The matter was not enrolled, I think, around afternoon.
Yes.
So when they were done, I think it was around 2 or so afternoon. Then the decision, my lord, I wouldn't say it was my directive, because what I know, I was made aware of the outcome and the fact that they needed to follow up on other investigation relating to accused number 2. And in addition to that, then the issue of the wood. That is why then I said I will meet them in Bukeng, my lord. So it was not one incident. Sergeant Mokane was sitting with a number of dockets that he wanted to follow also in that province. And then this one, the issue of the wood, then became also part of that. And I then said I will meet them in Bukeng police station, my lord.
Bekuyisinqumo sakho na sokuthi umangalelwa ayisiwe ePhukeng uthi cha kwakungasisinqumo sami uSergeant Mkhane wayekade namanye amadokodo abekade ewaphenya ehlanganisa nalo leli futhi kwavela nalendaba lehudi ingakho ke bagcine sebaya ePhukeng ngathi mina ngizohlangana nabo ePhukeng.
Now the issue of the hoodie, I cannot assume that it came up after a confession has been made. I'm concerned about after the matter has been withdrawn or was not placed on the roll. So the accused was not going to be released in any event according to your evidence because of those dockets that Mkhano had.
No, my lord. So the accused was released insofar as the matters that he was detained for. What then transpired after he was released, you can call it an interview, and it happens all the time, my lord. For example, people get involved in accident-related matters. They could call to the police station as suspect when they know very well that perhaps you may have been negligent. They will take a warning statement. That is an interview. You will be released. It doesn't mean that when you are interviewed on a specific matter, while you are with the police during that period, you can call it detention because you are with the police, but there's still a decision that the police, if they feel at that moment they can't move on you, then they will release you. It happens. So what transpired after the docket was not placed to the time when the second date kicked in, it was an interview on various matters and the cooperation that accused was giving. It wasn't a detention, because if it was a detention, then charges would have been said to him what is being detained for and would have been processed accordingly. It was a continuation of interview that started while he was in detention, because when I was following, my lord, an alibi that he gave us on the 18th, which said he was at work, that was part of the interview. It was not a detention. When I was with him, we went to his work. He was not in detention for this matter. It was an interview. We followed that alibi. It didn't materialize. So it was a continuation of interviews insofar as the hoodie and whatever the Sergeant Mkhane was following, my lord.
Ngemva kokuthi ummangalelwa lamacala lawa yanangafakwa enkantolo yena uye wakhululwa kodwa ubekade esahlonywa imibuzo kuyaye kuyenzeke umzekelo nawo ukuthi umuntu uma engaba kuyingozi yemoto lo muntu lo uyayabizwe ahlonywe imibuzo ukubheka ukuthi bekubani obekade enze iphutha nalokho mhlawumbe lo munye uyena obekade ebudedengu kodwa ke ummangalelwa naye wesibini ubekade ekhuluma esebenzisana nathi njengoba wayekade ebuzwa imibuzo kube wayekade engabaza kula ukuthi ubekade ezokuthweswa amacala ukuthi eliphi icala ekuthi usowuthweswa lona ke sesikuvalela ngenxa yaleli cala kodwa ngenxa yokuthi wayekade esebenzisana nathi ekhuluma uma silibele simbuza imibuzo kungakho siyasambuza leyo mibuzo kwathatha naleso sikhathi kodwa ngaleso sikhathi wayekade engakavalelwa wayekade nje ebuzwa imibuzo ngakho ugcine sekuthi kuvela naleliyana nasephukeni.
When it comes to interviewing a suspect, taking you back to the alibi that we had to follow up on, was there anything recorded, especially from the 18 when you interviewed accused number 2? Did you record the rights that you have explained to accused number 2? Did you record the conversation between you and accused or any kind of admission?
My Lord, I did make entries on my diary. I might not obviously, because it's the diary, you know, you summarize, and the copies which have been made to the defense is very clear of what was followed, and the fact that he made confessions, my Lord. And I gave the defense the copy of the diary of the 18th.
Bukhona la ukuthi kuye kwabhalwa khona noma kwayenzwa into ekuthi ibekade izobonisa ukuthi ukade ukhuluma nommangalelwa wesibini uthi yebo ngabhala kwi-diary yami nangokho ngabhalanga yonke imininingwane ngenxa yokuthi kwi-diary uyaye ubhale nje into encanyana ukuthi kwenzakeleni futhi leyo diary banikile abameli.
Alright. Accused now is released from Phosphorus Court. He is now conveyed to Rustenburg. You said it was not your instruction to take him to Rustenburg.
I'm saying, my Lord, I was aware. So if the position I was sitting in, I'm a commander. So obviously I didn't say they mustn't do it because I believed what they were embarking on was a legitimate follow-up or work-related issues. I was aware they were going there to follow up on what Sergeant Mukhane had insofar as the other investigations. And in addition, then the issue of the hoodie came up. That is why I had interest. My interest was simply on the hoodie because it relates to this matter. The other matter, Sergeant Mukhane, is something that you could deal with.
Nganginolwazi ukuthi ummangalelwa kwamele athathwe ayiswe ephukeni ngenxa yokuthi mina ngingumphathi ngiyengabona nokuthi bebakade bayenza into ehambelana nomsebenzi futhi uSergeant Mukhane wayekade enamanye amacala awaphenyayo kodwa kuye kwavela nalolu daba lwehudi ingakho ngiyengathi ngabona ukuthi bekulungile ukuthi baqhubeke ngalokho ngoba bebakade baqhubeka ngomsebenzi wabo.
So when you Sergeant Mukhane proceeded and which came to your knowledge that they went to Rustenburg, was there any warrant of search that was applied for?
No, there was no warrant of search that was applied for.
Manje ukuya kwabo ephukeni baye bafaka isicelo sencwadi egunyazayo ukuthi bayokhuthuza endaweni ethize uthi cha beyingekho leyo ncwadi leyo akuzange kufake nesicelo sinye.
So you wouldn't be surprised why accused number 2 was acquitted at Tlhabane Court due to the fact that there was no warrant of search, among other reasons why he had to be acquitted, among other reasons.
Yeah, my Lord, so no one knew that in his residence, insofar as I know because I was there, although I didn't go inside, the local police and my investigation team went inside. We didn't go there to look for ammunition. No one knew that ammunition would be found. It just so happened that when they were looking for the hoodie, then ammunition were found. And in that matter, in booking, that's why I didn't testify. I didn't submit a statement as well. So I don't know what reasons were given to make the court come to that decision. But yes, it was acquitted. I think that's justice. You have to prove your case beyond reasonable doubt. But I was not there. I was not part of those proceedings.
Tumeli ke yisona isizathu esenza ukuthi umangalelwa aye watholwa engenacala kulela cala lase ke uthi ke ubrigadier mina angizange ngingene phakathi njengoba bekade ukukhuthuzwa kuye kwangena amaphoyisa wakhona laphayana na lethimba lami ebengikade ngihamba nalo mina futhi angenzanga istatement nangalesikhathi siya besingazi ukuthi kuzotholakala inhlamba thina empeleni besithi siyofuna le yahudi angazi ukuthi eziphi izathu einkantolo yaphana ngazo ukuthi umangalelwa ukhululwa ngenxa yazo.
As we speak, this is what I also put to Sergeant Mkhane. As we speak, accused number 2 is facing this charge of murder under 636. That's the only matter against him at the moment.
Well, when we say this is perhaps the right context, my lord, it's the only matter that has been enrolled. But if you ask, is the only investigation that is facing the numerous of them, my lord. But yes, the only matter that is on the court roll, it is this matter.
Njengoba sikhuluma kwamanje umangalelo wesibini yena ubhekane nalecala lodwa elika 636 leli lokubulala uthi ubrigadier njengoba sisakhuluma kwamanje yilona lodwa elisafakwe enkantolo kodwa akhona amanye amacala ayikuthi kwamele asazofakwa enkantolo noma asapheli.
All right. Let's get into the confessions part of my questions. Have you taken a confession before?
Oh yes, I have, my lord.
Wena usuke brigadier wathatha istatement lesi umuntu ekhuluma egunyuluka uthi yebo.
Did you obtain a special training? Did you undergo a particular training relating to the taking of a confession?
Yes, especially the police training you undergo that my lord did explain. But I've also learned that at university, when you study law and law-related issues of confessions and so forth, it's covered in my lord. That's evidence. It's part of the legal studies, my lord.
Uye waqeqeshwa na uthi yebo njengephoyisa siyaye siqeqeshwe futhi mina ngafunda lokho njengoba ngifunda umthetho uma umuntu efunda ezomthetho uyaye aqeqeshwe nangayo le ndaba leyo ukuthi kubhalwa kanjani noma umuntu umbona kanjani uma ikuthi uyabona.
This question that I'm going to ask relates to accused number 1 and number 2 about the requirements or the process or the procedure of taking a confession. When you're taking, like as the lead investigator in the Senzo Meyiwa case, all right, it come to your attention that accused number 1 or accused number 2 wants to make a confession. Was it the right step to phone Mboto or to yes, you said you looked for somebody independent to take a confession. Ultimately, you got Mboto who took a confession.
So the question is, was it
the question right is it the right procedure that Mboto was supposed to take a confession after he had the discussion with you?
Yeah, my lord, I'll start with the last part, the discussion. The discussion between myself and Ken Mboto was not about the merits of the case. It was a request to say, can you assist in taking the confession, not discussing the matters of the case. That is why I indicated that he was independent because he did not work on this case. We never shared this information. It was someone independent. So that's my answer to the last part. But going to the first part of the question, my lord, yes, it is procedural, my lord, that when confessions, if you are involved in the matter, it is more reliable. It's a best practice, my lord, that you try and find someone independent to actually document that confession. Because, for example, I was a commission officer even then, but if I take it, you know the merits of the case, it's not neat. I think it's just a way, it's a best practice that is suggested that someone independent should be the one taking the confession. But obviously the sparking point or the starting point starts with me, because before you call this person, you have to certify yourself that the person you are interviewing is willing to freely, voluntarily, and without any undue influence to make such confessions, my lord, and is aware of his rights, then you move on to the independent person.
Le mibuzo elandelayo ngibuza ngaye ummangalelo wokuqala nowesibili, isikhulukazi lolu daba lokuthi nina benithi bayazithula kunezinto ebekade bezikhuluma. Manje umbuzo wokuqala ukuthi uthathe indlela elungile na yokuthi uze ushayele uKennel ukuze akube uyena oyikuthi ozothatha lezo statement. Uthi yebo, mina ngibona ukuthi ngithathe indlela elungile ngoba uKennel wayekade engasebenzi kulecala, futhi asizange sikhulume ngemininingwane yalecala, futhi yena wayekade engazi lutho ngalecala, bekuwumuntu ozimele phecelezi independent, la ukuthi vele kwamele kube umuntu ongazi lutho ngecala. Into yesibili, mina angizange ngaxoxa noma ngakhuluma naye uKennel ngalolu daba ukuthi nayi into engicela ukuthi uyiyenze ukuthi lo muntu uzothi ethi asizange saxoxa nokho.
According to your evidence, I doubt that you did not disclose the merits of the. I'll demonstrate why I'm saying that. I doubt that you did not discuss the merits of the case with Mboto. The reason being that, based on the question that I asked you, was Mboto a commissioned officer in terms of the procedure, being an independent person, qualified to take a confession from Mr. Spear? That's the question I'm asking. Was he not supposed to appoint another person?
No, I disagree. I totally disagree, my lord.
Yes.
So the last part, no, I did not, and I maintain that position. I did not discuss this case and what accused two intended to say. That's unethical. I wouldn't do that, my lord. I didn't do it. Secondly, Colonel Mboto, then he was a colonel. A colonel is a commissioned officer. And Section 217 is very clear, my lord. He's a justice of the peace. He's a commissioned officer, and by the virtue of his position as justice of the peace, he is allowed to take confessions.
uKennel Mboto wakade kuumuntu onelungelo na lokuthatha lesi statement besikade sizokhuluma umangalo wokuqala. Uthi yebo, ngoba yena kwakade kuyi-commission eyikuthi uma umuntu kuuKennel uyanikwa nalawo malungelo wokuthi angahle athathe inkulumo ezifana nalezo. Into yesibili, uthi ubrigadier yena uyaphinda futhi uyagomela ukuthi akazange akhulume noKennel ngalolu daba ukuthi umangalelwa uzokhuluma nalo udaba oluthize.
My lord, sorry, counsel. My lord, commissioned officers in the SAPS rank structure start at the rank of the captain. That's the first rank. Then you get majors. Then you get lieutenant colonel. Now you don't get majors. Then you get the colonel, the rank of Colonel Mboto, who is a middle manager. He's part of the senior management at that level. So he's quite someone quite senior in the police, but he is regarded as a commissioned officer.
Manje umuntu oyikuthi ubizwa i-commissioned officer esikhwayiseni umuntu oyikuthi uqala ku-captain bese ngalesa sikhathi esidlulile bekunabo major bese uthola lo kuyi-position eyaka-Colonel. La ukuthi uKennel wayekade enalo igunya lokuthi angathatha leso statement.
I understand. I'll get into. I'm glad you mentioned the and you explained what is the justice of the peace and the quality or the credentials that Colonel Mboto had in taking a confession. But I'll still maintain that he was not a candidate, not in terms of the credentials, in terms of the procedure. Before you proceed on that answer, is it fair for me to proceed on another question relating to what you were saying about Section 217?
Yeah, but before, my lord, let me answer the part that the counsel has raised to me. I disagree. Colonel Mboto, the only criteria he needs to meet is that he must be an officer. He was a colonel, far past the rank of a captain. He was a colonel, and as a result, by the virtue of that rank, it allows him to take a confession. That's all you need to prove them. And you simply have to be an officer. Automatically, you are then allowed to take the confession, any confession.
Into eyukuthi umuntu uyayidinga ukuze akwazi ukuthatha istatement salomuntu ogunyulukayo ukuthi umuntu kwamele abe uKenneth la ukuthi bese sekudala uKenneth edlulile kubukapteni manje yena wayekade enalo igunya lokuthi angahle alalele aphinda athathe statement esifana naso lesi.
So, in relation to Section 217, my Lord, I'm not sure if it would be prudent to ask about the interpretation of the provision to this witness because he seems to be knowledgeable about the law. If the court is
Are you disputing that Colonel Mboto is not authorized?
I'm not disputing that.
So this exercise is about what? Because why I'm asking this, Ramo CPD never queried the credentials of Mboto.
My Lord, I'm not querying the credentials.
No, I'm just saying.
I'm saying Mboto in terms of the procedure. After he received an information from Colonel Brigadier Gininda that somebody wants to make a confession, he was not supposed to take a confession. That's what I'm saying. Colonel Mboto, according to the procedure, was supposed to get an independent somebody who was going to meet with the person who wants to take a confession independently without knowing the because.
So wait. If I understand you well, this gentleman, Brigadier, you are entitled to take confessions. Is that not so?
That is so, my lord.
Right, but because you personally, as I was listening to you, but because you are personally seized with this letter, you wanted an independent.
Correct, my lord.
I may just mention that there's nothing debarring the law from you to take that confession.
Yes, my lord.
You know that.
I know that.
It's just best practice and it's advisable. The case, it's a Natal case, Kruger.
Yes.
The judge was I'll remember the judge. So, best practice says, give it to another person.
Yes, my lord.
And now you give it to a colonel.
Correct, my
Now,
lord.
the supposition or the assumption or the assertion by Mr. Gomezu is Mboto must get another commissioner.
That's correct. My
Is that
Lord,
the procedure, sir?
No, that's
Or
absolutely.
the law? Is it the law also?
It's not the law.
Okay.
It's not the law, and it's not even the procedure that is being followed, my lord. He's a commissioned officer, he's independent, and then he agreed to assist, my lord. I have taken confessions, I've been approached before, and it's the same principle. If I don't have any knowledge on the matter, and then I'll assist, my lord.
firstly, I'll disagree with the court and the witness on the basis that Colonel Brigadier Gininda, his credentials, yes, he can take a confession. But if he is a person of interest, he cannot take a
How is he a
confession.
person of interest? I'm quoting you a SCA case.
My Lord,
I used that case about 20 years back. And it's still the law. Okay, we can differ about that. It's still the law.
I'll
It's
make
just that
submissions.
it is advisable and best practice. There's best practice that because you assist with the matter, you must not take the confession. But there's no
Correct.
law disbarring you. But we can argue about that until it.com.
Yes. Yes, ma'am. May I proceed?
Yes.
Yes. In relation to text, section 217, especially where it deals with the justice of peace. And that justice of peace, according to the provision, it relates to the person conferred with such powers under section 334 of the Criminal Procedure Act. Have you read that provision?
No, I've not, my lord. The essence of what Section 217, my lord, I know. It's only the judicial officials that can take the part in justice of the peace, whom police officers who are commissioned officers falls under that category. Colonel Mboto is Justice of the Peace. He's a commissioned officer. He had a right, a legal right for that matter, my lord, to take the confession. He was legally qualified to do so.
Yeah, okay. In terms of the provisional, just because I have, my lord, a defense witness that will come and...
No, fine, you can argue that.
Yes.
Because you two are arguing about the law.
Yes.
So you can prove it by by whatever means. Okay, no problem.
And
As a court, please, we just want to point out the section 334 relates to the appointment of
334.
yes persons as peace officers. Not
Just
as,
read it to us
Not as justice.
so that we
of the
get
peace.
educated.
It's fairly long section.
No, read it, sir.
The headings: Minister may declare certain persons peace officers
Right.
for specific purposes. Subsection 1A, the minister may, by notice in the Gazette, declare that any person who, by virtue of his office, falls within any category defined in the notice, shall, within an area specified in the notice, be a peace officer for the purpose of exercising, with reference to any provisions of this Act or any offense or any class of offenses, likewise specify the powers defined in the notice. Subsection B, the powers referred to in paragraph A may include any power which is not conferred upon a peace officer by this Act. And subsection 2A, no person who is a peace officer by virtue of a notice issued under subsection 1 shall exercise any power conferred upon him under that subsection unless he is at the time of exercising such power in possession of a certificate of appointment issued by his employer, which certificate shall be produced on demand. Subsection B, a power exercised contrary to the provisions of paragraph A shall have no legal force or effect. Then subsection 3, the minister may by notice in the government prescribe A, the conditions which shall be complied with before a certificate of appointment may validly be issued under subsection 2A. Subsection B, any matter which shall appear in or such certificate of appointment in addition to any matter which the employer may include in such certificate. Then lastly, subsection 4, where the employer of any person who becomes a peace officer under this provision of this section will be liable for damaging arising out of any act or omission by such person in the discharge of any power conferred upon him under this section. The state shall not be liable for such damages unless the state is the employer of that person, in which event the Department of State, including a provincial administration in whose service such person is, shall be so liable.
Okay. So, sorry, so the criteria is the appointment
Yes.
the appointment.
by the minister or the authorized
Yes.
person.
Yes.
Let me just place it on record that Mboto produced, I don't know if you're there, he produced this certificate of appointment. And this evidence was basically that he showed his certificate, Mr. Nisi, you can correct me if I'm wrong, to the accused, before whom he was about to take a confession, and explain to him that I'm the justice of the peace. Here is my certificate of appointment. That's the evidence. And at that stage, Ramapsi PD never brought that argument. But you can bring it at any time to say Mboto had no lawful authority to take the confession.
My lord,
Then you can argue the matter. Okay, no
that's
problem.
correct. May I just place this on record?
Yeah.
When I came on board
Yeah,
on the evidence of Colonel Rappard,
yeah.
this is what I've advanced
Yeah, fine. I'm talking about Mboto.
And he talk about a certificate which he got from Ria Pierre,
Yeah.
something like that.
Okay.
There's that evidence.
Yeah.
But what I want to place on record is that what incapacitated I forgot the act and the year in which it was promulgated. But section 1 of the provision expressly states that the Justice Minister appoints a Justice of the Peace and issues a certificate after the appointment. The Justice, in terms of that, but in terms of section 217, read with section 334, this is the National Commissioner that appoints. You see the difference? In terms of section 217, read with section 334, Criminal Procedure Act, is the National Commissioner that appoints the Justice of the Peace. If I may remind the court about, sorry my lord, I used to...
Why don't you argue this thing? Because Mr. Mboto, Brigadier Gininda has told you what he thinks he knows, what a commissioner of Justice of the Peace is. And you are educating him that, no, you're actually wrong. Then you can leave it for argument. Because otherwise you are at university, all of you. I don't know what you're trying to prove. He says he knows that his Mboto was the Justice of the Peace. Is that not so? And that is authorized to take confessions.
Correct, my lord.
You say he's not a Justice of the Peace and he's not authorized to take confessions. You can argue that. And if you succeed, the so-called confession which is taken by Mboto will be rendered inadmissible. Okay, let's make progress, please.
Thank you, my lord. My lord, let me just continue. Thank you, my lord. I'll argue further.
Because it also depends which university were you at.
It doesn't mean, it doesn't relate to university.
No, I'm saying sometimes
you
were not at Oxford.
No, I'm coming from Vista University.
Oh, right.
So wait. Yes, that's where I graduated.
So isikolo somthetho asiphume sigcile kulolu daba ekuthi ulibele ukubuza ngawo ummeli ubuze imibuzo.
That's why I am going to discredit both Colonel Mboto and Colonel Rappert from taking confessions for both accused persons, accused number 1 and number 2. But let's move on. I just wanted to place it on record. Now, on the 30th of May 2020, accused number 1 is arrested just after lunchtime or during lunchtime, 1 o'clock or after 12:30. According to his version, he's taken to a place near a municipality area in Tembisa where he alleged that he was assaulted. I'm not intending to go back, but I just want to demonstrate something. Immediately after his arrest, he was taken to Fort Lawrence until he met you. When he met you, didn't have time to relax, didn't have time to think about his arrest. He didn't have time. His mental state at that time did not warrant for him to make a statement freely and voluntarily. Do you disagree with me? Because that confession was taken on the day in which he was arrested. Shortly after he was, maybe 4 to 5 hours difference.
Yeah. So, my lord, what I can say, obviously when he was arrested, I was not there. What I can testify about, and it's what I've said in my evidence in chief, when I spoke to him and gave him his right, when I met him for the first time, I did not see any signs of distress, someone who was in an uncomfortable position. I went even to an extent of asking the members who brought him to move away so that I can speak to him freely, voluntarily, and establish that he was not even under influence of alcohol or drugs. I did not detect such, and that version that he was assaulted was never told to me. Now that's the first part. Subsequent to that, my lord, we moved to the provincial office in Gauteng. He had time, he was not traveling with me in the car. It's about maybe 30 minutes or so from Postoras to that provincial office. He had time to think. And before I handed him over, when we arrived at the provincial office to the members of SWAT, I asked him, I warned him and asked him if he was still willing to proceed freely and voluntarily, and he was. My lord. So the version that he was, things were done in a short period of time, that's not correct. That's not the impression he gave me. I spoke to him, he was free, comfortable in making these assertions freely and voluntarily. I cannot talk to what happened in Tembisa, but he did not tell me that he was assaulted.
Ngeyithethi ummangalelwa uma eqeda ukuboshwa uSibiya yena uye wathathwa wayisiwa eThembisa washawa futhi makazolethwa kuweke bekangazange athole ithuba lokuthi acabange akhululeke acabange nangokuthi sekaboshiwe uboshelwe ini kwenzakalani uthi ubrigadier ke mina uma efika kimi ngiye ngakhuluma naye futhi nalabo abamlethile ngabacela ukuthi baphume ukuze azokhululeka. Uma ngikhuluma naye ngiye ngambheka angibonanga izimpawu zokuthi lo muntu lo akakhululekanga, angibonanga izimpawu zokuthi lo muntu lo mhlawumbe kunenye into emhluphayo emqondweni, futhi angibonanga nezimpawu zokuthi wayekade eshayile. Naye uma ngikhuluma naye akazange angitshele ukuthi ushayile. Ngoba ukusuka eFosloras ukuyofika eprovincial office la bengikhona kuthatha mhlawumbe isikhathi esingaba imizuzu engamashumi amathathu. La ukuthi kuleso sikhathi sona isikhathi la ukuthi mhlawumbe wayekade engacabanga akhululeke bese azilungisa nokuthi uma ngifika lapha kwamele ngifike ngicebe labantu into yokuqala ukuthi bafike bangishaya.
All right. About with reference to the diary that you recorded, can you please take your diary, you open the records of the 30th of May 2020 and please read them on record in relation to what you have recorded.
Duty on, that is 0730, Postoras case 636 of 1/2014, departure to Ereton, and then at 1410 got a report from Captain Yende and Mukula that the suspect Moses Sibiya has been arrested for the case of drug dealing and possession of unlicensed ammunition. I went to interview the suspect at Postoras around 1900 hours. The suspect implicated himself in the case after he was warned according to his rights. Colonel Mboto, I've mentioned his cell phone number, is requested to assist with the confession. He agreed. Says suspect must be brought to Diproof ACPS 30 May 2020, and then I've recorded just after midnight, 10 past 12, my lord. Colonel Mboto says he is done, and that I should come get the confession from his office, then 0130 duty off.
Futhi uyafunda ke istatement eyena sibhale kwi-diary yakhe nge-30 zika May ukuthi kwenzakeleni uma ngisicaphula nje uthi ngalelo langa uye waziswa ukuthi usekaboshiwe uMoses Sibiya futhi kunezinto afuna ukuzikhuluma kulaye ukuthi naye uye wathatha inyathelo zokuthi ashayele uKolonel Mboto ucingo amtshela ukuthi uzocela ukuthi amsize ngomuntu ofuna ukukhuluma indaba ezithize bese ke ntambama kulaye ukuthi uKolonel Mboto uye wamtshela ukuthi sekaqedile ngalesa statement yena bese wabhala nokuthi washesa ngobani isikhathi.
When you explained the rights, I beg your pardon, you explained the rights to accused number 1, and you told him about, I wouldn't say you told him about the requirements of Section 217, but what relates to taking, saying something freely and voluntarily, I assume this is what you told him. Was that recorded in your diary?
No, my lord. I've recorded that I've warned him according to his constitutional right. That is Section 35 of Act 108 of 1996. Insofar as the issues of him making the confession freely and voluntarily, the officer who is going to take the confession, for example, whether, like in this instance when I was talking to him, you have to satisfy yourself that this person is talking to you freely and voluntarily and without any undue influence. It's a requirement that you must meet, and that person is not under intoxication substance. Then you move on. So there's no, you can't tell that person to say, satisfy me that you are not, I must satisfy myself. Based on the question, his composure, the way he talks to me, the type, if I see injuries, obviously it's a sign that something is wrong. If I feel that he's crying or he's sullen somewhere, it shows that something is not right. So you must satisfy yourself that this person before you, indeed, is talking to you freely and voluntarily.
Indaba yamalungelo uyibhalile phansi kwi-diary yakho njengokuthi uye wamchazisela amalungelo uthi lokho angikubhalanga kodwa ngibhalile ukuthi ngiye ngamchazisela ukuthi unelungelo, unawonke amalungelo, futhi mina-ke kwamele mina nganeliseke ukuthi lo muntu engikhuluma naye ngempela uzimisele ukuthi akhulume engahoqwanga, futhi akusukuthi yinto ekwamele ibhalwe phansi leyo, yinto ekwamele nawe uyibone ukuthi lo muntu lo nanoma ekhuluma nawe ekhululekile. Uma ingabe kunezimpawu zokuthi mhlawumbe uthusele uyathuka noma ubonakala kuwumuntu engathi ufuna ukukhala noma kuwumuntu eyikuthi ekade elimele, bekwamele ngime bese ngiyabuza ke ukuthi kwenzakeleni noma kwenzakalani ngalendlela seyikuthi ubonakala uziphatha ngayo.
Brigadier Kininda, with due respect, sir, you are a person of interest under the case number, under the case number 636, and you were investigating the matter, and the information that you gathered from what you allege accused number 1 told you. There's no way, there's no reason for you not to be biased by saying you told him this, and if accused number 1 say he did not say this, obviously you will insist because you are the lead investigator in this case. So I'll argue at a later stage that your evidence is rational and I would say you are biased in any way from that evidence. What is expected of you, being the lead investigator in this matter, was not to keep him with you. The second reason why I'm saying this, the accused number 1 and number 2, at all various places where the alleged offenses were, alleged confessions were taken, were transported by your, I would say, people who were investigating in the same case. For instance, Sergeant Khumalo. I submit with due respect that that investigating officer, Sergeant Khumalo, was not supposed to be neither closer to these accused persons when they took a confession. Am I wrong, sir?
Yeah, well, we are wrong when you say I'm a person of interest. We can start there because my understanding of the person of interest is something different, my lord. So you're totally wrong. I'm not.
Sorry, a person of interest is a suspect.
It's a suspect.
Sorry.
So that you all understand what you're talking about.
May I correct myself
No.
with my poor English?
That's what it means.
No, but I want to correct it because I can see. You see, if every time say it might be mistakenly said, but if it is interpreted like either the witness or whoever intends to
Okay, fine.
to make
But
fool
that's
of
how I
myself,
understood.
but let me just withdraw that term or that word. It has been erroneously used,
Okay.
but no one must capitalize on that one. But if he says he is not a person of interest, it's fine.
Okay.
You are the lead investigator and you have an interest in investigating this matter.
Yes, my lord, I agree. I'm the lead investigating officer. That is why I said, after realizing that both accused were obviously on different occasions were confessing, I adopted an approach of getting independent officers as part of the bad practice rule. That was the whole idea. That is why there's Colonel Mboto, and then later there's Lieutenant Colonel Rapadu, and then Lieutenant Colonel Khatebe. That is the idea, my lord, because as the court has rightfully said, as a commissioned officer, I could have taken those confessions, but obviously because I've got knowledge, and as an investigating officer, when we are seized with the matter, is to prove that the crime was committed. So it will not be advisable that you do that because, you know, it's not the best practice way. But I adopted the approach that brings in people who are independent. That's what I've done.
Njengoba inkantolo bese seyishilo ukuthi benginayo imvume yokuthi mina ngingathatha lezo statement, kodwa ngoba ngingomunye wamaphoyisa aphenyayo noma iphoyisa eliphethe uphenyo lwalelicala, ingakho ngiye ngagcina sekuthi ngifuna abanye oza kwethu abekade bezosiza ukuthi bathathe lezo statement, ngoba mina akwamelanga ukuthi ngibe nendima engiyidlalayo kulezo statement, ngoba kuzosuka kube ingathi mina kunento engifuna ukuyenza, kodwa ingakho mina ngiyengafuna ukubona ukuthi ngenze isiqiniseko sokuthi utholakala abanye abantu ukuthi abaphenyi kulelicala.
And also, my lord, when I said, because I want Mr. Mgomezulu to understand this part, when I was correcting the part of saying I'm not a person of interest, it's what I said yesterday. It is not meant, or day before yesterday, it's not meant as an insult. My understanding in that time, because we're in court, if I concede to that, I'm exactly creating that impression that I'm a person of interest. I'm saying it with greatest respect because for me, that's what it says. And I'm correcting it that that's not the case. It's not meant to undermine him, so you shouldn't take it in a bad way. It's how I understand it, and I feel it must just be corrected. It's just what it is, nothing more than that.
Uma ngithi mina anginayo indima engiyidlalayo kuleli cala, angisho ngokudelela kumnumzana uMngomezulu, ngisho ngokuthi ngibeke izinto zicace, akusukuthi angimhloniphi umnumzana uMngomezulu, angayithathi ngokuthi angimhloniphi ngese baba uMngomezulu.
Thank you, Brigadier Keninda. We're coming from far with you. Brigadier Keninda, there's one thing that I want to know before we proceed. Remember when you read an affidavit, I think at the beginning of this week, there's an affidavit that you read when you brought an application for J50. I'm not going to J50 per se. I'm saying, remember that affidavit.
Yes, I do remember.
I want to know that affidavit. There's something that bothers me in that affidavit about the family whom accused number 1 was posting. You remember?
Yes.
In KwaZulu-Natal.
Yes.
As a result, that led him to that investigation to follow up to his arrest. So my concern is that information came to you on the 23rd of October 2020 for the first time.
No.
Or it's something that you got it before you made the affidavit.
Excuse me, I didn't know you were still talking. No, I got it before I made the application, my lord. So the application, I was seized with that information, statements were in the docket, my lord, which we've disclosed as well.
Ngiyenze le affidavit le ebengiyifunda ngomsombuluko ngemva kokuthi bese sengithole ulwazi izinto lezo i-statement zikhona phakathi kwedokodo. Ile affidavit uyasho ubaba uMngomezulu ukuthi la umangalelo oqala yena wayekade eziqhenya ekhuluma nabanye abantu abathize bomndeni wakhe abase KZN.
So that that those statements were obtained, was it before you took a confession or after you took a confession from accused number 1?
I know the one of Absalom Zungu, my lord, that I referred to, that clearly implicates accused 1 and 2, was taken before the confession was taken. I think it was taken the previous year. Confessions were taken in 2020. That statement, from my recollection, would have been in 2019, somewhere end of the year, November, December.
Statement is absolute Mzungu ngiyazikhumbula ukuthi sona sathathwa ngaphambi kokuthi abamangalelwa baye bayokunyuluka ngoba leso statement sayenzwa ngiyacabanga unyaka ka2019 uma soya emaphethelweni.
That means, in short, you had a prior knowledge prior to CBR talking to you or making such a statement to you in Force Lawrence. You already had a knowledge about
yes,
such
I knew
allegations.
I knew there were allegations, there were person of interest, my lord. Council will remember I've explained this, that the reason we focus on them is because there was this statement, there was information, there was this statement that we had which identifies them as being part of the perpetrators who killed Senzo Meyiwa. We did a cold case analysis around them. So when they were approached on various cases, yes, we were fully aware that there's allegation that they were involved in this matter, in the killing of Senzo Meyiwa.
Yebo ngalesikhathi ezele eza umangalelwa wokuqala bese sengazi ukuthi vele yena uyingxenye yalabantu ukuthi babulala uSenzo Meyiwa ngoba ithe uma kufika istatement kula ukuthi siye sabhekisisa abantu ukuthi kukhulunywa ngabo kulezi statement themayeza bese sengalo lolo lwazi.
And if you remember very well, I'm not intending to take you back from where I started my cross-examination, but there are certain things that are really necessary that should be placed on record so that we all understand each other. You'll pardon me for that. But may I remind you that, remember when we spoke about Section 219 of the criminal procedure?
My lord, I was spoken to regarding Section 219. I didn't say. I was asked to read Section 219, subsection 1, and then I think Mr. Ramsipil and then read Section 219. So that's how it came about.
Akusi mina ofundele nomthethosisekelo owaka 219 ngafundelwa njengoba bengade ngibuzwa imibuzo akusi mina ovele waqala wakhuluma nawo.
One of the reasons for my argument for these confessions to be inadmissible, to be made inadmissible, relates to Section 219, in that just a general understanding to mean a person making a confession, that confession is only admissible against him, not against other people. Did you understand that section?
Yes,
the same way I understand it.
Yes, and I did say that, my lord. I did say my understanding of Section 219. It simply says the confession made by accused 1 is admissible insofar as his consent. You cannot say now it's admissible on accused 2, 3, and 4.
Well, actually, the law says the statement.
The statement, yes.
Yeah, it's a case of state versus Molini.
Correct, my lord.
Extracurricular statement, Fortune Gwenya.
Correct, my lord.
Thank you, sir.
Uyazi ukuthi lo mthetho owaka 219 uthi uma umuntu esanda kugonyuluka lokho akukhulumile kuamele kusetshenziswe mayelana naye hayi abanye abantu. Uthi yebo ingalendlela enami ngichaze ngakhona ukuthi akusu ukuthi kwamele kusetshenziswe mayelana nalabo abanye ukuthi yena ukhuluma ngabo, kwamele kusetshenziswe kuye ukuthi uthi lezo zinto ziqondane naye hayi ukuthi ziqondane nalaba akhuluma ngabo.
And will I be right to say there is a supplementary affidavit or an additional affidavit that you have made other than the affidavit you used to bring the application for a J50? Is there any other affidavit that you have?
I've made numerous affidavits as the litigating officer on the docket. Others are changed, so it's not just one or two. It's various affidavits on the docket, which we've disclosed to the defense as well.
Uyavumelana nami na ukuthi ikhona enye affidavit ewuyenzile ngaphandle kwale ebokade uyifunda la emalangeni uthi yebo ngenze ama affidavit ambalwa kuleli cala?
Yes. With the leave of the court, my lord, I would request it's not going to be a futile exercise.
Which exercise is that?
Because no, I'm saying it's not going to be a futile exercise. I'm just asking the court's indulgence if a certain affidavit, but it does not contain the contents that were redacted.
You've got that affidavit?
To be read. It was made by a Brigadier Kinindam.
You have it in your possession?
Yes.
Can't tell you how to defend your clients. If you want to use it, use it. If the law allows you.
I'm asking the court if I can ask him to read it, my lord. I want to ask Brigadier to read that affidavit.
Where's that affidavit, sir?
It's A227. I believe.
What is exhibit what?
Exhibit. It doesn't have an exhibit, my lord.
It must have.
Because last time you said the witness can just read if the affidavit was made by him.
Now, because this witness says all the affidavits, he furnished you, or Mr. Baloyi furnished you with those affidavits. Is that what you're saying?
That's what I'm saying, my lord. Absolutely.
That's what he's saying. You've
Yes,
got all the affidavits.
That's correct, but I only request only that affidavit, not all. Only that affidavit to be read.
Mr. Baloyi, what's your view about that affidavit being read?
Well, if we have no problems with that, my lord, if they want to put it on that.
Okay.
Ummeli ucela ukuthi ubrigadier afunde nayi affidavit yakhe mshushisi ukuthi akunankinga angaqhubeka.
Okay. Is that the affidavit?
That's correct. Sorry.
Yeah, my lord. Yes, I can. It is A227.
A227.
My lord, I see it's 1 o'clock. I'm not sure if we can adjourn for lunch. Then we'll continue after lunch.
Okay, should we adjourn, Mr. Nisi?
Yes,
Indicated the investigation pertaining to that aspect of the affidavit is still ongoing, but secondly, we think it's unfair for a person or persons to hear their names be mentioned in court when they haven't been afforded the opportunity, when they haven't been firstly informed of that fact, and secondly afforded the opportunity to make representations as far as that aspect is concerned. We will then request, my lord, that is paragraph 3.5 of 3.6 of the statement, the entire paragraph.
Which statement? I don't know. I haven't seen the statement. Remember,
Yes.
you and the defense counsel refused me to see it.
Yes. Well,
So I don't know what you're talking about.
yes, my learned friend is on his feet, and I suppose he's going to have the statement proven. But that is the request that we want to make at this stage. Once the statement is proven,
Have you, sorry, have you spoken to your learned colleague?
yes, he signaled his intention to have that part read into the.
The very
into
part
the
you're
record.
saying it would be unfair for it to be
Yes.
publicized in the absence of having
Yes.
brought same to the attention of the person
Consent, yes.
concerned.
Indeed, Madam.
So, Mr. Tumezulu, what's your view?
My lord, the reason why I oppose the request by the state is because I also researched and checked the legal position regarding to the statements that were disclosed to me.
True.
That was disclosed to me, which were the affidavits of the investigating officer. And the state has not indicated any objection. And when an order was, or when the witness was asked to read the statement, then he raised that objection.
Okay, so
But I don't
whose statement
see-
is this? I don't know what you're talking about.
The statement is the statement of the investigating officer of Brigadier Kininda.
It's a statement by Brigadier.
Brigadier,
Kininda.
yes. Not of the witness.
What does it concern?
My lord, it relates to the participants in the commission of the alleged offense, and it won't actually be open to the court to give an informed judgment if there are certain aspects that are claimed to be privileged or to be redacted without reasons. In this case, an affidavit has been made. It's almost the same affidavit as the one that Brigadier Kininda has read on record. It's an additional paragraphs.
Does it concern a trial within a trial?
It is, my lord. It is, but particularly on the subject of 219.
Mr. Baloi?
As a court, please, my lord, we maintain that this information is irrelevant as far as the trial within a trial is concerned. But over and above that, my lord, we feel that it will be unfair to any individual or individuals to hear their names mentioned in court without them having been warned, and without them having been afforded the opportunity to come and make their own representations. We submit, my lord, that in a constitutional dispensation as ours, this cannot be allowed, my lord. There are no advantage, or there's no advantage to be gained by placing this information on record, as far as my learned friend is
When you say
concerned.
by placing it on record, I hear you. You know what, I've been lax in applying the law because I'm told, you're interfering. I've allowed so much leeway, people bringing evidence which has got nothing to do with the concept of a trial within the trial. Are you with me? Because this is a circumscribed interlocutory application. It's circumscribed, trial within a trial. And once you have used that evidence within a trial within a trial, you may possibly not use it in the general trial. Mr. Am I talking sense?
Yes, my lord.
But I've been lax. Mr. Gomezulu can tell you, he has gone to the Antarctic, and it comes back. For instance, now we're starting again in the Antarctic. You remember the statement you read?
Yes.
Which now he says it reminds him of something which you say accused number one was boasting about.
Yes.
Now, I don't know what he wants to prove about this, but I don't want to stop you. You can do what you think you must do. But when I come to adjudicate the matter, I'll be guided by the dictates of a trial within a trial. But I can't stop you from doing that because I'm told I'm interfering. So go ahead, do what you think you want to prove, sir. You don't want to encumber or abridge your testimonial duties as prescribed by your instructions. Okay.
Ngizokhumbula ngaphambi kokuthi siphume ummeli uNgomezulu wayekade ethe uBrigadier Gininda afunde istatement esithize. Manje uma sibuya umshushisi uyacela uthi kunengxenye zazo le statement acela ukuthi zingafundwa, akathi statement sonke singafundwa, uthi ingxenye ze statement zingafundwa ngoba kunamagama wabantu ayikuthi ayashiwo kuleso statement. Labo bantu ubona ukuthi izobakhinyebeza ngenxa yokuthi labo bantu abakatshelwa ukuthi kunamagama wabo kulezi statement, futhi abatshelwanga nokuthi nanamuhla kuzofundwa amagama wabo aphumele sobala. La ukuthi ubona ukuthi umshushisi ngeke iphathe labo bantu kahle, futhi nakuleli cala akusukuthi kunento ethize izoguquka ngemva kokuthi lawo magama ashiwo, kodwa ukuvikela labo bantu ngenxa yokuthi abaziswanga. Manje uyacela ukuthi yena leyo ngxenye yaleso statement ingafundwa. Ummeli wenu uthi yena ayifundwe, yena akabone kunenkinga nanoma labo bantu bangaziswanga. Inkantolo ithi ilibele yelule isandla ifuna ukuthi leli cala leli liqhubeke, kodwa kunenye indawo la ukuthi ilibele yenza izinto ngoba abameli bathi iyeka okunye okomthetho, kodwa manje inkantolo ibona ukuthi ingathi sekuzofikela la izogcina seyithi umthetho uthi akulandelelwe umthetho, ngoba sikulesi sigaba ese trial within a trial sokuthi kunobufakazi obuthize obukhulunywa ngabo. Lokho bufakazi khona kulesi sigaba bungasetshenziswa noma umuntu angakhetha ukuthi angabusebenzisi icala mase selizoqhubeka sesikuleyana ebizwa i-trial.
Okay, so you're at liberty, Mr. Ngomezulu, to do what your duty intends you to do.
May I please ask the court, my lord, the court, the witness to read the affidavit.
Read?
To read the affidavit.
Are you not going to prove the statement?
No.
Oh, he must read it.
Yes.
Yes, Mr. Baloyi, what is the law? What does the law prescribe?
Well, my lord, the law is very clear that no statement can be used unless it has been proven. And that is the steps that my learned colleague should follow.
Yes, Mr. Ngomezulu, you can start. You want him to read it, but
Just to read the statement. I won't
by not laying down the
now
legal
or the
protocol.
The basis. My lord,
Because then it is not a sworn statement. You understand it?
it is a sworn statement.
No, it is sworn until. It is sworn.
May I
But
lay
until, wait. If you want it to get onto the record,
Yes.
then you've got a legal duty to prove that the law was complied with when the statement was made
Yes.
to be a sworn statement.
Correct.
Okay, fine. You can proceed.
Thank you. Sir, Brigadier Gininda, is it correct that you are the deponent of the statement A227?
That is correct, my lord.
Kuyiqiniso ukuthi wena obhale lesi statement uthi yebo iqiniso.
Is it correct that you actually read this? Sorry, you're the one who wrote the statement by yourself.
That is correct, my lord.
We osibhale ngokwakho uthi yebo yimi.
So did you read back the statement to the satisfaction of the contents that are contained therein?
No, I made a statement, my lord. It's my statement. I
Yes.
made it.
Usifundile le statement ngemva kokuthi usibhale uthi mina yimina ongisibhalile bekungenasidingo sokuthi ngisifunde.
Did you sign the statement
Correct, my lord.
Usayinile uthi yebo ngisayinile
in the presence of the Commissioner of Oath?
That is correct, my lord.
usayine ngaphambi komuntu obekade esichithiza istembu uthi yebo.
Is the statement binding in your conscience?
That is correct, my lord.
Leso statement siphethene sihlangabezane nonembeza wakho uthi yebo.
So do you correct the truthfulness of that statement?
Yes, I do, my lord.
Leso statement siyiqiniso uthi yebo.
The date in which you signed the statement?
It was 20 November 2020, my lord.
Usayine nini uthi nge-20 zika November 2020.
Thank you, my lord. I beg leave for the witness to read the statement on record.
Okay, sir.
Cela ukuthi asifunde uyafunda ke uBrigadier Gininda.
My lord, it reads as follows. I, the undersigned Bongani Nicholas Gininda, state under oath as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit of the National Commissioner with the rank of a colonel. I've mentioned the service number, my lord, and the telephone number, which I would like to skip. Paragraph 2, I am the lead investigating officer of Phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. This deceased was shot at the house belonging to then his girlfriend, namely Khumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the suspects was carrying a firearm purporting to be a revolver. The accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as tall, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased, Senzo Meyiwa, on close range on his chest and exited at the back of his body. The second suspect, who is now accused 2, focused on the rest of the witnesses in the process. One cellular phone belonging to Miss Kelly Khumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others a hoodie, were standing hidden away, but only a few meters from the crime scene prior to the incident appearing to be typing on their cell phones. It is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikit was compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 20:30 and 2100 hours. The deceased was declared dead on arrival at the hospital at 21:15. Investigation further revealed, this paragraph 3, my lord. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost, covering the area of Phosphorus Hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under oath indicates that the planning of the offense and gathering after the incident took place at Phosphorus Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa. The suspects are as follows. 3.1 Musika Ukhulelwa's Thembas Biya. He was first linked to this offense by means of witnesses' statements under oath. The accused boasted to individuals closely associated with him in KZN Homeland as to his involvement together with Mafiga, herein under suspect 2, Carlos herein under suspect 3, Mapisa herein under suspect 4, and Nkani herein under suspect 5, into the killing of the deceased. A dispute ensued between these individuals, and the closely associated individuals disclosed to the SAPS the admissions this accused made to them. The accused was further linked with circumstantial evidence wherein he, minutes after the incident, made disclosures and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo, even before the death was reported in the media. He is further linked by means of a formal confession he made to the commissioned independent officer on the 30th of May 2020. In this confession, he clearly implicates Ms. Kelly Khumalo as the person who gave them the instruction to kill Senzo Meyiwa. The suspect further made a formal pointing out the scene collection prior to the incident, the gathering of the outside of the house during the assassination, and the dropping off of the accused at the cell phone tower referred to herein above. The pointing out by this accused identified the exact scene, place, however, the scene, place, house where the deceased was shot. The accused identified the place, position he held when this offense was committed. In place in terms of his pointing out is accurate and meshes out the crime scene. The pointing out was made to another commissioned officer on the 6th of June 2020. Here, my lord, is the mistake. It should be the 5th of June, because that's when the pointing out was made.
Okay.
The accused was further linked by a witch doctor he attended prior and after the killing of Senzo Meyiwa. The said witch doctor's premises were identified by this accused. After the said doctor was found, the said doctor was taken to our offices for interview. It was during this movement in the office that the witch doctor came across this accused. The said doctor recognized accused in my presence and said he recalled also that he once came with Mapisa from Phosphorus to him, but this accused denied the involvement of Mapisa and insisted to the witch doctor that he came only with the Buthelezi brothers. At this stage of the investigation, the presence of Mapisa is one of the suspect. The name of Mapisa is one of the suspects that was known to me, but it later became evident that this accused was hiding the presence of Mapisa to the police. The accused was initially confronted with the identikit of the suspect with the dreadlock as the person resembles his looks. The accused was formally warned according to his constitutional rights prior to the questioning. It was under these circumstances that he decided to make a confession, but clearly stating that he was not the shooter and that he was standing outside. He further indicated that Senzo was shot on the chest. He was confronted with this knowledge and how he know the exact spot of the wound if he did not do it or was not in the house. He then implicated one Marco Buthelezi as the shooter and the person who told him. He further said he was willing to make a confession and pointing out at the crime scene freely and voluntarily without any undue influence. 3.2 Bongani Sandisontanzi. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identity kit complied through the description to the witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and the compiled identity kits. During the questioning and subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. The accused was warned according to his constitutional rights and then interviewed about the suspicion that creates the belief that he was involved in the death of Senzo Meyiwa. The accused immediately said that he remembers that the incident took place on the 26th of October 2014 and that on that specific day he was at work in Rustenburg. I requested the accused to identify the said place of work, which he voluntarily identified. Upon proceeding and arriving at the premises of his previous employer, it was discovered through evidence obtained under oath that this accused lied about his whereabouts. In fact, he was on absent without leave from the 25th of October 2014 to the 3rd of November 2014. Hereafter, the suspect indicated his eagerness to confess as to his involvement in the matter. The suspect made a commission to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Magistrate Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as tall, slender built, which came into the house. He also implicates Ms. Kelly Khumalo as the person who gave the order to kill Senzo Meyiwa. 3.3. Mtobisi Prince Mngube, nicknamed Carlos. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was a sentenced prisoner serving 35 years in prison for the murder committed in 2015. Ballistic tests reveal that the same firearm used in the murder for which the accused was serving his sentence was used in the murder of Senzo Meyiwa. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloads of this cell phone were done. Photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver entering the house. Photos downloaded taken of the accused by him, selfies, during the day of the 26th October 2014 matched the description of the suspect who had the firearm with red locks, big eyes and with gold teeth. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Evidence confirms that he is Zulu speaking. In fact, all accused in this matter are Zulu speaking and knows each other. Photos were equally found of the murder weapon used in the murder of Senzo Meyiwa. A photo containing the exact bag of money similar to the one found in Ms. Kelly Khumalo was found. There is also another selfie that was taken by the cell phone of this accused, which shows him having a gold tooth. The gold tooth was one of the things that was noted by the witnesses. It is imperative to mention that this accused currently does not have the gold tooth as well as the dreadlocks, but evidence shows that he had both in 2014, October 26. Mtuguziseni Zipozonke Mapisa, also known as Mapisa. This suspect, this is 3.4, my lord. This suspect is linked to this offense by means of certified sworn statements and referred to herein above. He is further linked by means of a confession he made to a private person, a close friend, about his involvement in this matter. The confession came about in that this suspect requested this private person to establish the reason why suspect Mafika was arrested. The information disclosed was that the suspect Mafika was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person return disclosing this information to suspect Mapisa, did Mapisa instruct the private person to return to and inform suspect Mafika not to disclose his Mapisa involvement as he, Mafika, will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside their house. He was also armed with a small firearm. 3.5, Sifokuhle Nkani Ntuli, also known as Nkani. The suspect is linked by means of a sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo with registration CT49YZGP before, during and after the murder of the deceased. Evidence also reveals that he drove the car with the suspect to the crime scene and back to Phosphorus Hostel after the incident. The accused is linked by cell phone analyst by means of a cell phone links to Miss Kelly Khumalo. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafika, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the vehicle prior to and after the committal of the offense in the company of the referred suspect above. The above suspects are also known as hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35/108 of 1996 by me and questioned for this incident. Some of the suspects made confession to independent commissioned officers as well as magistrate as indicated above. Others made confession as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence on the cell phone analyst links him to Kelly Khumalo. 3.6, Nonhlanhla Kelly Khumalo. 4 cell phone numbers that she did not disclose to the police when this incident took place. These numbers were discovered by the XDS system used by the cell phone analyst and subsequently linked to her activities. The numbers are as follows: 079-494-4358, 073-451-5017, 073-886730, 061-456-2108. Investigation further revealed that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis, her cell phone memory album has the same photo of a see-through bag containing cash, notes, and in the exact position or location or spot of that of accused number 3. There is no reasonable explanation as to why Kelly Khumalo will be in contact telephonically with the headman or killers of a boyfriend and share the same picture of a bag full of money. Communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it. It is apparently clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all these facts, an inference can be drawn that she meant killing him. Cell phone record shows that after the incident took after the incident took supposed place, she phoned a number of people from 082-703-4358 number, but no call was made to emergency services. She also subsequently went to the witch doctor for cleansing, as was also done by the other accused in this matter. The statement of Mr. Mkhize, who is an expert in this matter, clearly indicates that this is normally or how it this is not normally or how it should be done, especially in if one is innocent. Evidence by means of a sworn corroborating and independent witness's statement establish a causal link between the offenders and the offenses of murder, robbery and aggravating circumstances, possession of unlicensed firearm and unlawful possession of ammunition and conspiracy to commit murder. Ms. Kelly Khumalo seems to be the trigger point of this murder. Then paragraph 5, my lord, which is the last one, is basically the oath, and I signed. It was commissioned on 2020 November the 20th.
Yeah, just one query before Mr. Gomezulu starts. You read, you say there's a casual relationship, it's causal.
Causal relation. Thank
Please,
you, my lord.
because I understand a bit of English.
Thank you, my lord. Causal relationship.
Right.
My-
Yes, sir.
Sorry, my lord, there's one last page at the back which I
Yeah.
didn't go to. It's basically a J50 application warrant which was not
okay.
signed for
Okay.
Ms. Kelly Khumalo. So, because it forms
It
part
is
of
in the
it's
list.
part of the statement.
Yeah, it's part of it. Okay, fine, I hear you. But I say it's in the link of exhibits.
Yes, my lord. I suppose. I wouldn't know.
Yeah, okay, fine. Yes,
Manje-ke,
yes. Oh yeah, by the way, you've got to interpret.
as the court business, lesi statement siyafana cishe naleziyana esifundwe ngomsombuluko. Lesi sihluka nje ngokuthi sifaka igama ukuthi umangalelo oqala uye washo ke ukuthi ubani umuntu obekade ethe bayobulala umnumzana uSenzo Meyiwa. La ukuthi umangalelo oqala uchaze ukuthi bekade bethunyelwe uKelly Khumalo eyikuthi uye obekade ebatshele ukuthi babulale uSenzo Meyiwa. Nomangalelo wesibini naye uma eqhubeka ngemva kokuthi sekagunyuluka kulaye ukuthi uye wachaza naye ukuthi uKelly Khumalo uyena obekade ebatshele ukuthi bayobulala umnumzana uSenzo Meyiwa. Bese ke umangalelo wesithathu naye uyabandakaneka kulo lelicala leli la ukuthi yena umangalelo wesithathu uCarlos kuthiwa ubekade naye ekhulume nabanye abantu abathize labo bantu nabo bayenze istatement bafunga phambi kwamaphoyisa ukuthi lezi zinto abazishoyo kuyiqiniso futhi kuthiwa uCarlos kahle nani nonke nikhuluma isiZulu futhi kuye kwashiwo ukuthi efonini kaCarlos yekwatholakala isithombe ebesikade sibonisa isikhwama esithize ebesibonakala sinemali ngaphakathi. Leso sithombe satholakala efonini yakhe uCarlos eyikuthi ithe isikhathi masiqhubeka kuye kwatholakala nokuthi futhi efonini yakhe uKelly Khumalo wakade kunaso leso sithombe esifana ncamashi nalesiyana esikuyifoni yaka Carlos. Futhi ke umangalelwa wesine ke yena utholakele ngokuthi naye ubekade ekhulume nomuntu othize. Lo muntu wagcina sekambuza ukuthi manje akungichazisele kufike kanjani ukuthi umafika agcine seyikuthi uyaboshwa. Umaphisa wamthumela ke wathi awuke uye uyohlona ubuze imibuzo ethize. Lithe makabuya lo muntu lo ongakhulunywanga igama lakhe wathi yena ukhulumile nomafika umafika umtshele ukuthi uboshwe leli yaqala futhi umaphisa wathumela lo yamuntu wathi hamba uyomtshela umaphisa ukuthi angakhulumi ukuthi kwenzakeleni kuthunyelwe ubani angalinge nje akhulume ngoba uzogcina naye sekabulawa. Umangalelwa wesine umangalelwa wesihlanu yena ubandakanyiswa ngokuthi uyena obekade eshayela imoto ebekade kuyinhlobo ye-VW Polo number plate yakhona yi-CT79 YZGP wabonwa ayishayela ngaphambi kokuthi kwenzakale lesi sigameko nangemva kokuthi isigameko senzeke uye wabonwa ekade eshayela leyo moto futhi naye uye wacebisa ukuthi uma fika angakhulumi ukuthi kwenzakeleni ngalesikhathi kuze bekubulawa umnumzana uSenzo Meyiwa. Kuthiwa ke abamangalelwa bonke bona baziwa ngeinkabi ebezikade zinokubulala abantu uma kunezimpi zamathekisi. Kwacebiswa futhi uma fika ukuthi angalinge akhulume ecetshiswana futhi umangalelwa wesihlanu ukuthi angalinge akhulume ukuthi kwenzakeleni ngoba naye angagcina seyikuthi uyabulawa. Bufakazi bubonakalisile futhi ukuthi uKhelly Khumalo naye uyabandakanyiseka kuleli cala. Manje ke uKhelly Khumalo yena kunamanombolo athize ayikuthi uye waxhumana nawo kodwa kuthiwa umuntu omsulwa akwamelanga ukuthi ayenze kanjalo uma sekunecala sekunengozi evelile. Nawa amanombolo kuthiwa mane nombolo yokuqala 079 494 4358 yesibini 073 451 5017 yesithathu 073 388 6730 eyokugcina 061 4562104. Lawo manombolo akushiwo ngokuthi awakabani kodwa kuyabonakala ukuthi uKhelly Khumalo naye ubeke washo ukuthi ubekade ekhulumisene nabamangalelwa ngoba kunala ukuthi ithombe nazo ziye zatholakala la umangalelwa wesithathu atholakele khona kukhulunywa ngalesa sithombe salesa sikhwama lesibekade sinemali futhi uma kuqhutshekwa kuhlolwa i-cellphone yakaKhelly Khumalo yokwabonakaliswa ukuthi inamba eyikuthi ubekade eyisebenzisa beku 0827044358 la ukuthi naye ke uye wagcina seyikuthi uya enyangeni eyozigeza njengoba nabo abamangalelwa bebakade bayile enyangeni bayozigeza ngaphambi nangemva kokuthi kubulawe umnumzana uSenzo Meyiwa. Bufakazi buyabonakalisa kwi-statement eyikuthi umuntu uye waya emaphoyiseni yena wafunga ukuthi bekade kunecala lokubulala futhi necala lokubamba inkunzi kuhlonyiwe nokuthi bekade kunecala lekubanjwa isibhamu ngendlela engekho emthethweni nezinhlamvu bezikade zingekho emthethweni ukuthi kuyobulawa umuntu. uKhelly Khumalo kubonakala ingathi uyena umuntu oyikuthi uye wathumela lezi inkabi ukuthi ziye ziyokwenza lelicala. Ubrigadier ufungile naye ukuthi zonke lezi zinto ezibhalwe kulesi statement iqiniso futhi uthi nasi esinye kodwa lesi asizange sisayinwe bekade kuyincwadi ebekade ecela ukugunyazwa kokuboshwa kukaKhelly Khumalo as the part of this thing.
Okay, thanks. Mr. Khumalo.
My Lord, thank as the court, please. May I request the statement to be handed in, my Lord?
Yes. What will be the exhibit?
Exhibit ZZ.
ZZ.
We just want to remain one, my learned friend, that it refers to the confessions and the pointing outs which are the subject matter of this trial within a trial, and which might be to the detriment of the defense.
What do you say about that remark by Mr. Baloyi?
I have no response.
Hello?
I have no response, my Lord, to this.
What do you mean you have no response?
If he says to the detriment, the time has come to argue this matter.
No, he says there's a potential prejudice against the disclosure of this statement vis-a-vis your clients, accused 1 and 2. Is that what you're saying, Mr. Baloyi? Right. So,
Yes.
I mean, I did say to you, you have veered off from the principles of a trial within a trial.
Yes.
So I don't want to circumscribe your cross-examination, whatever, but you have been forewarned. And now, even your learned colleague here is saying the disclosure of this statement may presage the contents of the alleged confessions. Are you with me?
I'm with you, my lord.
Okay, so you're free to cross-examine.
Thank you.
Ummeli ucela ukuthi lesi statement sinikezele kwinkantolo njengobufakazi umshutshisi uyaphakama uthi ucelisa ummeli ukuthi lesi statement uma sinikezela kwinkantolo azi ukuthi singahle sifake abamangalelwa wokuqala nowesibini esimene siqayi uma lesi statement sifakwa njengobufakazi kwinkantolo.
Okay. Thank you. Court pleases, my lord. The attached document at the back of the statement was not part of the document attached when you brought the application for a warrant of arrest.
I don't. Can I ask defense, my lord, to clarify perhaps the question? I don't follow.
I'm saying, when you brought an application under section 43, the 23rd, if I'm not mistaken, October, the warrant of arrest, the J50, bearing the name Kelly Khumalo, was not part of the documents that we...
No, it wasn't, my lord. That statement was made in November, and the application for J50 for Kelly Khumalo was made at that stage, my lord, November 2020.
Le ncwadi ebe ucela ukugunyaza ukuboshwa kuka Kelly Khumalo beyikade ikhona na ngalesa sikhathi wenza le statement cha le statement siyenziwe ngo-2020 le ncwadi yona iyenziwe ngemva kwalokho.
Thank you. May I proceed to establish from your brigadier in terms of the discretion? Did you take any discretion to stay or not to apply for a warrant of arrest against Kelly Khumalo?
No, I did not, my lord. As I indicated, it was this case, this matter was a prosecutorial-driven investigation. Now, prior to the application of the warrants that was made on the 23rd of October 2020, I've indicated in my evidence in chief that I made presentations, or not presentation, a memorandum to the DPP, where the North Gauteng one, where I indicated all the evidence that we have on all implicated people, including Ms. Kelly Khumalo. She is there. A decision was taken at that time that these are the people that must be indicted, and that is accused 1 to 5. I cannot disclose further details in terms of our discussion with the NPA, my lord, but there were certain things that needed to be looked into insofar as Ms. Kelly Khumalo. Then the following month, when we've covered some more grounds than then, that's when now I made a presentation again to say this is where we are and we're making this proposal.
When brigadier uye wathatha isinqumo noma wacabanga ngokuthi mhlawumbe le ncwadi le egunyaza ukuthi uKelly Khumalo aboshwe ingahle iqhubekiswe na uthi cha angizange mina nyenze kanjalo mina bengikade ngiphenya lelicala kulibele kuphenywa yonke into futhi ithema kuqedwa kula ukuthi mina ngiye ngaya kubaphathi babashushisi ngiyofaka isicelo sokuthi naba abamangalelwa ekuthi mina nginabo nginokufakazi nakubo ukubandakanisa naye uKelly Khumalo la ukuthi ke bona abashushisi baye bathi naba abantu ekuthi bakwamele bashushiswe okwamanje njengoba kungakaqedwa uphenyo yena ubrigadier akazange athi akushushiswe labantu uKelly Khumalo yena ayena.
In the light of the fact that of the evidence that accused number 2 made 2 confessions, one before Colonel Rapatu and the other one before Magistrate Mrs. Cronje, was it also your discretion that that it was not necessary for accused number 1 to be taken before another magistrate after he has made a confession or the alleged confession before Colonel Mboto.
No, my lord. I think I've explained this part. So the magistrate part for accused number 2 came as a result of a 105A communication between ourselves and the state prosecutors. That's how it kicked in. I was satisfied with the confession that was made because it missed the merit. It's a commission officer, he's a justice of the peace, there was a confession. Subsequent to us engaging with the attorney for accused number 2, and in discussion with the plea bargaining with the state, it flowed from them, and then there was this confession for accused number 2, which was not the case with accused number 1.
Awuzange-ke ucabanga ukuthi ummangalo lokuqala naye bekwamele ayiswe ayoyenza ayogunyuluka phambi komantshi njengommangalelo wesibili. Uthi ngemva kokuthi bese sesikhulumisene nabashushisi kulayi ukuthi ummangalelo wesibili bese sesiye sathatha waxoxwa futhi njengoba bekayenze nalesi sicelo sokuthi yena kube ufakazi kugcine seyikuthi unikwa isigwebo esingaphansi. Ngemva kwalokho kulayi ukuthi siye sathi sanelisekile ukuthi ummangalelwa uqedile ugunyulukile bese kwathathwa ke nalesi yasinqumo sabona ukuthi naso ummangalelwa wokuqala ubekade egunyuluke kumuntu onayo imvume yokuthi angalalela istatement esifana nazo lezo lo muntu ngikhuluma ngaye uKenneth.
Thank you, Brigadier. I'm well aware that such an engagement was done between the representative of accused number 2, as you say. But I just want to get into the point of accused number 2 being represented. The evidence, according to the state, is that the said person on the 24th of June 2020 was present when accused number 2 make a confession or the alleged confession. Secondly, the evidence that the state has is that the same attorney also participated in the plea bargaining agreement, and to the extent that such a decision or such a plea bargaining agreement was not concluded or finalized.
So
the question,
must I comment?
Yes,
What is the question?
I just wanted to ask a question. Throughout the involvement of Mr. Mjiako, the alleged Mr. Mjiako, firstly, before I proceed with the question, was the agreement concluded, the plea bargaining agreement, in terms of section 105, capital letter A?
My lord, yes, it was. So there was. It was not only Mr. Mjiako when the 105 capital A was involved. There was also another advocate who came on board. I mean, those are the issues that because they form part of the discussions, and there was proposals and affirmations of standing with the confessions that were made by accused to the magistrate and Lieutenant Colonel Rapad, and the proposal of him testifying against his co-accused for a specific sentence, which we were of the view as the state that we are not happy with that sentence. The deadlock, it was concluded, because there's a formal communication, it was concluded the difference was on the proposed sentence from the defense side in terms of what accused 2 is prepared to do in relation. There was a specific sentence that is sent to us and said, I'm prepared to serve this sentence and in this manner, and then in return, I will testify against my co-accused, etc., etc. So it was formal and finalized.
Yebo bekuye kwaqedwa inkulumo phakathi kwabashushisi amaphoyisa nommeli ummeli umjiyapha akusiyena yedwa khona omunye ummeli into bengikade ngingafuni ukuyiveza kodwa ngoba seyabuzwa nakho-ke kwamele ngiyiveze ukuthi siye sahlulana nje uma sesekufika kwisigwebo lesi ummangalelo wesibini wayekade ethe yena uzimisela ukuthi angasiya ejele noma ahlale endaweni ethize noma ahlale kanjani leso sigwebo leso kula siye sahlukana khona futhi ummangalelo wesibini yena bekathe uzimisela ukuthi angayenza leso sigwebo bese uyabuya abe ufakazi ngombuso afakaze kulento ukuthi abamangalelwa abane laba abanye bayenzile kulo lecala.
My Lord, it's also prudent to mention that in this communication, I remember one document, he clearly admits that he stands with the two confessions that he made. And these discussions, my Lord, were taking place after the matter was enrolled. It was not discussion that took place before the first appearance on the 27th of October 2020. While the matter was going on, after the first appearance, second appearance, those discussions were taking place so that one can decide where he must be placed. That is why at some stage the court would have seen that in the occurrence book he spent also a lot of time in police stations because there was these discussions and it was put by I think on the first appearance the request was made by him in court. Mr. Mshalolo was there for accused to be kept at the police station. It was because there were these part of discussions that were taking place confidentially.
Futhi le inkulumo lezi ziyenzakele leli cala liselingenile enkantolo akusukuthi beqalwa ukuthi abamangalelwa bavele enkantolo bese sekulibele bevile enkantolo ingakho ummangalelo wesibini yena uNtanzi wayelibele ebekwe esitokisini samaphoyisa isikhathi esiningi futhi uthi nommeli umshololo wayekade ekhona ngalesikhathi uNtanzi eyenza leso sicelo akusukuthi bavele bayicabangela ukuthi uNtanzi yena angafakwa nabanye esitokisini kungenxa yokuthi bekusakhulunyiswana.
Thank you.
Once again, we just want to sound a word of caution to my learned friend that in terms of section 105A, if there's a proposal, a 105A proposal, if it falls flat, reference may not be made to it in any other manner, but if he elects to elicit that information, he does so at his own peril.
Umshutshisi ucela ukucebisa ummeli uMngomezulu ukuthi le mvumelwano leyana noma le yankulumo akusiyinto ukuthi kungahle kudingidwe ngayo kodwa uma ingabe uyafuna ukuqhubeka lapho angahle ahlabele umgaqo.
Thank you, my Lord. I'm not intending to get into the gist of.
Oh, you're not disputing it.
No.
One matter to not intending to get into the gist of it.
Not that I'm not disputing
Okay,
it. Not that I'm not disputing it. My, in fact, I'm concerned about the representative, the legal representative, or the mandate that Mr. Mjiako alleged to have been given by accused number 2 to represent him. That, according to you, Brigadier, is there any power of attorney that was furnished by Mr. Mjiako?
My Lord, I don't think I have authority to ask him to show me the power of attorney. When I met him on the 23rd, the first time, 23rd of June, after I was informed that there's a gentleman who is saying he's an attorney for accused number 2. I don't know how they communicated. I went there, my instruction, and I've said this in evidence in chief, my Lord, that I said they must allow him, despite the COVID regulation, because it was a legal visit. I arrived, he identified himself, gave me a proof from the LPC, which I verified, and later we just get a confirmation from people. Other than that, my Lord, I don't think I could have taken it any further. I don't think I have authority to say, give me the power of attorney. All I wanted to know was to confirm when I arrived, if he was legally, if he was indeed an attorney, that was confirmed. And subsequent to the proceeding that followed, I was convinced he was an attorney, my Lord, because like I said, He appeared numerous times on this matter from the time of its inception and subsequently in Pukeng as well, my lord. And then thirdly, the discussions in terms of Section 105 with the state and with the advocate that he appointed at that time, my lord.
You don't want to disclose the advocate?
I know the surname was Buteleza, my lord. I remember the surname was advocate Buteleza.
Okay.
uthi ke wena ke brigadier ubona ukuthi ummeli lo umjiyakho wayekade enalo ilungelo na lokumela ummangalelo wesibini uthi mina anginalo lelo gunya lokuthi ngimbuza ukuthi unalo ilungelo ngitshelwe ukuthi kuthwa uthi uzomela untanzi ngathi abamvumele ngenxa yokuthi bekunale labhubhane lo COVID-19 ngathi abamvumele nami thema ngifika wanginika ke incwadi ebonisayo ukuthi buya khona kubaphathi bama lawyer waphinda futhi ngambona futhi nasenkantolo kulo leli cala leli futhi nasephukeni ngambona nangokho bekungasuyena yedwa lo munye owesibini angilazi igama lakhe ngazi nje isibongo sakhe kwakade kungowakabuthelezi.
Lastly, my lord, also I've indicated that on the 23rd, as I was approaching when I arrived at the police station, it is accused number 2 who first stood up and said, "This is my attorney," to me. Secondly, on the first appearance, because I was there, it was asked, accused 2 confirmed that he, Mr. Mjiako, is his legal representative. It's on record, it was televised, my lord, it's there.
Futhi ke enye into yesibili esemqoka uthi ithe yena mayifika lapha esiphoyiseni kulayi ukuthi ummangalelo wesibini uyena watshela ubrigadier ukuthi nangu ummeli wami futhi nayiqala uma lingena enkantolo belikade liboniswa nakumabona kude ummangalelo wesibini washo nakhona ukuthi ummeli wakhe uyena umjiyako.
Sir Brigadier, with due respect, if the court were to grant us leave to produce the clip, accused number 2, you were present, and he instructed me that when he was addressing the magistrate to the effect that I don't want this attorney, Mr. Mjiako responded, the presiding officer said, "I can't listen to you if you are represented." Did you observe that, sir?
Not only, but that's not true, my lord. I was there, that's not true. Like I said, Mr. Mcholo was there, the state advocate was there, number of people were there, journalists were there. There is no way where accused 2 said in that the first appearance that he does not want Mr. Mjiako. That's absolutely not true. That's why even the request of where he must be incarcerated came through the attorney, Mr. Mjiako. And accused 2 moved with us for that incarceration during that time. So that is not correct, my lord.
Manje ke uthi ummeli umngomezulu brigadier akusiqiniso lento ewuyishoyo ngoba ngale sasikhathi ummangalelwa evela enkantolo uye waphakamisa isandla wathi yena akafuni umjiyakho kodwa umantshi wathi ngeke ngikulalele wena ntanzi ngoba unommeli nangokho ummangalelwa besisekathe yena akamfuni umjiyakho futhi naye ummeli umjiyakho uyena owaqhubeka efaka nalesi sicelo sokuthi ummangalelwa athathwe ahlaliswe endaweni yakhe eyedwa futhi uthi bebakhona umshushisi wayekhona uyaphinda futhi uthi nommeli umshololo wayekade ekhona neyintatheli zazikhona ngalelo langa ayikho lento yokuthi umantshi wathi ngeke alalele untanzi ngoba enommeli uyakuchitha lokho ubrigadier.
Mr. Ndomezulu, I hear you saying you're thinking while there, no. Maybe it would be necessary for the clip to be played. Did I hear you correctly, sir?
That's correct, my lord.
No, but does the law allow it? Remember, those proceedings were nullified. Now the question is, are you saying the proceedings in the regional court are not part and parcel of the subsequent proceedings which inured before my colleague?
My lord,
just listen to me, because
yes,
You can think it's something simple. So if the proceedings start from the regional court,
Yes.
and then they are postponed in terms of section 72C to the High Court, those are the same proceedings. And when subsequently there's a plea and the proceedings before what's my colleague's name by the way? Right. Sorry, yeah, thanks. Mr. Judge Maumela, they proceed. And subsequently, through an order of this court, before I was appointed to take over the matter, they are nullified. Are you with me?
I'm with you, my lord.
Can you have the right to think loud, like you are thinking, to say that tape of the first appearance in the regional court must be played? I don't think so. Me.
May I
What
be?
do you think?
May I be afforded an opportunity to
To check the law.
check the law, my lord? Then I'll make proper submissions. I'll be guessing.
Yeah, me, I'm certain the proceedings didn't be. That's why, for instance, section 337, you can quote the record of the regional court in the High Court. For instance, the bail application.
Yes.
When you argue bail application in the High Court, in the district court or the regional court, that evidence of the bail application is admissible in the High Court, meaning that, in my view, those are single proceedings which commenced when the accused were indicted and appeared in the regional court. What do you say, Mr. Baloyi? Let me hear your wisdom.
Well, our view is that the proceedings that were set aside are the proceedings that served before Judge Maumela, and the proceedings in the lower court, in the district form, stand separately from those proceedings in the High Court. In fact, the charge sheet was not even handed up at that stage. So it was only the indictment and the evidence that was laid before Judge Maumela that were set aside. The proceedings in the lower court did not form part of the proceedings in the High Court. The charge sheet was not handed up.
Okay, who wants to address this matter? Let's hear Ms. Mshololo. Any view?
My lord, I confirm that the proceedings for the magistrate court did not form part of the proceedings which were before Judge Maumela.
Okay.
Therefore, we can still make references to that record.
Okay, Mr. Khumalo.
Thank you, my lord. You can still make reference to that record.
Mr. Mnisi, you were the big prosecutor in the NPA, formally,
I share the same sentiment.
with them.
Yes. Thank you.
Okay, me, I'm making a ruling that is not so. They're the same proceedings. Go and check your law. The same accused were arraigned before a magistrate. In terms of section 72C, those proceedings before the magistrate under the same docket, under the same indictment which is subsequently drawn by the NPA, the Director of Public Prosecutions. They are superimposed and promoted, and continued before my colleague. That's why, for instance, anything that happened in the regional court, you can refer to it like Mr. Gomezulu wants to say. For instance, if there was a dispute about the bail application, he said this, he didn't say that. The record of the proceedings in the regional court are applicable as evidence also in the High Court. Go and check section 337. Is that not so? Is it 337?
That's correct.
Just quote it.
Yeah, well, as you mentioned, my lord, our view is that the proceedings in the High Court starts with the service of indictment in terms of section 144. So it's a completely new process that starts in the High Court. The Director of Public Prosecutions draws up an indictment as well as a written notice for the accused to appear in court. It's served on the accused in the lower court, and he then appears in the High Court on a new indictment, and the proceedings then commence in the High Court.
Okay, my ruling is that they are not. But if anybody who thinks I'm wrong, you can proceed as if they are part of what you say are the present proceedings. I don't want when it goes to the SCA, where there are several guys I've trained, they'll say, how will the judge do? Okay, so you can decide otherwise, but I'm making a ruling that they are not part and parcel. They are part and parcel of Momela's evidence proceedings, and those were set aside. Set aside. That's why when I came here, if you can recall, I said we are starting de novo, and you've got a right to apply for bail. You remember? I said that.
Yes.
Thank you. Yeah.
Indeed, that.
Okay, no. Let's
yes. Yes, just the final point that I want to make.
Yeah.
Because remember, the accused appears in the lower court, in the district court, before this magistrate, and at that stage, my lord, there were no the magistrate there. There were no problems regarding those proceedings. The only proceedings in respect of which there was a problem, my lord, were the proceedings in the High Court, in respect of which, my lord, in our submission, the proceedings in the lower court did not form part.
Okay, fine. Yes, Mr.
With the guardians of the court, I don't intend to be long, but it is true that the proceedings that were before, I'm sorry, stay here. It's true that the proceedings before the Honorable Judge Maumela were nullified. However, in this very same trial that we're busy with here, we continue to refer to charge sheets that came from the regional court. For instance, I refer the court to Exhibit E.
No, I agree with everything you're saying.
Yes.
Except that in law,
yes,
all those proceedings were nullified. I even tried to say, look at section 337. What? You just read 337.
337, my lord, if I were to help.
Application that evidence in the lower court.
No, 337, my lord, has got to do with the estimation of an age of a person.
No, sorry, you're not 3.
Yes.
What's the 3? Just check that. Bail application, section 60.
It should be around 60s. So.
No, but it's the transposition of proceedings in the regional court, making the bail application proceedings applicable in the High Court. You have it, sir?
Got it. Quick look. Yes, I'm aware of that provision that says
read it.
The bail proceedings form part of the subsequent proceedings.
Yes.
Just looking for the relevant section. That is why the accused must be warned of that fact that the bail proceedings will form part of the subsequent.
Yes, you are right. You see, now you are getting it. That's why, for instance, as you say, the magistrate in the regional court, when an accused brings a bail application, he is obliged to warn that accused to say, be cognizant of the fact that when you're giving evidence regarding a bail application in this court, that evidence can be referred to and it is admissible in the High Court. Now, here comes the JP here, Judge Lidwaba. He sets aside the proceedings to which this statement that the bail application proceedings are admissible in the High Court, but those proceedings are set aside.
I found the relevant section, my lord.
What does it say?
Section 60.
What's the section?
11.
Section?
Section 60, 11B, subsection C.
Right, let's read
says
it.
the record of the bail proceedings excluding the information in paragraph A. Paragraph A refers to the
Yeah.
previous convictions
Yeah,
of
yeah,
the
fine.
accused. Shall form part of the record of the trial of the accused following upon such bail proceedings.
Thank you. Shall.
Yes.
Don't even have a choice. Shall form part of the trial. And which trial are they referring to?
Yes. Well, any subsequent trial.
Yeah, which was, in this case, it was who? Maumela,
Yes.
right? But Maumela's trial has been set aside. And
Yes.
in other words, you can't come and apply for a bail application, you,
Yes, but
Mr. Gomezulu, and then tell me that you addressed the court in the regional court,
yes.
okay?
But the section clearly speaks of the bail proceedings. There was no bail application
That's it.
in the lower court in this matter.
That's it. So what's your problem?
So our submission is that this section refers to the bail. If there was a bail application, those bail proceedings will form part of the proceedings.
Okay, fine. No,
in
fine.
subsequent
That's a good
proceedings.
exercise. And of course, it refers to the very same 5 accused who appeared in the regional court. The same proceedings, which are the same accused. They were arraigned in the regional court. Is that not so? Right. Okay, you have heard me. Let's move, please. Let's move. You say I'm wrong.
Just a quick one.
Yeah.
I think my colleague is now being unfair
Of
when he says the section only refers to bail proceedings because it is
Not
him
fair.
who introduced these exhibits, the
That-
charge sheets,
it doesn't say so.
the charge sheets that are from the regional court. Then he must make an application to withdraw them
you're right.
if they are not applicable in this trial. Yes,
The charge sheet was served in the regional court.
yes.
Now, when I listen to you guys, the charge sheet was served before Maumela. No. They were indicted in the regional court. Is that not
Then the
so?
state must withdraw its charge sheet.
No, it's okay, fine.
Thank you.
Well, just to correct my learned friend,
Okay, let's
section
proceed.
235 was
Let's proceed. You are saying what, and I'm saying the ruling is no. But because I can't stop you talking, you can keep arguing that way.
as a colleague, but we use 235.
Okay, fine, no problem.
le nkulumo ela ivele njengoba umnumzana uMgomezulu bekathi kungahle kudlalwe le ndaba uma uNtanzi ephakamisa isandla ethi akafuni ummeli umjiyapho manje inkantolo ithi umnumzana uMgomezulu ucabanga ukuthi umthetho uyavuma na ukuthi lezi zinto ezisuliwe lezi bekuthi bezikade zixoxwa kuyicala uma inkosi yenkantolo kwakade kujudge Mawume cabanga ukuthi zingahle zisetshenzisiwe na manje njengoba leliyacala liye la suswa kwathiwa kuqalwe kabusha ingakho no judge Mokgahleng mayengena uye wanicebisa enjela ukuthi nani namalungelo wokuthi ningafaka isicelo sokuthi nikhishwe ngebhayili ngoba icala liqala kabusha manje balibele badinga indaba umthetho lana oyikuthi uyakhuluma ngebhayili futhi bakhuluma nangama-charge sheet ebekade ekhishwe laphayana enkantolo engaphansi i-regional court manje ithi inkosi yenkantolo asiqhubeke ngoba ngeke siliqede lolu daba singahle silale la sivuke nakusasa siqhubeke
Hayi mina ngiliqedile usho kanjani? Oh, yini Yeah, okay, it's an interesting thing, you know, because it's a question of interpretation, but it's not even that. Remember, Mr. Gomezulu, I said, we'll now start arguing about which university did you go to.
Yes, ma'am.
Yes.
I remember.
You can't nullify something which started. When was the first appearance?
27.
Of the
27
On the
October.
27 October.
Yes, 2020.
When the DJP, the DOA was nullifying the proceedings before Mawume, he was wiping off the slate from the time these guys appeared in court. That is the nullity. Now, according to you guys, the nullity is just the High Court proceedings. And then The regional proceedings are still current. Oh, my God. Okay, fine.
Just to mention, the proceedings were nullified not before the DJP, but Judge Mo.
Yeah, sorry, yes. Okay, fine. Yes, Mr.
My Lord, I was going to request an adjournment.
What's the time now?
It's 20 past 3, my Lord.
20 past 3.
Yes.
I'll still continue with this witness, Brigadier Sas.
It's only a few things.
So why don't we finish? If it's a few things.
It's an AVL, my Lord, Mchiako. AVL Mchiako.
Yes? Okay, fine. Maybe you'll have to come back tomorrow. I'll tell you why. You were saying the section 105A plea bargaining was completed. You heard yourself.
Yes,
it's an agreement, is that not so?
Correct.
Was it signed by both parties?
Insofar as I know, my Lord, but that was between
Was it signed by both parties? Even if, because of whatever you say, there are threats made to accused number 2,
yes.
but it was signed.
My Lord, it was signed.
It was signed. Okay, that's all I wanted to know.
Yes,
yeah. And I'm sure the copy of that thing is somewhere.
There is a copy, like I said, where I know the proposal of this thing that I'm talking about, and there's a signature.
All right.
So it was a formal engagement.
Okay, fine. Tomorrow then at 10. Thank you. To that effect. Oh, like I said to you, you're just thinking, maybe not.
That's correct, my Lord.
What is correct?
I was intending to bring an application. To bring an application, my Lord.
You intend doing so?
Yes.
Okay, fine. Where are you going to get that clip?
May I be given an opportunity to consult with my colleagues, because it has been discussed. So the source of that document or that tape.
So I must get out again?
No. It's something that you can get during the course.
You discussed it?
Yes.
You are adamant that you want to bring that application?
That's correct.
Okay, fine. I will grant it. I will tell you. You know my views, ne?
Yes.
That those proceedings. I've got an authority here. Maybe you must read it. But it doesn't stop you from bringing the application. Are you with me?
I'm with you, madam.
Because I still have to adjudicate all the submissions you made pertaining to the trial within a trial.
Yes, ma'am.
Now, if you are of the view that that application of the clip and the viewing or the reviewing thereof in an open court will assist your client in the rebuttal of the allegations, not the submission by the state that the confessions were made freely and voluntarily, if it's going to assist you, I must accord you the opportunity to call whatever evidence.
That's correct, madam.
And subsequently, I have to review whatever evidence is before me when I'm coming to decide on that issue, whether the confessions were made freely or voluntarily or not.
The court pleases.
Okay?
That's correct, madam.
And as we all know, a ruling can be... Hello?
Yes.
A ruling can be reversed.
Yes.
When the court hears evidence which is contrary to the ruling being lawful, which the court has made, that court or this court can revoke that ruling so that there is no prejudice. The problem comes when I say you mustn't bring the application. So I mustn't be understood that you mustn't bring. You are entitled to bring it if you want to. And the other fact you must reconcile yourself with are proceedings which are recorded through the devices in court. Are those court records? Is that a court record? Are you with me?
That's correct. I'm with you, madam.
Yeah. It's different when you take a court document, like you were doing with Mr. Ginanda yesterday, and you say page 27, line 7, paragraph what. That is a court record.
That's correct.
whether that screen which records the proceedings can be categorized as forming part of a court record. You must also prepare a submission for me on that. But you can use it. Okay?
Court, please.
Anybody who wants to add anything to what I've said?
No, my lord. No, sir.
Mr. Mnisi?
But none as well, madam.
Yeah, just on record, who is going to stand up for Mr. Khumalo?
My lord, I confirm that Mr. Khumalo requested me to stand in for him.
Yeah, fine, okay.
Thank you.
Yeah, he did approach me in chambers and said today there's a court in Pietermaritzburg. In the High Court, they've issued an order that he should appear there. That's why he won't be present here. But he told me that he has spoken to one of his colleagues to stand in his stead, and on Friday he'll be present. Okay, so you can continue, sir.
Because inkantolo beyibuza ukuthi ummeli wakho Ntanzi ufuna ukufaka lesicelo na sokuthi lo yamfanekiso ubonakaliswe loyana lo bephakamise isandla ukuthi awufuni lo yammeli loyana manje ummeli wakho uthi yebo uzimisela ukuthi angafaka leso sicelo because inkantolo beyilibele imexwayisa futhi imbonisa nezinye izinto zomthetho kodwa ithi akunankinga uma ingabe ummeli wakho efuna ukufaka leso sicelo nangokho lezo zinto lo mfanekiso loyo kuwumfanekiso na oyikuthi ungasetshenziswa la enkantolo njengezinto ezenzakele la enkantolo ngokomthetho ama-records womthetho njengoba kungasi inkantolo ekuthi ikhiphe ukuthi kube namakhemera ukuthi akhona ngenxa yokuthi leli cala kuyicala elisesimeni esifana nalezi manje-ke inkosi yenkantolo beyimbonisa ukuthi okunye izinto ekuthi bekangazigwema kodwa uma engabe angafuna ukuthi afake leso sicelo kulungile angasifaka leso sicelo ayimvimbi inkantolo.
Okay, yes, Mr. Mgomezulu.
Thank you. Mr. Kininga,
You're still under oath, eh? I mean, you know that.
Yes, thank you, my lord.
But the SCA doesn't know that.
I know, my lord.
Okay. Yes, sir.
thank you, my lord. Relating to the AVL system that was presented in court as evidence by Mr. Dupreez, I'm not going to, I'll not go through all the stops or all the places where that vehicle was driven by Sergeant Mkhane, but there are certain spots or places where they are relevant insofar as the version of accused number 2. All right. Firstly, it has been placed on record during cross-examination that on the 18th, a motor vehicle stopped at an engine garage in Albertine. And according to the version of accused number 2, his instruction was that after they went to Carltonville, or to the place where he's working, Mr. Mkhane and Sergeant Mabena were driving a Toyota Fortuner, and he saw a board reflecting Albertine next to that engine garage. That's where they stopped. So I'm putting to you that that version of accused number 2 has been confirmed by the AVL of the 18th. Can you dispute it?
No, I can't dispute it. I can't dispute that, my lord, because I was not there. I was not driving with the accused.
Okay.
Umangalelo wesibini yena uthe ngalesikhathi bekade kushayelwa imoto eya lapha emsebenzini yena ithema kulibele kuhanjwa uye wabona iboard ebhalwe Albertine kula ukuthi imoto iye yamanga khona manje ungakwazi ukuphika lokho na ukuthi cha ngoba bengingekho ngeke ngikwazi ukuphika lokho.
So that's why he alleged that he was assaulted next to that engine garage. And most of the witnesses obviously denied that. And at that garage,
All the witnesses denied that.
all the witnesses,
Because when you say most of, then it means some others didn't deny
all
it.
the witnesses denied that. Thereafter, he he said when they stopped at that garage, they were joined by Jonathan, Khumalo and Buthelezi, where the assault took place. After that, they traveled. On that night, they went to, because he was taken to another motor vehicle that was driven by Jonathan. They went to a place next to or near a dumping area. That's when you feature in, where you arrived with Sergeant Mukhola and another male person who was wearing braces.
Excuse me, my lord, what time was this, if I can just
On the
get clarity?
18th, in the evening of the 18th of April.
No, but that's not true, my lord. As I said, I met the accused in Carltonville, followed the alibi, found to be false. We parted ways. I've never seen him again until I met him on the 19th at Booking Police Station. So I never had any encounter.
Sorry to interject. Mr. Mgomezelu's question relates to the 18th. When
Yes.
first, in other words, if you want to respond,
Yes.
when first did you meet that person? Because it has been proved to you that actually you did meet him on the 18th in the evening. That's the assertion.
Yes, my lord. That's what I'm saying, my lord, that I did meet him on the 18th at Carltonville mine. This is
Okay.
where we're following the alibi that says he was
Okay.
at work and found to be false. Subsequent to that meeting and the admissions or rather utterances that he's willing to make a confessions, I left with Sergeant Mukhola. That is now from Carltonville. I never saw him again. I never traveled together with him and Sergeant Mohane. We went our separate ways. I went to the provincial office, my national office, took my car and went home, and only met him the following day in the evening. This is after his court appearances as Bouquet. So on the 18th, my lord, I only met him in Carltonville to follow up on the first false alibi. Thereafter, we parted ways. I was never in Albertine, my lord, with him.
Ummeli kaMmangalelo wesibini uthi uMmangalelo wesibini uthi yena ithema ngale ngase Albertine eno Sergeant Mukhola yena noMabhena kulayi ukuthi kuye kwafika uJonathan Buthelezi nomunye futhi kulayi ukuthi bona mabafika kuye kwaqhutshekwa ukuthi ashawe wasuswa wafakwa kwenye imoto le ebekade kuhamba abo Jonathan ngayo wayisiwa kwenye indawo ethize nalapho kulayi ukuthi ubrigadier uye wafika ehamba no Sergeant Mukhola. Sergeant ubrigadier uyala uthi cha mina uMmangalelo wesibini ngiqale ukumbona eCarltonville njengoba besiya siyophenya le ndaba yasemsebenzini njengoba bekade bekasemsebenzini. Ukusuka lapho angizange ngimbone ngoba ithema ngisuka eCarltonville ngengaya emsebenzini ngathatha imoto yami ngahamba ngaye ekhaya ngazohlangana naye kusasa uma sisephukeni. Angizange mina ngibe naye uMmangalelwa ebusuku kule ndawo le ayichaza.
Sorry. And furthermore, my lord, that's why I said, and I've testified about this area, that for me, based on the OBs that were collected of his detention on that very same day, my lord, there was no indication that he was assaulted, because I had a privilege of organizing the OBs. Subsequent to the mechanical fault that I was reported by Sergeant Mohane, that was reported to me by Sergeant Mohane, I do know that subsequently was was booked, he was taken through the OB registers in the morning hours of the 19th, booked out for court proceedings on the 19th. Nowhere does it reflect at any stage that he was assaulted when he was there.
Futhi
Okay, yeah.
futhi ke uMmangalelwa mina uma ngibuka konke la kubhalwe khona akukho la ukuthi kuye kwabhalwa ukuthi uMmangalelwa ungene eshayiwe noma ekhishwa eshayiwe estokisini. ngoba uma ngisuka mina uma ngiyobuka nazo lezo incwadi ezibhaliwe azikho la zibonakalisayo ukuthi nangumangalelwa makangena epolice station ethize unezimpawu zokuthi ushayiwe noma uthe ushayiwe akukho la kuchaza khona.
Sorry, Mr. Mgomezelo, for clarity, the court's clarification. You're putting it to Brigadier Gnenda that at the dumping area he was there.
That's correct.
And he came with Mahole,
Yes.
the lady,
Yes.
Sergeant
Mahole.
Sergeant Mahole.
That's correct.
And you say your client was assaulted there.
That's correct.
Now, Mahole too, being a woman, assaulted, because you say he was assaulted there. You didn't differentiate whether Mahole being a woman didn't assault or what. So I take it when you say he was assaulted by all the police there, you include Mahole.
My Lord, on record, I've put that he was assaulted by Jonathan, Mabena, Buteles.
Yes.
And on the arrival of Brigadier Kininda with Sergeant Mohola and the men with the braces.
Yes.
And Sergeant Mohani now was not participating in
Yeah,
the...
Mohani, you say he just looked,
Yes,
but you never dealt with Mahole.
never.
That's what I want to know.
Yes. The only version I got in relation to Mohola assaulting was from accused number 1, that she participated in the assault of accused number 1. That's the instruction I got from accused number 1.
And then the man with braces,
No,
he did nothing.
he did not.
He just played with his braces.
I beg your pardon?
He just played with his braces.
No, I can't say that.
Because you say he was there also.
Maybe he was accompanying
No.
Brigadier Kininda. I don't even know him.
To get your client's version so that
Yes.
I mustn't be confused.
Yes,
Because the police and the SWAT team,
yes,
you are saying they assaulted your client.
that's correct.
Right.
As they were mentioned,
Yes, yes.
Jonathan,
Okay, fine.
Mabena and Butelis.
Okay, fine. Okay,
Yes.
thanks.
Manje mawuthi umangalelwa wesibini ushayiwe kuleya ndawo la kulahlwa khona izibi ubrigadier uma ke fika nalensizwa le enye no Sergeant Mohola nabo bafike bamshaya na no Sergeant Mohola lo wesifazana washaya na umangalelwa wesibini uthi cha ngithe uJonathan uMabhena uMaphumulo yibona ukuthi baye bashaya umangalelwa wesibini eyokushaywa kwakamangal eyokushaya umhula la ashaye umuntu khona kulama kashaya umangalelwa wokuqala akusukuthi ngomangalelwa wesibini uye wamshaya nakho.
Okay.
My Lord, no, I denied it. It's not true. As I said, I was not there. If I was in the vicinity or company of accused number 2, I would have recorded, as I did when we followed the alibi. There's no reason for me not to mention that I'm with him. And secondly, there is no way I would have allowed, as an officer, because then I was a colonel, I was a full colonel, I would have allowed junior members to embark on such atrocious acts. There is no way, there is no purpose, there was no benefit in that. I warned the accused according to his right. He voluntarily and freely told me that he's prepared to make a confession. What would be the purpose of the assault, my Lord? But I wasn't there. The only thing that I was told about was that there was a car, there was a mechanical issues with the vehicle, and subsequently then they made it back to the police station. So I deny that I was there and witnessed any assault.
Manje ke ubrigadier uthi le ndaba yokushawa kukamangalelwa wesibini wayekade engekho futhi njengoba kuthiwa uye wafika kuleyo ndawo umangalelwa elibele eshawa uthi yena bengeke avume ukuthi umsolwa ashawe ngenxa yokuthi ngaleso sikhathi bekuKenneth bekanamandla ukuthi avimbe noma akhuze abantu abashaya umuntu oyikuthi yena ngokwakhe uyasho ukuthi ufuna ukugonyuluka ufuna ukuchaza ukuthi kwenzakele futhi yena njengomphathi wabo bengeke abavumele ukuthi bashaye umangalelwa noma umsolwa yena ekhona bekungena sizathu bekungenanto ebazoyizuza uma beshaya umuntu isikhulukazi yena ngokwakhe uma eyena athi uyafisa ukuthi akhulume axoxe ukuthi kwenzakele.
if we proceed to the following day, the 19th, okay, on that, in the early hours of the 19th, at 2:30, that's when he was booked back at Pretoria North. And few minutes and few hours, he was booked out again. And that's when he was told that he was going to appear in Vosloorus. Suddenly, according to him, he saw himself in Soweto. He's not familiar with Soweto, but what is important about what his version is that he did not sign any document, maybe could be purported to be a confession, in the morning of the 19th of June 2020.
My Lord, what I know, there was an understanding between myself and accused 2 on the 19th that he is freely and voluntarily willing to make a confession to an independent officer. Subsequent to that, arrangements were made for such a confession to be taken, and indeed it was taken. The document I received from Lieutenant Colonel Rappard, I think a day or so or after, in his office in Ennerdale, was signed on the portion where accused 2, or rather a deponent or a suspect is supposed to be signing. It was signed, my Lord. And I didn't get any indication, as I've said, even when I met him later on that day, on the 19th, because the confession was concluded just before midday. When I met him later in Phokeng at the police station, there was no indication, my Lord, that he's got complaints. But subsequent to that, my Lord, even in Phokeng, he was detained there when the ammunition was found, and then booked out again to Primrose police station. Nowhere does it reflect even there, my Lord, that it's at any stage he complained of assault or any assault were detected, my Lord.
Manje ke Ntathabusa imizuzu emashumi amathathu ngemva kwehora lesibini, ummangalelwa wesibini yena uye wathathwa wafakwa estokisini, bamkhipha ngemva kwesikhashanyana amahora ambalwa, yena wazibeka isuka eVosloorus, kodwa ugcine sekazibona eSoweto, le ukuthi akayazi iSoweto ummangalelwa wesibini nge-19 zika June 2020, bese kulayi ukuthi ugcine sekazohlangana noma sekabonana nobrigadier. Uyaphika ubrigadier uthi cha, lokho mina angikwazi, engikwaziyo nje ukuthi ummangalelwa yena ngokwakhe uye wathi uyafisa ukuthi akhulume ukuthi kwenzakeleni, ingakho egcine sekuthi uyisiwa khona eSoweto ukuze ayokhuluma khona lapho. Mina ke ngubrigadier ngathola lawo maphepha abekade ummangalelwa asayinile kuwo, la kusayina khona umuntu uma eqeda ukukhuluma isitatimende esifana naleso. Bese ke mina ngiye ngahlangana naye, sengihlangana naye futhi ePhokeng, wagcinwa khona lapho estokisini ePhokeng, wasuswa ePhokeng wayisiwa ePrimrose, kulayi ukuthi mina nommangalelwa besilibele sihlangana khona. Nala sihlangene khona ePhokeng, akazange ummangalelwa angitshele noma angazise ukuthi unesikhalazo esithize ngento eyenzakele kuye, yena ummangalelwa zange angitshele lokho.
Brigadier, I appreciate the fact that there's so much that you want to explain, but I'll ask you to at least give me an answer according to the question that I'm asking, and because the reason is because I'm following the instruction as it is, because I'm not in Phokeng as yet. I'm still at Moroka police station. Then my instruction and the questions that I need to put across to you, they must make such a relevant sequence. Because what I want to, when I'm asking you, the version that I'm putting across to you, it must be confirmed by the AVL system. That's why I'm taking two things in one time, so that we can have a smooth.
My Lord, I understand it, but my explanation, in other words, I do give an answer, and then I give an explanation in relation to the specific day council is referring to. So it's not that I'm giving answers that are haphazard. So I will say, for example, on the 18th, this is not correct. When I refer to the OBs, I'm referring to the OBs of the 18th. Now on the 19th, I've referred to the 19th, and I've referred to the occurrence book of the 19th in Phokeng, and subsequently when he was moved to Primrose? Because it's relevant to the question that I'm being asked, my lord.
uthi ummeli ucela ukuthi ubrigadier aphendule lokho ambuza kona uyazwisisa futhi uyajabula nokuthi kunezinye azigcwaliselayo kodwa ucela ukuthi aphendule lokho ambuza kona ngenxa yokuthi usahamba ngendlela ethize ukuthi ucebiswe ummangalelo ukuthi abuze kanjena nakanjena azilandelelane manje ubrigadier uthi uma ngiphendula bese ngiyagcwalisela kuzo lezo zinto zangalo lolanga ongibuza ngalo akusukuthi ngikhuluma ngezinto zelanga elithize ngombuzo othize ngiphendula ngigcwalise kulezi zinto ukuthi usakhuluma ngazo ezihambelanayo nawo lo mbuzo owubuza.
For instance, accused number 2 confirmed that he was transported from Pretoria to Morocco, although he didn't know that he was at Morocco, and that was also confirmed by the AVL. After Morocco, he was transported to Foslora's court, and that is also confirmed by the AVL. This is what I'm putting across to you so that we flow with the...
No, I agree, my lord. And the AVL records, I seem to recall that they reflect such, that he went to Morocco and went to, subsequent to that, then he went to Foslora's magistrate court, my lord. We agree.
Magalelo wesibini yena uthe ususwe esiphoyiseni sase Pretoria wayisiwa eMorocco nangokho wayekade engazi ukuthi kusesowethu kuseMorocco kodwa uyisiwe khona kusuka lapho wayisiwa eFosloras enkantolo uthi yebo ubrigadier uyavuma njengoba neAVL ichaza isho kanjalo.
And it is further my instruction that at Fosloras he did not confirm, he did not appear in court. That has been confirmed by Sergeant Khumalo to say he did not appear in court, but because the matter was not placed on the roll. Soon thereafter, they traveled. When they traveled, he saw a boat bearing Albertine. This is the second time he saw the boat reflecting the name Albertine. That is also confirmed in terms of what he explained by the AVL. Because according to the AVL, they drove from Foslora's court, joined N3 and off-ramp at Heidelberg Road. They joined Heidelberg Road.
My lord, as I said, I was not there. I was not traveling with him, so I'm not sure how can I assist counsel on that.
Manje ke ithema kusukwa ke enkantolo yase Fosloras kulayi ukuthi uthi umangalelwa uye manje sekuyihlandla lesibini ebona ibhodi ebekade ibhalwe Albertine naye ukuthi iyavune AVL nayo ivumelana nayo uthi ubrigadier bengingekho ngeke ngikwazi ukuvuma noma ukuphika lokho.
So when they joined Heidelberg Road, there were stops at that road. There was a stop at Heidelberg Road. And they were driving towards, after that stop, they were driving towards New Market in Albertine. And that has been confirmed by the AVL. And where they stopped, he said it was near a dumping area where he was assaulted.